So overpowered his voice, so I was shocked. Who is this?
My apologies, my lords.
As always, yes, no problem. Yes.
This suit has been, it has been
Is she
judgmented
not
on.
telling? Why do you want to intrude? You can come there, I'll come there. Yes.
The judgment has been done in 1992, my lords. And
ಈಗ
it is,
ಏನ್ 2:30 ಬೇಕಾ?
ಇಲ್ಲ my lords, Monday ಬೇಕು my lords. Urgency ಇದೆ. ಯಾಕೆಂದ್ರೆ petitioners ಎಲ್ಲ 70 years and above ಇದೆ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
We have only asked for direction, my lords.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅದು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಷ್ಟೇನಾ?
Yes, my lords.
give it.
Much obliged, my lords.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
It's on Monday.
Fresh tax, whatever it, any subject, fresh matter, please give.
Request a date for tomorrow, my lords.
Tomorrow. Monday ಆಗ್ಬೋದಲ್ಲ?
There's urgency that respondent might pass orders without jurisdiction, my lords.
I no problem. You think this court is powerless not to annul it? Yes, give it.
My lords, please.
ಒಂದ್ ನಿಮಿಷ, ಬೇರೆ ಎಲ್ಲ ಫ್ರೆಶ್ ಕೊಟ್ಬಿಡಿ. 2:30 ಮಾತ್ರ wait.
Humble submission for Monday, my lords.
Monday ಬರುತ್ತೆ ಸರ್.
It's not, my lords. Last Monday also same thing happened, but please.
Beyond
Humble request. my
ಅಲ್ಲ
lords.
400, 500 can I take? What is this? Every
It's
day?
already covered by judgment, my lords. It was
Whatever it is,
notification through
it
email,
will
my
come,
lords,
don't
please.
worry. Monday ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ Monday 2:30 ಮೂವ್ ಮಾಡಿ.
My lords, tax matter, fresh matter.
Office objections comply ಮಾಡಿ first, ಆಮೇಲೆ
ಎಲ್ಲ
ಬರುತ್ತೆ.
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ. It's all done
See,
now.
comply ಆಗಿರೋದು ಒಂದು ಫೈಲ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. If you comply, it will come.
My lords, it's been completed on 12/8 itself. my
Then
lords.
it
There have
will, it
been.
will definitely come, don't worry.
Last time 28 ಗೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು, ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಈಗ ಆಗುತ್ತೆ ಬಿಡಿ.
My lords, tax
Lord,
matter.
Thanks, my lords.
2:30 ಗ
My lords,
My
tax
lord,
matter, fresh matter, my
Tomorrow,
lords,
my lord.
covered by 151A.
give
Can
it.
it be
one
taken up
matter.
tomorrow?
Matters, give it.
My lords,
ನಾಳೆ
ಎಲ್ಲ ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. 2:30 ಗಾದ್ರೆ wait.
Civil
One
division.
my lords, fresh matter it was filed on March, my lords. I moved.
Last year is it?
No, my lords, this year March.
Last year ದೇ ಬಂದಿಲ್ಲ ಇನ್ನು, ಕೊಡಿ.
My lords, urgency is
Give it,
impeding
sir.
application came to be.
Give it, give it. Yes.
My lord, two matters for a civil revision petitions, my lord.
ಕೊಡಿ ಮೇಡಮ್, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
No, my lord.
ಪೆಂಡಿಂಗ್ ಆದ್ರೆ on next Friday.
I'm on
Please,
behalf
my
of the
lord.
respondent.
Because she is
lordship.
a retired school teacher.
Pending
my
matters
lord.
you give, they will be listed on the designated days according to seniority.
My lord, I
I'm the
moved that.
respondent.
My lord,
Parallel,
I moved that matter twice, my lord. It
It come,
didn't came, my lord. She
I'm
is a
pending
retired
CPC
school
matter.
teacher, my lord, for that.
It will come, madam. Yes. Oh, ಕೊಡಿ. ಅದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಂಡೇ ಹಾಕೋಣ, ಕೊಡಿ. ಅದು 8th ಹಾಕಿ.
I'm,
ನಿಮ್ಗೂ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಲೋ ಮಾಡಕ್ಕೆ?
My lord,
ನೀವೇ ಪಿಟಿಷನರ್ ಅದು.
pending CPC matter, my lord.
ಎಸ್ ಕರೆಕ್ಟ್, ಹೌದು. ಏನಾಯ್ತದು? 12th ಹಾಕೋಣ, ಕೊಡಿ. ಎಸ್. Objector application dismissed, file an appeal. I will not entertain, sir. Confirm ಆಗೋಯ್ತಾ? ಅದು ಅಪೀಲ್ ಅಲ್ಲ, ಕೇಳಿ.
in this case, lordship,
At 2:30 ತಗೊಳ್ಳಿ. Rejected, appeal.
in this case, lordship,
Appeal also rejected. Concurrent finding, Monday ಅಥವಾ
this
ಬರುತ್ತೆ?
case, lordship,
No problem, ಬರುತ್ತೆ.
I am the respondent, your
ಹೇಳ್ತಾ
honor.
ಇರಿ, ಒಂದ್ ನಿಮಿಷ.
Sorry.
For 2:30.
My suit for injunction, my lords, I have filed an application for ex parte.
Not granted.
He has spotted on the orders for us and then he has posted it for emergent notice.
Anyway, give it, yes. No, 2:30.
Execution court has issued for attachment.
2:30. Tomorrow. Monday. Which subject? It will come. Monday or Tuesday? It will come.
It is in a,
ಒಂದ್ ನಿಮಿಷ.
The lordship had directed the ADL to conduct survey, my lord. HGP has placed on record the survey report, my lord. The date may be fixed in the next week, my lord.
Eh?
It is a pending matter, my lord.
ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir.
ಕೊಡಿ.
in this case, I am the respondent, your honor. Petitioner has taken the status quo order from this court.
Vacating
your
stay ಹಾಕಿದ್ದೀರಾ?
honor. Vacating, no, still they have not, office objection was complied. Notice is not taken the process. RACI is also pending.
ಆಯ್ತು, ಕೊಡಿ. Give it.
Tomorrow.
Not
Tomorrow.
Tomorrow already fixed 150 ಇದೆ, ಆಗಲ್ಲ.
Monday, your honor, Monday.
Next Wednesday. Yes.
ಅಲ್ಲ, because
ಅಯ್ಯಲ್ಲೇನಿಲ್ಲ, ಏನ್ Yes, good.
Execution suit is pending before the trial court, my lord. Since 4 years, they're not paying the rent.
I am the respondent to.
Monday. ಅದ್ ಕೊಡಿ, ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ.
Hearing my lord, BDA ಅವರು 30 ಗುಂಟ land ಗೆ
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಮಂಗಳವಾರ ಬರುತ್ತೆ.
Execution court has ordered delivery warrant, your lordship, for tomorrow, 2:30, your lordship.
2:30.
My lord, CRP pending matter, my lord. I have filed the 5 memos, my lord. We have dead
ಇದು
early hearing application also filed.
ಇದು 6th,
6th, my lord.
ಇನ್ನೊಂದೆರಡು ಹಾಕ್ಬಿಡಿ ಆಮೇಲೆ ನೋಡಿ.
But CRP pending.
ಕೊಡಿ
my lord.
ಸರ್.
Date may be-
ಯಾವ
early
ವರ್ಷದ್ದು?
hearing
ಡೇಟ್
application
ಫಿಕ್ಸ್
also
ಮಾಡಲ್ಲ.
filed, my lord. My lord,
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಲ್ಲ, ಕೊಡಿ.
since 2 months in the matter, earlier.
ಏನ್
bench also,
ಪರವಾಗಿಲ್ಲ
my
ಸರ್,
lord.
ಕೊಡಿ. ನೀವು ಪೆಟಿಷನರ್ ಈಗ
Petitioner.
ಏನ್ ಪ್ಲೇಂಟ್ ರಿಜೆಕ್ಟ್ ಆಗ್ಬೇಕಾ?
Hello?
ಪ್ಲೇಂಟ್ ರಿಜೆಕ್ಟ್ ಆಗ್ಬೇಕಾ?
Client reject, yes, my lord. That's early.
My lord, disposed.
ಏನ್
Early hearing
suit
application
for
also
what,
filed.
sir?
Suit for partition, my lord.
I will never entertain suit for partition 711 applications. ಕೊಡಿ, ಬೇಕಾದ್ರೆ ಕೊಡಿ, ತೊಂದ್ರೆ. You got the order already. Yes, give it.
Disposed matter.
ಈಗ ಮೆಮೊ ಬೇಕಾ ಬೇಡವಾ?
Yes, my lord.
ಬೇಕಾ? ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
My lord,
Executive court puts the property for sale on 6th, my lord. 2:30.
2:30.
My lord, disposed matter, my lord. My lord, disposed matter, my lord. It's disposed day before yesterday. I have filed an application for continuation of interim order, my lord.
ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದ ಯಾವುದು?
ಮೊನ್ನೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಆ?
ಮೊನ್ನೆ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್, my lord.
Interim order ಇತ್ತಾ?
Interim order ಇದೆ.
ನೋಡೋಣ ಕೊಡಿ ಅದು. ನೋಡಿ ಮೇಡಮ್.
Petition is squarely covered with apex court judgment, my lord. Then ಮಧ್ಯಾಹ್ನ ಒಂದು
ಸಾರಿ?
apex court judgment ಕವರ್ ಆಗಿದೆ petition.
ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಕವರ್ ಆಗಿರುತ್ತೆ.
Yesterday also my lordship had posted on 9th one similar matter, not this can also.
ಏನ್ ಎಲ್ಲೇ ಬಿಡಿ ಅನ್ನ
KDP matter.
ಎಲ್ಲ ಕೊಡಿ.
Fresh matter. That's fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
This
ಗಿವ್ ಇಟ್ ಸರ್.
There is an urgency.
ವಾಟ್ ಆರ್ ದಿಸ್?
Road dispute since from 45 years. No, all of sudden, original shoot ಅಲ್ಲಿ IA number 1 reject ಆಯ್ತು. MN divorce order ಆಗಿದೆ. Since 2024 matter is not posted before court.
ಅದು ತುಂಬಾ ಅರ್ಜೆನ್ಸಿನಾ?
Yes.
ಕೊಡಿ.
My lord,
ನೋ
My lord, there is no road.
ಇಟ್ ವಿಲ್ ಕಮ್ ಸರ್. 45 years ಇಂದ ತೊಂದರೆ ಇರಲಿಲ್ಲ, ಈಗ ತೊಂದರೆ.
ಇವಾಗ road ಅಲ್ಲ.
1 ವರ್ಷದಿಂದ ಕ್ಲೋಸ್ ಆಗಿದೆ, ಇನ್ನು ತೊಂದರೆ ಇಲ್ಲ.
MN divorce order ಆಗಿದೆ.
ಯಾವಾಗ ರಿವರ್ಸ್ ಆಯ್ತು?
ಮೊನ್ನೆ 6 months back ಇವಾಗ
ಮೊನ್ನೆ 6 months back. ಪರವಾಗಿಲ್ಲ.
We have filed a suit for money recovery. Maintainability ಮೇಲೆ ಲಿಸ್ಟೇ ಆಗ್ತಿಲ್ಲ ಮ್ಯಾಟರ್.
ಎಲ್ಲಿ?
ಇಲ್ಲ ಕೋರ್ಟ್ ಆನ್. The reason behind this is a suit for money recovery. The sum is 15 crore 17.
ಫ್ರೆಶ್ ಮ್ಯಾಟರಾ?
Fresh matter, my lord. ಇಲ್ಲ maintainability ಲಿಸ್ಟೇ ಮಾಡ್ತಿಲ್ಲ ಅವರು.
ಅದು ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡುತ್ತೆ ಮಂಡೆ.
Date ಮೇಲೆ
There are 100 maintainability petitions which will all come on Monday. Give it. We'll following some method. Don't mix up things. ಕೊಡಿ.
ಇಲ್ಲ my lord, the thing is
ಬರುತ್ತೆ ಅಂತ ಹೇಳದ್ನಲ್ಲ, ಕೊಡಿ.
One fresh matter, so wherein the injunction suit, so the all our cousins, the partition suit, the boundaries are fixed.
ಈ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಹೇಳಿ ಸರ್ ನೀವು? ಯಾರಾದ್ರೆ
So, ಇದು ಎಕ್ಸ್ಟೆಂಟ್ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಒಂದು ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ಬೌಂಡ್ರೀಸ್ ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ?
ಸೊ ಅದಕ್ಕೆ ಅದು ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಅಪೀಲ್ ಅವ್ರ ಕಡೆನೆ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಓಯ್ಯೋ, ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. ಏನಾಗುತ್ತೆ?
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ
2 ವರ್ಷದಿಂದ ಏನು ಇಲ್ದೇ ಇರೋದು ಇವಾಗ ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ, ಈಗ ಅದು ನಮ್ದು ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಎಕ್ಸ್ಟೆಂಟ್ ಏನ್ ತೊಂದರೆ ಆಗಿಲ್ಲ,
ತೊಂದರೆ ಇಲ್ಲ.
ಬಟ್ ಬೌಂಡ್ರೀಸ್ ಮಾಡ್ಕೊಂಡು ಅವರು ಎನಿ ಡೇಟ್ ಮೇ ಬಿ ಕೈಂಡ್.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
One GMCPC matter, my lord, injunction was granted by the trial court, refused by the appellate court. There's immediate threat of disposition, my lord. Tenant.
No sir. Yes. ಕೊಡಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಮೇಲೆ ಅವೆಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ, ಕೊಡಿ.
Then execution petition tomorrow, the sale 2:30.
My lord, order of the trial court is now restraining me from selling beer. Agreement says only craft beer.
What?
Beer. My lords, I've been selling beer for suddenly now, my lords, my business is stopped. Business is stopped, my lords. Ex parte interim order was passed. I move IA for clarification. Agreement was only for not selling craft beer. I am telling craft beer is different from normal beer. But the agreement now says all kinds.
How do you know?
My lords, I know, my lord.
All right. ಈಗೇನು beer urgency ಇದೆಯಾ?
My lords, from last 4 days I'm not able to.
Not able to sell beer.
My lords, it's a pub, my lords. I have an excise license, everything I have, my lords, I'm restrained. That's the problem. 2:30, my lord.
beer ಅಲ್ವಾ? 2:30 ಗೆ ಕೊಡಿ.
Your lordships.
Strength of the impugned order, the respondents have entered the property. They have brought on construction materials such as JCB. They are doing bore welling.
Construction material JCB ಅಲ್ಲ, destruction material.
My lord, I mean that equipment to carry out construction. They have broken down my compound wall on the strength of the impugned order, my lord.
Which is the impugned order?
My lord, there's an ex parte injunction that has been passed. 39.
File an appeal.
My lords, 39(3)(a) has not been complied with, plus. My lords, may I please have a 230, my lords?
230.
Please, my lords.
1817. Order 18 rule 17 ನ ಯಾವಾಗ ಎವಿಡೆನ್ಸ್ ನಡಿ ಜಡ್ಮೆಂಟ್ ರಿಸರ್ವ್ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರ ಮತ್ತೆ ಇಲ್ಲ ಅದೇನ್ ಹೆವೆನ್ಸ್ ವೋಂಟ್ ಫಾಲ್. ಎಸ್
It's a fresh matter, my lords. The executing court has passed an order against the terms of settlement that have been agreed upon, my lords. I've deposited a sum before the executing court and they've released that sum without the JDA complying with the terms of the settlement terms. May the matter kindly be taken up by 230, my lord. It was already passed at 20.
Not at all.
On 20.
Mondays.
Please, my lord. Date may kindly be fixed, my lord.
Mondays.
Much obliged.
ಮೆಮೊ ಕೊಡಲ್ವಾ? ಹೇಳಿ.
ಪೆಂಡಿಂಗ್ ಮಾರ್ಕೆಟ್.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಟ್ಬಿಡಿ. ಯಾವ ಸಬ್ಜೆಕ್ಟ್? ಸ್ಪೀಡಿ. ಆಯ್ತು ಕೊಡಿ ಮೇಡಮ್. ಅದು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಹಾಕ್ಬಿಡಿ. ಯಾವ?
Suit for injunction. Suit for injunction. Lordships are directed to the registry to list this matter today. Urgency is, my lord. My sale date is due on 1998.
ಆಯ್ತು, ಈಗ ಏನ್ ಇನ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಏನಾಗಿದೆ?
Very notice for that. I sought for, my lords, an ex parte order. My construction is stalled. I'm servicing the loan, the huge loan. And, my lords, the fake business card saying that Ministry of Defense and the create ಮಾಡಿದೆ. And on that score, he's saying that I am the social protector. These are all agricultural lands. The layouts have been found, my lords, in 1995. 230.
230.
So let's sorry.
ನಿಮ್ದು ಪರ್ಸನಲ್ ಮ್ಯಾಟ್ರಾ? ಸ್ಟೇ ಇದೆಯಾ? ಯಾರಿಗೆ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಬೇಕು? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಎಲ್ಲೇ ಟ್ಯೂಸ್ಡೇ. ಎಸ್ ಮೇಡಮ್, ಈಗ ಹೇಳಿ. ಓಹ್, ಆ ಥರ ವೀಕ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಬರುತ್ತೆ ಕೊಡಿ. ಏನ್ 230ಗೆ ಯಾಕೆ? ಅರೆ ಆ ರೀಸನ್ 230ಗೆ ಅಲ್ವೇ ಅಲ್ಲ. When was the compromise entered into? 230.
Order 7.
ಪೆಂಡಿಂಗ್ ಅಲ್ಲ ತಾನೆ ಕಿಶನ್? ಫ್ರೆಶ್.
Pending matter, my lord, where we have not obtained the.
ಕೊಡಿ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
End of list one matter.
Give it, sir. If I permit 12 o'clock ವರೆಗೂ ಬರೀ ಮೆಮೋಸ್ ಕೊಡ್ತಾ ಇರ್ತೀರಾ, ಕೊಡಿ. Give it. You can't finish every court and come to this court and keep moving. Come. Give it. End of the list ಇಲ್ಲ ಕೊಡಿ. You want to give the memo? Give.
Commissioner's warrant is issued, my lord.
ಓ, ಏನಾಗಲ್ಲ ಕೊಡಿ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ there is one interim order in my favor, not directing defendants not to execute.
Yes, call the cases.
If my last may permit me 1 minute, my lord.
Yes.
Impleading application has been filed.
6th matter ಇದೆ.
ಪರವಾಗಿಲ್ಲ.
Impleading application
maybe had tomorrow, my lord.
No, sir. Give it.
Because I haven't, there is.
ಬಂದ್ರೆ ಮಂಡೆ ಬರುತ್ತೆ ಕೊಡಿ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ 6th ಗೆ commissioner's warrant is issued, my lord.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಸರ್ ಅಲ್ಲಿ.
ಅಲ್ಲ, execution ಅಲ್ಲಿ my objector application is rejected.
No, sir.
Let's.
Period. No, Monday.
Tomorrow, my lord.
Commissioner report ಗೆಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ.
ಅಲ್ಲ, commissioner's warrant report ಅಲ್ಲ, sale date.
Warrant.
End of list, my lords.
Tomorrow.
My lords, impleading application have been filed, my lords. They have taken the interim order, my lords, that stating that there is no person taken by the KDB, but KDB has allotted the site for me, my lords. I am the beneficiary, my lords.
Give it. Vacating stay ಹಾಕಿದ್ದೀರಾ?
My lords, I am impleading applications, my lord. I filed impleading application.
ಅದ್ರ ಜೊತೆ vacating stay ಹಾಕ್ಬಿಡಿ.
Please, my lords, I'll file.
ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ.
Please, my lords.
ಕೊಡಿ. Yes, call the cases.
Being spoken to still number 1. My lords adjourn. Serial number 14. It's a
No adjournment in the morning. Mention when it is called.
I appeal for the.
Some typographical errors. I've moved it.
It has been served just now.
I'm just clarifying it.
I'm sorry, but this is the type of practice being done. Should I not be given it well in advance?
Absolutely, sir. Don't worry. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ನಿಮಗೆ.
I'm not saying anything,
that
sir.
You should senior ಗೆ ಮುಂಚೆನೆ ಕೊಡಬೇಕು.
I was under the impression.
What is all this?
I was under the impression.
No. When you have moved the matter.
I was under the impression.
What impression?
I was in the impression that my office has done it. I apologize if it's not done. ನನಗೆ.
These are all big lawyers, of course. They're too busy. He thought that his office has done it.
Sir, anyway.
Not fair.
ಅದೇ ನೀವೇನು ಹೇಳಿ. Bigger than you, who is there? Yes. ಯಾವತ್ತು ಬೇಕು ಸರ್?
My lord, your lordship may have it next week.
ಆಯ್ತು. 12th ಹಾಕ್ಲಾ?
Very well.
12th, same
Not a
stage.
little earlier, because the only thing is that I need to
12th,
clarify.
same stage.
Like
If only you had given it served in advance,
Please.
we would have definitely.
Because that one
Because you have
person
not done that,
on
12th. ಯಾಕೆ? 11th or 12th ಯಾವತ್ತು ಬೇಕು ಸರ್?
Very well.
11th early,
ಆಯ್ತು,
because if
11th.
I'm getting a day in advance, please.
ಈ ಕಾಪಿ ಕೊಟ್ಬಿಟ್ಟು you can't. This is
I'm not-
very,
I was
very
under the impression it was done, Manoj. I
Not
apologize.
correct.
If that's the case, I
Why you
apologize.
did not give, is it?
If that is the case, I apologize.
Yes.
Bill number 2.
My lord, I appear for the respondent number 2
Madam,
applicant.
ಯಾವ್ದಿದು? Cell number 2?
Being spoken to.
Nisha Tiwari, madam. She's not there?
My lord,
Madam, there are four applications on that day.
yes, my lord.
Where are you, madam? You are there?
Am I not visible to the court, my lord? My view
Visible.
is on. Yes.
Yes. There are four applications on that day. The other two applications were also decided?
My lord, one had become infructuous, which sought listing of the matter. So when the matter got
That
listed,
is, one was infructuous,
please, my lord.
IA 1. The other one was for change of name.
Change of name.
Change of your name in the sense,
My lord, that was not an application, it was an oral request, my lord.
oral, then which are the four applications were pending?
My lord, on that day, there were
Ah.
3 applications. One was for clarification, my lord. There-
Madam.
That was decided on that day. One was for direction in the matters of
Yes.
listing, my lord. The third
Yes.
one was seeking listing, which was filed prior to the IA for directions. So that
Oh, that
became,
had become infructuous.
infectious on the
Oh,
very day.
because no order was passed on those that day, the office says that the other applications are still pending. That's the reason it was, in the afternoon, it will be uploaded, madam.
Great.
Yes,
Okay.
Adba, make note of that. The subject, the applications were listed on 30/6/2025, which were 3 in number. Owing to certain obfuscation with regard to the disposal of the application, of all the applications, the order was not released. In that light, the matter is posted today for being spoken to, and clarification is now sought. In that light, the application number 3, IA number 3, which was for the purpose of listing of the matter, since the matter was not getting listed, and that the matter was listed on the said day, the said application is rendered infructuous and is disposed as having become infructuous. In the other two already, yes.
Great.
Yes,
Great.
madam.
For the petitioner in this case, my lordship.
Idian, Praveen.
Being spoken to.
My lordship, there is one sentence where we had sought one part of the prayer to consider the representation made to respondent number 2, my lordship. That is not forthcoming in the order, my lordship.
Respondent number 2 ka.
How this one?
Petition's position structure shall not be.
That is right, my lordship. To BDA, my lordship. Respondent number 2 is the BDA, my lordship.
ಆಯ್ತು, ಇನ್ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ 38 ಡೀಲ್ ಅವರೇ ಮಾಡೋದು.
It may be mentioned this
subject.
Page number 5, last paragraph ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
The subject petition was disposed by an order dated 16th July 2025 following the judgment of the coordinate bench. The learned counsel for the petitioner submits that a direction to the second respondent BDA to consider the representation is inadvertently omitted in the order. In that light, the BDA, second respondent, shall consider the same in accordance with law and consider the same in accordance with law and communicate the order so made on such consideration to the petitioner. This order shall be treated as part and parcel of the main order. Yes, next.
Oblige, my lordship.
Orders.
Withdrawal in terms of
5.
unserved return postal shara unclaimed.
But third respondent, lordship can say that the service is held sufficient because he is the person who has created the gift deed and subsequently has taken the revenue entries in his name.
Sufficient ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಕ್ಕೆ ಕಾನೂನು ಪ್ರಕಾರ ಏನ್ ಮಾಡ್ಬೇಕು ಸರ್?
But he is unclaimed as per the shara.
Once unclaimed ಆಗಿದೆಯಾ?
Unclaimed.
The postal shara indicates that the respondent, which respondent?
Third respondent.
The third respondent.
He is the main, my lord, there.
ಏನ್ ಮಾಡೋದು ಕ್ಲೈಮ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಾಯ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳೋಕ್ಕಾಗತ್ತೆ. The postal shara indicates that the respondent has not claimed the notice that was sought to be served upon him through the court. In that light, registry is directed to print the name of the respondent, third respondent, and show him as served.
Next week.
Place the matter on 16th.
Please.
Yes.
Bill number 6.
Only for the respond, I have filed this memo for dismissal of the writ petition.
Dismissing.
Please, because the relief prayed therein has already been granted by an order of this honorable court on 24/9/24.
Kodi sir. RFA.
There was a decree in my favor, injunction.
Who is the plaintiff?
I was the plaintiff in suit, original suit. And they challenged the decree.
1 minute. Who is that counsel appearing from the car? Yes.
There is a decree in my favor, my lord. Injunction was granted in my favor. That came to be challenged in the RFA. During the in the RFA, they took up a plea saying that they are in possession. During the pendency of the RFA, they filed a suit for declaration stating that the decree is a fraudulent decree and it's not binding on them, and etc. etc. When the RFA came to be taken up for hearing, a submission was made by us saying that the relief claimed there in the appeal are one and the same. Then they made a submission saying that which has been recorded also, that we are going to withdraw the suit. Accordingly, they withdrew the suit. Thereafter, they filed this petition, writ petition, seeking restoration of that suit. And the office.
Withdraw madadme.
How? And the office raised the objection how the writ is maintainable. And later, this honorable court granted leave to withdraw the file necessary application before the trial court in the suit. Accordingly, now they have filed the application. Therefore, nothing survives in this.
ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
Lords, for a reason, Lords.
ಯಾವ reason?
Alla.
Well, where is the order of withdrawal?
My lords, the order of withdrawal is at page 112, my lords.
112.
Yes, my lord.
All right. 1 minute.
Before that, my lords, kindly refer to.
1 minute, sir.
Yes, ma'am.
Counts for the plaintiff, whereas allowed plaintiff is permitted to withdraw the above suit as per the undertaking given by the plaintiff in RFA. Where is that undertaking? Undertaking ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
98, my lord.
ಯಾವ page ಅಲ್ಲಿ?
Page number 98.
ಇದೇ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲ?
ಹೌದು, same. 1822.
Since the dispute involved present so and so.
Alla, 98.
Appellant wants to withdraw the suit in the trial court.
Please.
My lords, for that, my lords, I have filed an application under, my lords, page 99. Because, my lord, rights of the parties cannot be, my lords, in respect of immovable property.
Sir, withdrawal application ಹಾಕಿರೋದು ನೀವೇ ತಾನೆ?
My lords, my lords, my other counsel has filed this.
Counsel ಬಿಟ್ಬಿಡಿ.
Yes, my lords, kindly refer to that application, my lords, for this moment. My lords, withdraw the above suit with the liberty to approach this honorable court on the same cause of action if need arises. Lord,
ಮೆಮೊ ಹಾಕಿರೋದಾ ಇದು?
my lords, this is an application.
Early, before the trial court.
Before the trial court in the said suit. My lords, on that day, my lords, since I sought for liberty to file a fresh suit on the same cause of action, because that is a suit for declaration, possession and other mandatory injunction, my lord. A comprehensive suit was filed. My lords, this liberty, my lords, on that day, my lords, a junior counsel was appearing before the learned trial judge, where, my lords, my learned friend has opposed the said application to remove the liberty, word liberty.
ಆಮೇಲೆ ಏನಾಯ್ತು?
On that day, my lords, it was forced, my lords, by the learned counsel to remove that, my lords, scratch of that.
Where is the order?
My lords, my lords, order is at page 112, my lords.
Same
Its
order.
application is not
Same
considered.
order.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ವಾ?
My lords, that application, my lords, adanna, my lords, there is no express. My lords, kindly refer to the counsel for the plaintiff filed an application order 23 rule 1 CPC, peruse allowed. That is the only order.
ಎಲ್ಲಿದೆ ಅದು?
ಅದೇ 112 ಅಲ್ಲಿ, my lords, that is on 18/8/2022.
Same order he is referring. Very same order. 112.
Where do I get that?
My lords, order page 112, my lords.
112 along with power counsel so and so.
Yes, my lords.
As per undertaking, accordingly suit is closed as withdrawn.
Counsel for the plaintiff filed application order 22 allowed. My lords, where I have specifically stated in my application and alleged with the affidavit, where I sought for a liberty to file a fresh suit on the same cause of action for possession and declaration. I have not sought for any, my lord, that liberty
ಈಗ
was not.
when you sought liberty to withdraw the suit here,
Yes, my lord.
on what basis?
My lord, on the
Memo
basis,
ಹಾಕಿದ್ರಾ ಇಲ್ಲಿ?
ಇಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ.
RFL ಮೆಮೋ
ಇಲ್ಲ
ಹಾಕಿದ್ರ?
ಹಾಕ್ಲಿಲ್ಲ.
ಇಲ್ಲಿ ಲಿಬರ್ಟಿ ಕೇಳ್ದೇ ಇರೋದು ಅಲ್ಲೆಂಗ್ ಕೇಳಿದ್ರಿ?
ಯಾವ್ದು?
ಅಲ್ಲಿ.
My lords, ಅಲ್ಲಿ, my lords, while arguing the matter, my lords, my learned friend
Whatever it is, before which court permitted you to withdraw? You file an application before the same court and seek clarification with regard to withdrawal with liberty. Otherwise, that order would stare at us.
May I make one submission? The very same argument was canvassed, and thereafter 24/9 order came to be passed.
Before this
court
my
was
lord,
in the
in
present
the same
petition.
writ
1 minute.
petition.
Submit that.
And once that order is passed.
1
nothing
minute.
changes. Sorry.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಲ್ಲ ಆಮೇಲೆ?
ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ 24/9/24 ಆದ್ಮೇಲೆ ಹಾಕಿದೀರಾ?
My lords, after this order, I filed an application.
After 24/9/24.
Yes, my lords, I filed
Where
an
is that?
application for recalling the order.
Where is that application?
My lords, that application I have not produced, my lords.
It is pending consideration.
It is pending consideration, my lords, already, my lords, my learned friend has taken.
Will direct the court to consider
Yes,
that.
my lords,
ಅಷ್ಟೇ?
18 dates, they have taken time for filing objections on my application.
In a 15 days, I will direct it to be
Yes, my
considered.
lords. My lords, on the memo, my lords, what my learned friend has filed, my lords, I filed a wrong affidavit, my lords, memo, saying that I have sought for liberty to file a fresh suit before.
What
this
they have
honorable court.
filed is
My lords,
there.
1 minute, my lords.
Sir, whatever is filed, not filed, I am bound by what 24/9/2024 order says. He has filed an application on the liberty reserved by the coordinate bench. That application is pending. I will direct the court to consider in accordance with law. Whatever you want to say, you say
But,
there.
my lords, this memo may not be accepted for this, for
Which memo?
dismissal. My lords, for
ಇಲ್ಲಿ
dismissal.
ಹಾಕಿರೋ memo ನ?
ಹಾಕಿರೋದು. What they said that, my lord, I have been reserved liberty to file a fresh suit by the this honorable court is the memo reads, my lords.
We
Cannot
forget
be
about
done,
the
my
memos.
lords.
ಯಾಕೆ ಮೆಮೊ ಬಗ್ಗೆ ಅಷ್ಟಂತ?
ಅಲ್ಲಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳೋದು, my lords, they should not.
The petitioner is before this court seeking the following prayer. The petitioner, the parties to the list were before the court in RFA 50 of 2020. Ada? RFA 50 of, in RFA 50 of 2020, the petitioner makes a submission that he would wish to withdraw the suit. The coordinate bench records the said order, records the said submission in terms of the order dated 1/8/2022. It reads as follows, page 98, madam. Accordingly, the petitioner files a memo before the filed an application before the concerned court under Order 23 Rule 1, and the application reads as follows. The application is supported by an affidavit. The few paragraphs of the affidavit, paragraph 8 of the affidavit that is germane reads as follows, page 107. The concerned court passes an order on end date 18/8/2022. It reads as follows. In terms of the undertaking rendered by the petitioner in RFA 50 of 2020, the suit is permitted to be withdrawn. No liberty is reserved to file a fresh suit. It is therefore the petitioner is before this court. This coordinate bench of this court, after hearing the parties at length, on 24/9/2024 had passed the following order. In terms of the said order, the coordinate bench reserved liberty to the petitioner to file a necessary application before the concerned court if he would so desire. Exercising the said liberty, the petitioner has already preferred an application
On 21/11/2024.
on 21/11/2024, the learned, which is pending consideration. The learned counsel for the petitioner submits on the pretext of filing of statement of objections, the matter has been adjourned on close to 18 occasions. Therefore, I deem it appropriate to direct the concerned court to dispose the application so filed in terms of the order dated 24/9/2024 with an outer limit of 4 weeks from the date of receipt of the copy of the order, objections, if not filed by then, be filed by the respondents. On the pretext of filing of objections, no further adjournment should be granted by the concerned court. With the aforesaid observation, leaving open all the contentions of the petitioner and the respondent to be urged before the concerned court, the petition stands disposed.
RFA may be listed before the roster bench, my lord.
Other D-Link RFA 50 of 2020 posts the matter before the bench having roster.
Seven.
Recalling what, sir?
Recalling non-prosecution dismiss.
Allowed for the reason so and so, restored to file.
I seek for stay, my lords.
Avagitta?
Avaga, my lords, there was a condition, my lords, on 4/9/2023 for deposit of 10 lakhs, my lords.
Madilva?
Madidi, sir. I have deposited 25 lakhs, my lords, now. In 20 lakhs matra kodbeku.
Dismiss agid yake?
That's non-prosecution dismiss agid.
Yaar nanda?
No.
My order.
No, not your order. It is dismissed on 26/10/2023, my lords. Let's see
The
petition.
coordinate bench of this court dismissed the subject petition by the following order. The learned counsel for the petitioner submits that not 10 lakhs but 25 lakhs has already been deposited before the court. He could not be present on the said date owing to the reasons narrated in the affidavit accompanying the application. In the light of the aforesaid submission being satisfied with the reasons so rendered in the affidavit accompanying the application, the order date so and so stands recalled. The petition is restored to file. Any order subsisting as on the date of its dismissal shall stand restored.
Let's stay.
Avatti
Our stay ಕೊಟ್ಟಿಲ್ಲ 10 lakhs deposit ಮಾಡಿ bona fide ತೋರಿಸಿ ಆಮೇಲೆ stay
in the light of the petitioner submitting that he has deposited 25 lakhs, ಎಲ್ಲಿದೆ?
ಆಮೇಲೆ
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ? ನಿಮ್ಮ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಲ್ಲ?
No, my lords, to the respondent.
To the respondent, 25 lakhs. There shall be an interim order of stay of further proceedings as sought for.
Statement also produced.
As sought for. Notice ಆಗಿಲ್ವಾ?
ಇಲ್ಲ sir, ಎಲ್ಲ clear.
ಎಲ್ಲ clear.
Bank statement I have produced.
So and so emergent notice to the respondent returnable by 26th September.
What's up, please?
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು 50 ಲಕ್ಷ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ಇಲ್ಲ my lords, 45 lakhs compromise ಆಗಿತ್ತು sir. 45 lakhs ಕೊಡಬೇಕಿತ್ತು, 20 lakhs
ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ
ಇಲ್ಲ ಇಲ್ಲ sir.
25 ಇನ್ನೊಂದು 25 ಹಾಕ್ಬೋಣ.
No.
Yes.
8.
Appeal. The learned counsel for the petitioner submits that he would prefer an appeal against the order, as the order is an appealable order. Order impugned is an appealable order. Reserving such liberty, the petition stands disposed.
9.
Question for the respondent in this matter.
Delay.
Delay.
Okay. The petitioner is entitled to the benefit of section 14 of the Limitation Act.
Yes. Respondent in this matter, my lord.
Rectification. Nimde vacating stay rectification.
I filed the application for vacating of stay.
Adralle rectification iradu.
I'll just
We will
verify.
dismiss the IA then.
No.
The learned counsel seeks a week's time to rectify.
It may be fixed, my lord.
Rectify the objections que the vacating stay application.
Next week, Monday or Tuesday.
Wednesday next. Vacating stay hakir. Under the caption interlocutory application. Comply madidra illa andre illa.
10.
For the first respondent.
Yes, my lord. Respondent number 3 to 10 has not been served.
Then
7
Correct
suit for partition.
correct court ಗೆ ಬಂದಿದ್ದೀರಾ?
ಆಗಾಗ
11 ಬದಲು ಇಲ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಆಗೊಂದ್ಸಲ ಈಗೊಂದ್ಸಲ. My lord, the petitioners approach on the ground that their interim TI is not been considered ex parte. Therefore, they have
Both of
approached
you
this
are there.
court.
Let the court
ಅಷ್ಟೇ
consider.
ಅಲ್ಲಿ.
Consider and pass orders.
Pass
my lord.
orders.
Then, still then, my lord.
ಏನಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Please.
For 4 weeks.
Please.
The petitioner, the plaintiff, is before this court seeking the following prayer. What drives the petitioner to this court is non-grant of ex parte temporary injunction as sought for under application 39(1) and 2, rule 39(1) and 2. This court, protecting the interests of the petitioner, had granted an interim order till the next date. The interim order was directing not to create any third-party interest in respect of the property. Now the respondent has represented and the application is pending before the concerned court. In that light, I deem it appropriate to dispose the petition with a direction to the concerned court to consider the application in Authorized Rule 1 and 2 within 4 weeks from the date of receipt of the copy of this order. The interim order subsisting would continue till the application is considered. The parties are at liberty to seek necessary orders from the hands of the court. Yes. Ordered accordingly.
29th ke
Respondent
the
may
matter is-
undertake to file work because there also all.
Both ಇದೆ.
29th ಇದೆ. So
29th.
4 weeks, 29th ಇದೆ.
September. 4 weeks correct ಆಗುತ್ತಲ್ಲ.
Please, from today ಅಂದ್ಬಿಟ್ರೆ, that will also will advance the case.
ಏನಾಗತ್ತೆ
From the
ಸರ್ವ್
date of
ಆಗಿಲ್ಲ.
receipt. ಇವತ್ತೇ ರಿಸೀವ್ ಆಗ.
Very well.
Serve ಆಗಿಲ್ಲ. Therefore, my lord, court may in problem because all of them they have not taken.
But
Let him undertake.
contesting is me.
ಅಲ್ವಾ?
ನಾನು contesting is by on my
ಅಲ್ಲಿ
properties.
trial court ಅಲ್ಲಿ
They are all
ಇಲ್ಲ ಆದಂಗೆ ಆಗೋದು.
Accordance with laws.
Please. ಮತ್ತೆ.
11.
Lord, I
2
appear
weeks
for the
time to
petition.
do the needful interim order subsisting will continue till the next date of hearing.
My Lord, can a date be fixed, my Lord? I appear from, I'm coming from Kolkata, so my Lord.
From?
From Calcutta, my Lord.
ಇವಾಗ ಕೋಲ್ಕತ್ತಾ ಅಂದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರು.
Lord,
Yes.
Kolkata
You
is
are
the
correct
new name
only.
given
Yes.
to Calcutta.
No problem.
So can. a
What's
date-
the matter?
So this is a application under 227, which has been filed pursuant to leave granted by the Honorable Supreme Court. That, my Lord, a 29A application has to be filed whether the cause of action arises. So, my Lord, this order was passed by the commercial court at Bangalore, where no part of the cause of action arose. So against that, my Lord, order, we have come back before my Lord, pursuant to a leave granted by the Honorable Supreme Court.
No, I have granted an interim order.
Yes, my Lord,
We'll
kindly, my
fix a
Lord,
date. When do you come next?
But, whenever Lordship pleases, but my Lord, our long holiday starts from 27th, my Lord. The Puja
Same here,
holidays.
same here. We'll do it before that.
My Lord, we
For-
can come back in November, my Lord, if your Lordship.
No problems. Yes. But PF is not paid. Who's the advocate? Yes, Amit? Why?
I've served the copy, my lord.
A week's time is granted to do the needful. Heard the learned, your names,
Shoturu Banerjee, my Lord.
so and so appearing for the senior counsel?
My Lord, there is a meeting, but I wouldn't say.
Oh, yes. Nice. All the best. Yes. The heard the learned counsel so and so appearing for the petitioner. This court had granted an interim order of stay in terms of its order dated so and so on the score that no part of the cause of action arose within the jurisdiction of the court at Bangalore. Albeit prima facie. The respondent is yet to get served. Therefore, list the matter in on November the 7th, 2025.
Writ for me. Writ.
Interim order subsisting would continue till the next date of hearing.
Writ.
Needful be done in the next 1 week.
12.
Yes.
I am for the petitioner, my lord. In this case, my lord, respondent filed a suit for specific performance. my
ಸರ್ವ್
lord.
ಮಾಡಿದ್ದೀರಾ?
ಸರ್ವ್ ಮಾಡಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಸರ್ವ್ ಮಾಡಿದ್ದೇವೆ ಸ್ವಾಮಿ. ನಂತರ ನಾಳೆ ಆಕ್ಷನ್ ಕೋರ್ಟ್ ಆಕ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರು ನಾಳೆ. ಅದು ಸ್ಟೇ ಆಗ್ಬೇಕಾಗಿದೆ ಸ್ವಾಮಿ ಅವ್ರೆ. ನಮಗೆ ಸಿವಿಲ್ ಮಿಸಲೇನಿಯಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರೆ.
List the matter on 12th in preliminary hearing. This court on 22/8/2025 had passed the following order. In the light of the absence of the respondent and the observation in 22/8/2025, auction insofar as the property of the petitioner shall remain stayed till the next date.
Hand delivery may be given. Much obliged.
Yes.
13.
Rectification of
Served the copy.
ಏನು modification?
Interim order was granted subject to deposit of 20 lakhs.
ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ?
First condition is complied. Second condition for which my lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಸೇಮ್ ಸಾಂಗ್.
My lord says.
ಇವತ್ತಿನ ಸಾಂಗ್ ಬೇರೆ ಟ್ಯೂನ್ ಇರ್ಬೇಕು.
My lords have heard this matter.
Correct.
My lords, the decree is for 25 lakhs. My lords, I have placed the material on record.
You have withdrawn 10 lakhs now?
ಇಲ್ಲ my lord, interim order certified copy ಬಂದಿಲ್ಲ.
ಯಾವತ್ತೂ ಆಗಿರುತ್ತೆ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಬಂದಿಲ್ಲ.
Just.
ಏನೇನೋ ಮಾತಾಡ್ತಾರೆ. Yes.
Lords, now application.
ಅಪ್ಲೈ ಮಾಡಿ ಸಿಗುತ್ತೆ.
Application to
ಡೋರ್
recall.
ಡೆಲಿವರಿ ಸರ್ವಿಸ್ ಇಲ್ಲ, ನೀವೇ ಅಪ್ಲೈ ಮಾಡ್ಬೇಕು.
ಅಪ್ಲೈ ಮಾಡಿದ್ದೇವೆ.
ಎಲ್ಲಿ ಹೋಗಿ ನೋಡ್ಬೇಕು. Yes,
Application to recall the warrant has been rejected, hence I am before this court.
I have stayed it anyway.
My lord, stayed subject to condition of 10 plus 10. 10 have complied with, my lord, the other for 10.
Next
another 10.
5 ಇದೆಯಾ?
No, every decree is complied with, that is the reason why I am before this court.
ಆಯ್ತು, ವಿಡ್ರಾ ಮಾಡ್ಲಿ ಅವ್ರು. 10 ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ ಮುಂಚೆ?
ಇಲ್ಲ my lord.
10 plus 10 ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ ಈಗ?
My lords, ಅವರು ಇನ್ನೂ 10 ಪೇಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ ಇನ್ನು. Next 10.
For another 10, I made an application to relax the condition.
No relaxations.
The reason is this, there is no, my lords, decree is already complied with.
ಅದೇ 20 ಲಕ್ಷ.
ಇಲ್ಲ. My lords, there is a reason, just I'll place this memo.
ಮನಿ ಡಿಕ್ರಿನಾ?
No.
ಪುಟ ಏನಿದೆ?
But just I'll place this memo.
ನೀವು ಅದನ್ನೇ ಕಲ್ಸಿದ್ದೀರಾ ಅವ್ರಿಗೆ. ನೀವು ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಅಲ್ಲಿ ಕೊಟ್ರೆ ಅವರು ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಅಲ್ಲಿ ಕೊಟ್ರೆ.
I'm sorry, sir.
Yes.
Hurry,
Court.
I'm sorry, sir.
Ah.
Such mistakes not to my.
Yes.
Deposit before the court is 10 lakhs. Total amount paid in the joint account is 19 lakhs 18,828. That is from January. Husband. Now, my lord, school fees paid by the petitioner is 6 lakhs. Total amount paid is 35 lakhs 18,828.
ಅದು ಸ್ಕೂಲ್ ಫೀ ರಿಕರಿಂಗ್ ಅದು.
ಇಲ್ಲ, my lord, just. Total amount paid is 35 lakhs 18,828.
ಆಯ್ತು,
Total
now you-
decree amount is 25 lakhs.
Now you take 10 lakhs.
My lord.
You withdraw 10 lakhs, we will see remaining later.
My lords, on the last date, it was argued at length, my lord. In fact, I showed it your lordships. According to the memorandum of understanding, 25 lakhs had to be paid in fixed deposit. Along with that, for 3 years, he was liable to maintain the children and the wife.
For 3 years.
For 3 years, my lord.
That is the reason 10
My lord,
lakhs 18,000 is in excess with him. That is the school education expenses.
ಅದು ನಿಮ್ಮ ಮಕ್ಕಳಿಗೆ ಸರ್.
ನನ್ನ ಮಕ್ಕಳಿಗೆ.
ಮತ್ತೆ
My lords, for
My lords,
24
all that I am saying is let the warrant be recalled. My lords, let the executing
stay
court
ಮಾಡಿದೀವಲ್ಲ.
adjudicate this thing. Execution petition is still
First 10
pending.
lakhs withdraw ಮಾಡ್ಬಿಡ್ಲಿ ಅವರು.
Let,
You withdraw 10 lakhs today. We'll post this on Wednesday and close the matter.
Yes, ma'am. Please.
The petitioner submits, ಅಲ್ಲ ಇದ್ಲೇನು ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ.
Already ಮಾಡಿದ್ದೀರಾ, my lord.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಬಂದಿದ್ಯಾ ನೋಡಿ. 1 ವಾರ ಆಗಿದೆ ಬಂದು. ಇನ್ನು ಅದೊಂದು ಕೇಳ್ತೀರಾ, ಡೋರ್ ಡೆಲಿವರಿ ಕೊಡಿ.
ಇಲ್ಲ.
ಮತ್ತೆ? Yes.
second condition be relaxed for time being.
No.
Warrant is an excess 10 lakh.
No problem. You relax till the next date. Second condition will look at relaxing
The
next.
execution is going on.
Let it go on.
My lords, if
Arrest
I have
warrant
not-
ಏನಾರು ಕೊಟ್ರೆ ಬನ್ನಿ.
Arrest warrant, because I made an application for.
ವಾರಂಟ್ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಲ್ಲ.
My lords, warrant was, proceedings was stayed subject to 2 conditions.
No.
10 lakhs I
If
had
there,
deposit.
if the court could do anything, come back, sir. Yes. First ಅವ್ರು 10 withdraw ಮಾಡ್ಲಿ. ಹಸ್ಬೆಂಡ್ ಅಲ್ವಾ, ಅಷ್ಟು ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೊಡಲ್ಲ.
Great.
Yes. Next Wednesday.
Yes. Office objection be overruled, my lords.
With regard to what?
Not serving the copy of the IE.
Office objections overruled. List on 10th.
Great.
Great.
14.
Furnishing FPF issue.
Appeal for the petitioner, my lord. My lord, neither the petitioner nor her GPA holder has come forward to comply with the interim order, my lord.
That's not the issue. PF ಎಲ್ಲಿದೆ?
ಅದೇ
PF ಕಟ್ಟಿದ್ರೆ ಹೆಂಗ್ ಬರ್ತಾರೆ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ?
ಅಲ್ಲ ಅವರಲ್ಲ, ನಮ್ಮವರು. Petitioner has not come forward. We do not have any instruction from them.
We'll dismiss it then.
By a week's time may be granted, my lord. We will file a memo of retirement, my lord.
A week's time is granted to do the needful. Yes.
15.
So, I pay for the petitioner, my lord.
Furnishing PF.
No, so far as PF is concerned, my lord, there was no order for issuing notice through court. We have served the copies to the standing counsels at the plaintiff, my lord. I filed a memo to that effect as well as this affidavit where the respondent number 10 to 12 has avoided the service.
13 to 18 dispensed.
Please, my lord. On 7th.
Needful has been done and last time council files a memo dispensation.
Please. On 1/19 I filed a memo to that effect.
Petitioner to serve,
We have done it.
take out steps on the respondents. Interim order subsisting would continue to the next date. Next.
No, we have served the copies to the standing counsel. They were
ಅವ್ರೇನ್
received.
ಬಂದಿಲ್ಲಲ್ಲ. Next.
No, I've served the memo on the 1/9/2025, filed the memo in the registry.
ಈಗ R1 to R12
ಆಗಿದೆ, my lord. We have
ಯಾರಿಗಾಗಿದೆ?
R1 to R8, I have served the copies to the plaintiffs.
ಅದಕ್ಕೆ take out steps.
Great.
Yes. Next.
16.
Post immediately after service of notice upon respondents 9 to 11 IO if any. Yes.
Interim order making. So in
Next.
serial number 16, interim order making.
ಆಯ್ತು sir.
17.
For
Trial
respondent
court.
number 1. For respondent number 3 in this matter.
Third. Both the counts it's as per your lordship direction.
R1, 2 and 3.
R1. I'm appearing for 3, my lordship, and also undertake to file the wakalat on behalf of R2.
R2.
3 also served.
The learned counsel. What's your name, madam?
Radhika K.
So and so undertakes to enter appearance for respondents.
Number 2.
Respond 2 and 3 both.
Both, my lordship.
Arvind
The same
Desai
office.
ಅಂತಿದೆ in respondents 2 and 3. Yeah, what's the matter?
26. Yeah, annexure H, my lord.
Commissioner. Suit for?
Suit for declaration portion.
Suit stage.
Stage is evidence.
Scientific evidence.
Evidence.
Suit of the year?
Of year
2010.
my lord. Annexure
10.
H, annexure H, my lord.
And that is rejected.
Page number 58.
Rejected. Correctly rejected. Yes. List on 17th.
18.
That I represent the petitioner, my lord. I have served the copy on the counsel who represents the defendants in the trial court also.
The learned counsel submits needful has been done. The petitioner shall take out steps for service of respondent 2 and 3 apart from the order dated 1/8/2025 by the next date. Interim order subsisting will continue to the next date.
Please.
19.
Insert the copies, not Charati appears in case. Pray for time, Your Honor, for objection, respondent number 4.
Counsel for the respondents seek 2 weeks time to file objections or otherwise. List after 2 weeks, interim order subsisting will continue.
20.
Post immediately after service of notice upon.
ಒಂದು ನಿಮಿಷ ಸ್ವಾಮಿ, ಈ ಆಲ್ರೆಡಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಅದೆಲ್ಲ ಬಂದೋಗಿದೆ. ಸುಮ್ನೆ ಡ್ರಾಗನ್ ಈ ಕೋರ್ಟೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದೆ 23 ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಬಟ್ ಅದನ್ನು ಕನ್ಸರ್ನ್ ಮಾಡಿ ಇಲ್ಲಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿ ಸ್ವಾಮಿ, ಸೇಮ್ ಪ್ಯಾಕ್ಸ್ ಆಫ್ ಕೇಸು ತಿರ್ಗಾ ಅದೇ ಪ್ಯಾರನ್ನೇ ತಿರ್ಗಾ ಆಡ್ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್ ಅಮಾಂಡ್ಮೆಂಟ್ ಆಫ್ 6 Rule 17 ಕೇಳ್ತಾರೆ. 2 and 3 is not necessary party, is only tenant, my lord. Not file any return statement, any objections.
Notices may be issued upon 2 and 3.
No, sir.
ಮಿಸ್ಲಿನಿಯಸ್ ಆಗಿ ರೆಸ್ಟೋರ್ ಆಗಿ 23
ನೋಟಿಸ್ ಬೇಕಾ 2 and 3 ಗೆ? I'll vacate the interim order and issue
No, my
notice.
lords, no, my lords. The interim order may be.
We'll vacate the interim order and issue notice.
No, my lords, interim order may.
is not necessary.
Not necessary ಅಂದ್ರೆ ಮೆಮೊ ಹಾಕಿ.
I'll file a memo.
File a memo, list the matter on 10th.
Interim order may be.
Interim order subsist. Memo ಹಾಕಿ ಈಗಲೇ.
Yes.
Yes, interim order subsisting will continue to the next date of hearing.
ಡಿಸ್ಪೋಸಲ್
Disposal 10th ಗೆ disposal ಗೆನೆ. Preliminary hearing.
21.
ನಿಮ್ಮ ಹೆಸರು ರಾಜಾನಾ?
ಹೌದು.
Yes.
23 ರಿಂದ ಎಳಿತಾ ಇದ್ದಾರೆ. 2023ಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಗಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
2023ಕ್ಕ?
ದಿಸ್ ಆನ್ ಬಲ್ಕೋ ಡೈರೆಕ್ಷನ್ ಸರ್.
ಅಲ್ಲಿಂದ ಎಳೀತಾ ಇದ್ದಾರಾ?
No, my lords.
ಒಂದಲ್ಲ ಒಂದು ಅಪ್ಲಿಕೇಶನ್.
Initially, the suit was filed as an indigent person. Then I was placed ex parte. My miscellaneous was rejected, my lords.
Get ready on 10th, no more adjournments. Yes. ಇನ್ನು ಎಳೆಯಕ್ ಬಿಡಲ್ಲ ಬಿಡಿ.
21.
And for the petitioner, my lord, we have served the copy to respondent number 2 and 3, my lord.
Post immediately after service of notice upon respondents 2 and 3.
ಸ್ವಾಮಿ ಸರ್ವಿಸ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ 2 and 3 ಗೆ.
Council submits needful has been done, office to verify. Next. Yes.
22.
Please, appear for respondent.
Learned counsel so and so. ಇದಿರಲ್ಲ already. ಮತ್ತೆ trial court advocate. All of them are represented?
Yes. I guess except respondent number 2, everybody else is represented.
R2 ಯಾರು?
R2 CH Shivappa anta.
ಅದಾಯ್ತು, ಅದೇ who knows.
Well, he is the brother of respondent number 1.
Suit for partition.
Suit for declaration.
Declaration. No representation on behalf of the petitioner. List after 2 weeks.
Please.
Yes.
53.
Post immediately after service of notice upon the respondent. Interim order continue.
24.
We have served the counsel appearing, single counsel is appearing.
but they have filed wakalat only for R1.
Same counsel.
Same counsel is appealing for all the respondents.
ಆಯ್ತು ಬರ್ಲಿ ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದೆ sir.
List on 17th, awaiting the appearance / representation of R2 and R3.
Entry border.
Entry modus.
25.
Respondent 2 to 11 is not required to be adjudicated. I am placing the memo for it. Dispense the notice to be gathered.
Dispense.
Respondent 2 to 11. That was the formal parties. I narrated the same in cast title also. my lords.
List after 2 weeks, entry modus subsisting will continue to the next.
Great.
No for dispensation.
Dispensation allow ಮಾಡ್ಬಿಡಿ. Yes.
26.
26 appear for petitioner Melado. R1 is served Melado. Respondent number 2 to 10 are placed ex parte before the trial court Melado.
Memo.
Can entry matter may kindly be extended.
Apart from the order dated 4/8/2025, the petitioner shall take out steps to serve R. Memo ಯಾರಿಗೆ ಹಾಕ್ತಾ ಇದ್ದೀರಾ?
Respondent number 2 to 10 Melado.
R1 in the light of the memo ಇದ್ರೆ ಮಾತ್ರ. Memo so filed. Dispense. Yes.
Please.
Next. Entry modus subsisting will continue to the next date.
27.
Post immediately after service of notice upon the respondent. Entry modus.
58.
My lord, I appear for petitioner. My lord, I have served the copy, my lord, writ petition papers on the council appearing for the respondent.
Entry modus ಇದೆ ಪ್ರಕಾಶ್ ಸರ್.
ಇಲ್ಲ ತಾವು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಜಾರಿ ಮಾಡಿದ್ದೀನಿ. 30 ಆಗಸ್ಟ್ 25ಕ್ಕೆ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹಾ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇಲ್ಲಿದೆ, ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀನಿ, ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
This court on 13/8/2025 had passed the following order. On 29/7/2025, the following order. Even today, the respondents are not represented. In that light, there shall suit ಏನು?
ಅಲ್ಲ, suit is for partition and declaration, etc.
ಏನ್ entry ಮಾಡ್ರೆ ಏನು?
Entry order, my lord, to stay the further proceedings, my lord.
Why?
Because I wanted PW1 to be cross-examined.
1817 application.
ಹೌದು ಹೌದು.
Further proceedings till the next date shall remain stayed. List on 17th. Yes.
29.
29, my lord. The first respondent, my lord, is no more. By oversight, my lord, we had made him as a party. Respondents 2 to 5 are LRs, my lord, who are already on record. Respondents 6 to 8, my lord, are ex parte. I may be pleased filing the memo, my lord, for dispensation. The other respondents, my lord, are served and represented, my lord, served on the council.
Counsel for the petitioner files a memo. In terms of the memo, ಏನೇನ್ ಕೇಳಿದ್ದೀರಾ ಸರ್?
First respondent to delete first respondent, dispense notice to 5.
First respondent who is no more be deleted from the array of parties. The memo further indicates that respondent 6 to 8 were placed ex parte before the court and seeks dispensation of issuance of notice. In terms of memo, all others are served. Therefore, the service of notice has stood completed. List the matter on intermodal. List the matter after 3 weeks. Intermodal subsisting will continue to the next day.
Great.
3 weeks. 30.
My lords, I've served a copy on the counsel appearing before the trial court, my lords. I've informed him as well yesterday. He said there's some personal inconvenience, so he won't be able to appear today, my lords.
List on 10th in preliminary hearing. Intermodal subsisting will continue to the next date of hearing. Counsel of the petitioner submits. Needful has been done. Office to verify. Next.
Obliged, my lords.
31.
Appearing to the petitioner, my lord, I've already served on the respondent counsel who's appearing before the trial court. Respondent number 1. Respondent 2 has been placed ex parte. I've mentioned that memo. I'll file another memo, my lord.
You already filed a memo?
Yes, I had filed a memo, my lord, stating that respondent number 2 has been placed ex parte on 2nd August. I filed a memo, my lord. I'll file another specific memo if that is required.
Yes. Counsel of the petitioner submits needful has been done. Office to verify. List after 3 weeks. Interim order subsisting will continue to the next.
Great.
Yes, next.
32.
Application for application under 18 rule 17. ಇದರಲ್ಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 to 11 they have not filed written statement. Maybe dispensation my lord.
Memo.
Memo ಕೊಡ್ತೀನಿ ಸರ್ ಈಗಲೇ.
ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಕೊಟ್ಮೇಲೆ ಡಿಸ್ಪೆನ್ಸ್.
ಈಗಲೇ ಕೊಡ್ತೀನಿ ಸರ್.
ನೀವು ಕೊಟ್ರೆ ಈಗಲೇ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ. ಅದೆಲ್ಲ ತಗೊಂಡ್ಬರ್ಬೇಕು.
I'm sorry my lord. I will write it and give it.
ಹಾಗಾದ್ರೆ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಕ್ಷನ್ ಮಾಡೋದು ಬೇಡವಾ?
ಇಲ್ಲ 1 ಮತ್ತೆ 12 who are contesting ಅವ್ರ ಮೇಲೆ ಸರ್ವ್ ಮಾಡಿದೀವಿ.
Counsel for the petitioner submits respondents 1 and 12, i.e. the contesting respondents are served. List the matter on. Interim order ಇದೆಯಲ್ಲ?
Interim order ಇದೆ.
List after 2 weeks IO till then. Memo ಕೊಟ್ರೆ ಡಿಸ್ಪೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ.
33.
As well undertaking wakalat of respondent, my lord. Interior
DD
order.
is ready with my lord.
DD?
File in the council.
What DD?
Interior order not complied, my lord.
one ನಿಮಿಷ.
I'm complaining.
Not complied.
No, my lord, I'm complaining. Just received morning, my lord.
Shall remain state subject to condition of payment of 1 lakh.
Yes, DD is ready, madam. I will file in the counter today.
The DD na photo na?
DD, my lord.
DD na ready.
My lord.
Original.
Previous writ petition is pending, my lord.
Which is that?
Same related execution petition stay ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಆಯ್ತು, ಯಾವ ನಂಬರ್ ಹೇಳಿ?
Writ petition number 11601 of 24.
Tag this petition along with 11601 of 2024.
So trial court advocate has refused to accept notice, my lord.
No, my lord.
ಇವ್ರು ಯಾರು?
Chikmagalur, my lord. That court.
ಟ್ರಯಲ್ ಎಲ್ಲಿದೆ?
Order has
ಇವ್ರಲ್ವಾ ಅದು?
No, my lord.
So it's
Kindly interim order may extend it. I will.
DD ಕೊಡಿ.
Yes.
The learned counsel for the petitioner hands over a demand draft of rupees 1 lakh in terms of the order dated 5/8/2025, which is acknowledged, receipt of which is acknowledged by the counsel appearing for the respondent.
Interim order.
Interim order subsisting would continue to the next date of hearing. Tag this petition along with. ಬರ್ಕೊಂಡ್ರದು? Yes.
Obliged.
Next. Yeah. ಒಂದು ನಿಮಿಷ ಮೇಡಮ್. Name ಕೊಟ್ಟಿದ್ದಾರಾ? Learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondent. Yes.
34.
Petition counsel is not well, my lord.
Not well.
I pay for respondents tomorrow or Monday, my lord.
He'll be well.
I'll seek time for objections.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. The R1 and R2 ಇಬ್ರಿಗೂ ನೀವೇನಾ?
Ibro.
Registry to delete the indication of awaiting service for R1 and R2 as the respondents are represented. List the matter on 17th. Interim order subsisting would continue to the next date of hearing. Next. Objections, if any, by then.
35.
For the petitioner, my lord. Returning the hand summons, my lord. In the trial court, defendants have not turned up.
Petitioner shall post immediately after service of notice upon the respondent 1 to 5.
Memo filed to. Returning of hand summons, my lord.
I'll register file.
Yes.
17th interim order. Yes, next.
Post after service.
Post after service. Yes.
17th ಇಲ್ಲ. 36.
Served on the caveator minutes by way of RP. 23 lakh rupees is the lease amount.
23?
23 lakh rupees is the lease amount. Without paying that, my lords, they tried to dispossess me. I filed suit, my lords. Trial court issued emergent notice. Then, my lords, now they have virtually demolished the building itself. Not to change the nature
On
of.
acceptance of post having serve ಮಾಡಿದ್ದೀರಾ?
Serve ಮಾಡಿದ್ದೀನಿ.
ಈಗೇನ್ ಬೇಕು?
Lords, not to change the nature of the.
ಆಗೋಗಿದೆಯಲ್ಲ, ಡೆಮಾಲಿಶ್ ಆಗೋಗಿದೆ.
At least ಹಾಗಾದ್ರೂ ನಮ್ಗೆ ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅಂತ, ಇಲ್ಲಾಂದ್ರೆ ದುಡ್ಡು ಕೊಡಲ್ಲ, ಏನೂ ಇಲ್ಲ.
I list the matter on 17th, awaiting the appearance of the caveator, respondent number 4. List 4, the respondent is restrained from changing the nature of the property till the next date. Yes, next.
Time notice to emergent notice to R1 to 3, R2.
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
R1 to emergent notice to 1 to 3 returnable by ಯಾವತ್ತಾಗ್ತದೆ? 17th. Yes.
Please. Great.
37.
Lord, the notices have been taken out again to R3 and 5.
The interim order expires today, my lord, your lordships may extend it.
ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್?
Respondent number 1, my lord. I appear for respondent number 1, my lord. I have come on record today, my lords.
Learned counsel. So also undertakes to enter appearance for the respondent. Muralidhar C ಅಂತಿದೆ.
I have come on NOC.
Submits that she has entered appearance in place of Muralidhar C. Registry to print the name of so and so as appearing for the caveat respondent number 1. The learned senior counsel submits in terms of the order dated 5/8/2025. Steps have been taken to serve response 2 and 3.
3 and 5.
3 and 5. The registry to put up the matter after representation of 3 and 5 or on 17th, whichever is earlier. Interim order subsisting would continue till the next date of hearing. I heard the learned senior counsel GL Vishwanathan mail hakut ಮಾಡಿ.
Just after your lordships have extracted the order of the trial court, one of my apprehensions was that the suit, independent suit, not this suit, the suit as between the plaintiff, the petitioner and respondent number 2 is sought to be compromised. So it will not come in the way anta tavu bardiddira alli. After extracting it, your lordships have noted there that yesterday everybody has gone there, including the man who is 85 years old. He comes there to the court. Compromise petition is filed. The present respondent number 1, my lord, files an impleading application in a suit that is going to be disposed of. And we said it can't be done. The plaintiff doesn't want to prosecute the suit.
That is under challenge.
No, that is.
Yes, you want, we'll take it on 17th.
Please.
List on 17th in preliminary hearing. Objections, if any, by then.
Obliged.
Yes.
One submission, my lord. Serial number 33. They have taken the DD in the name of this court.
To deposit ಮಾಡಿದ್ದಾರೆ. My lord.
Again ಮಾಡೋಣ ಅದಕ್ಕೆ.
Change it 2 days given.
List on Monday 8th. Change ಮಾಡದೆ ಹೋದ್ರೆ ಮತ್ತೆ will vacate it.
No, my lord, no. I will change.
Obliged.
Bona fide mistake. Yes. Yes, Vardhan sir.
ಬಾಕಿ ಅವ್ರಿಗೆ ಬೇಕಿಲ್ಲ. It's between me and the plaintiff. I am filing a memo to.
ಏನಾಯ್ತು? Dispensation.
It's only between me and the first respondent.
ಇವರು ಇದಾರಲ್ಲ first respondent. Yes, Vijay Kumar.
Please. That's the only question is, after the matter is posted for reply arguments, he files an application for recalling PW1. He wants to mark 2 documents. One is a judgment of this court in a RFA, which is in fact already marked as exhibit P29.
All right.
The other document which he wanted to mark is some 84 proceedings where my father is stated to have made some admissions.
So what?
This is a suit for immovable property for declaration and possession.
So what would madli bidi? Adre mere marking of a document will not amount to its proof.
Already ಒಂದು mark ಆಗೋಗಿದೆ. ಅದರಿಂದ no purpose will be served.
Correct.
The suit is one for possession, inherently declaratory relief.
ಇಲ್ಲ 16 suit is 2016. I will direct its closure.
ಅಲ್ಲ ಇದು ರೀಕಾಲ್ ದಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಮಾಡಬಾರದು ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ಏನ್ ಟೈಮ್ ಅಲ್ಲಿ?
ರಿಪ್ಲೈ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೋದ.
ಅಯ್ಯೋ ಅದು ಬೇಕಾದಷ್ಟಿದೆ, ಅದು ಈ ತರನೂ ಇದೆ.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಹೇಳಿದ್ದು some purpose what I said. 84 some father's admission, it's a suit for immovable property, declaration and possession.
It is pertaining to
admission
ಮಾರ್ಕ್ ಆಗೋಗಿದೆ. ಮಾರ್ಕ್
ಆಗೋಗಿದೆ ಅದರಿಂದ ಅದು ಅದಕ್ಕೆ
ಆಯ್ತು. ಮಾರ್ಕ್ ಆಗೋಗಿರೋದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಸೂಟ್ ನ 6 months ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಡೈರೆಕ್ಟ್.
ಅಲ್ಲ ಅದು ಮಾಡ್ತೀನಿ, ಬಟ್ ಆ ಮಾರ್ಕ್ ಮಾಡೋದು ಸೂಟ್ ಇಸ್ ಫಾರ್ ಇಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ. ಈ ಬೇರೆಯವರು ಯಾರೋ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗುತ್ತೆ.
We will answer. Mere marking of a document will not amount to its proof.
ಅಲ್ಲ, generally right.
Generally right.
This will be a never ending this thing ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ ತಾವೊಂದು ಲಾನೇ ಲೇ ಡೌನ್ ಮಾಡ್ಬಿಡ್ತಿರೋ ಇದ್ರ ಮೇಲೆ ಅಂತ.
ಅದೆಲ್ಲ ಬರ್ತಾ ಇರಬೇಕು, ನಾವು ಕಳಿಸ್ತಾ ಇರಬೇಕು.
ಯಾಕಂದ್ರೆ ಪ್ಲೇಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ಕ್ಲೋಸ್ ಆಗಿ 1.5 ವರ್ಷ ಆಗಿತ್ತು. ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಆಗಿ ನಮ್ಮ ಡೀಟೈಲ್ ಆಗಿ ಪಾರ್ಟಿ ಸವಾಲ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ
ಆ ಟೈಮಲ್ಲಿ
ರಿಪ್ಲೈನಲ್ಲಿ ಹಾಕಿದ್ದು. ರಿಪ್ಲೈಗೆ ಪೋಸ್ಟ್ ಆಗಿದಾಗ ಅರ್ಜಿ ಹಾಕಿರೋದು.
ಏನಾಗುತ್ತೆ?
Documents are already marked, my lord.
That is
pertaining to the admission made by the father of the petitioner herein.
ಆಯ್ತು, ಮಾಡ್ಕೊಳ್ಳಿ. We'll close direct closure of this suit,
please,
because they are already marked. The petitioner is before this court seeking the following prayer heard so and so. A suit comes to be instituted by the petitioner plaintiff in OS 7132 of 2016 for possession,
Possession.
for possession,
Inherently declaration also.
possession, inter-alia. The issue is not with regard to the merit of the matter. At the time of the reply arguments, the respondent defendant files two applications seeking
Plaintiff filed.
a plaintiff evidence. Plaintiff files two applications seeking marking of two documents. By the time the petition could be preferred or the order could be passed at the hands of this court, the counsel for the parties would submit that the documents had already been marked. The documents that are marked are a judgment of this court in RFA so and so, and another legal proceeding in the year 1984. It is trite law that mere marking of a document would not amount to its proof. It is for the plaintiff to prove those documents in accordance with law. In the light of the marking of documents already taken place and the suit languishing before the concerned court for the last 9 years, I deem it appropriate to infuse finality without interfering with the impugned order with a direction to the concerned court to dispose the suit with an outer limit of 6 months in accordance with law, if not earlier, ordered accordingly.
Obliged.
39.
Post immediately after service of notice.
Interim order may be extended.
Yes, next.
Date may be fixed. But
No, ಎಲ್ಲ ಕೇಳ್ಬಿಟ್ರಂಗೆ. Yes, next.
40.
Lord, my application for recalling the compromise decree has been rejected. Referring to the judgment of the Bhargavi Constructions. Lord, I have produced the order sheet. Your Lordship may kindly have a look at the order sheet. I filed along with the memo dated
Filed an application for
20th
vacating
August
stay.
2025.
When memo?
Order sheet ಹಾಕಿದ್ದೀನಿ.
ಅದೇ ಕೋರ್ಟ್ ಮಾಡ್ಲಿ. ಸಪರೇಟ್ ಸೂಟ್ ಬರಲ್ಲ.
This is a award by the Lok Adalat.
ಲೋಕ ಅದಾಲತ್ ಆದ್ರೆ ಇಲ್ಲೇ.
Lok Adalat, it can only be under 226. Here,
227 also.
My lords, I will submit this. Lok Adalat award, part performance under the compromise. Thereafter, after 3 years, you can't file seeking a review. The order under question is rejecting the review. That does not arise.
23(3)(a), if it is Lok Adalat.
Lok Adalat
It is
award.
23(3). That is why
not-
order sheet, my lord, kindly have a look at the order sheet I have filed. I will show.
Page.
My lord, the test is where the settlement is arrived.
Page.
My lord, I have filed along with the memo dated 20th August 25.
Memo is not given to us anyway. I'll go by the records, my lords. Can't go by the order sheet.
ಎಲ್ಲಿದೆ
Order sheet.
memo?
Award ನೋಡ್ಬೇಕು.
ಮೆಮೊ ಎಲ್ಲಿ?
Put up ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. 20th August 2025.
ಅವತ್ತು ಹಾಕಿರೋದು ಪುಟಪ್ ಆಗಿಲ್ಲ.
ಹಾ.
20th August ಇದೆ ಹೇಳಿ.
ಅದ್ರ
copy
order
ಕೊಟ್ಟಿಲ್ವಾ?
sheet ನೋಡಿ. Page number 4 of the.
ಇಲ್ಲ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅವ್ರಿಗೆ ಕಾಪಿ ಅವಾಗ ಅವ್ರು ಅಪಿಯರ್ ಆಗಿರಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಹಾಕ್ಬಿಟ್ಟು
ನೋಟಿಸೇ ಆಗಿರ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಅವಾಗ.
ಜೆರಾಕ್ಸ್ ಇಲ್ವಾ?
Refer to Lok Adalat
My
for
lord, on
settlement.
18th, the suit was settled for appearance. of the
Refer to Lok Adalat for settlement.
Settlement. Next, your lordship may kindly say, on 18th itself, a compromise petition under order 23 rules filed before the court.
Where?
Before the court.
Lok Adalat.
ಅಲ್ಲ ಅಲ್ಲಿ ಲೋಕ್ ಅದಾಲತ್ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ. ಸೆಟಲ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಅರೈವ್ಡ್ ಬಿಫೋರ್ ದಿ ಲೋಕ್ ಅದಾಲತ್. ನೆಕ್ಸ್ಟ್ ಡೇ ತಾವ್ ನೋಡಿ, ಇಟ್ ಇಸ್ ದ ಅಫೋರ್ಸೈಡ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇಸ್ ಸೈನ್ಡ್ ಬೈ ಪ್ಲಾಂಟಿಫ್ ಅಂಡ್ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 1 and the respective counsel, hence posted for acceptance before the lok adalat. On that day, no parties are present. Kindly see on 12/3/22.
ಸರ್ ಸೆಟ್ಲ್ ಆಗಿದ್ದು ಎಲ್ಲಿ ಸರ್?
ಸೆಟ್ಲ್ ಆಗಿದ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಇಲ್ಲಿ ಪ್ಲಾಂಟಿಫ್ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್.
Before, one ನಿಮಿಷ ಸರ್, before the Lok Adalat on 12/3/2022, the counsel so and so present settlement memo is filed, the case is disposed of as settled. ಎಲ್ಲಿ?
ಅಲ್ಲಿ 18/8/2 previous day.
ಸರ್ 12/3 ಪ್ರೀವಿಯಸ್ ಬಿಡಿ 12/3/22ಕ್ಕೆ
Party say illa, bari what is settled and placed before Lok Adalat is accepted.
So what?
My submission is when it is under the compromise petition is filed under order 23 rule 3, it is not the settlement made before the Lok Adalat. For points purpose, it is taken before the Lok Adalat.
What is the suit for?
Not suit for recovery of money.
ಎಷ್ಟು?
Lord, kindly have a look at that.
ಅಲ್ಲ ಎಷ್ಟು? You are the
51 laksha.
You are the plaintiff.
I am the defendant.
I am the plaintiff.
I am the defendant. 51 laksha ಅವರು ಕೊಟ್ಟಿರೋದು ಅಕೌಂಟ್ ಅಲ್ಲಿ. Totally 90 lakhs change. He claims he has given in cash. His uncle was arrested. He was kept in police custody because he was in the verge of retirement. He was made to enter the settlement. He entered the settlement.
Uncle was custody.
What transfer?
Government servant.
Howದು? He was executing. He introduced this plaintiff to this defendant.
Compromise ಯಾಕೆ ಮಾಡ್ಕೊ?
Al number of multiple criminal cases.
Compromise ಯಾಕೆ ಮಾಡ್ಕೊ?
Multiple criminal cases were filed. On the teeth of arrest, he was forced to enter the settlement. Therefore, my lord, the compromise petition was drafted by them, brought before the court, sent to the Lok Adalat. I filed an
Where did it get closed is what is important.
Closed is before the Lok Adalat. My lord, that is not the ground on which it can be considered.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ಯಾಕೆ? Why are you wanting to withdraw it? Recall ಯಾಕೆ?
Recall because my lord, they registered the criminal case. On the they arrested the Narayan Swami, who is the uncle of the petitioner, kept him in custody.
Story ಹೇಳಿ.
ಅಲ್ಲ ಸ್ಟೋರಿ ಅಲ್ಲ, ನಾನು ಅದನ್ನ ರಿವ್ಯೂ ಅಪ್ಲಿಕೇಶನ್ ಬರೆದು ultimately it is for me to establish that. Now the test is whether I have to file.
Now why are you here?
Why my review application has been rejected on the ground that it is a settlement arrived in Lok Adalat and the
ಯಾವ judgment ಕೊಡಿ?
ಒಂದು ನಿಮಿಷ.
If it is Lok Adalat 226 or 227, both.
Kindly have a look at the latest judgment of the Honorable Supreme Court. The test is where the compromise petition is entertained. Para 14, you last me kindly have a look. Referring to Pushpadevi Bhagavati, it was held that only the court that entertains the petition of compromise can determine its legality at the time of recording the compromise or when it is questioned by way of recall application. No other remedy is available to the party who is aggrieved by the compromise decree as an appeal.
That is settled.
How the?
Which court has recorded the compromise? There only you have to.
My submission
Lok Adalat has
is,
recorded the compromise, so it cannot go there.
In the order sheet, the compromise petition, it was submitted to the court, matter is settled. For technical purpose.
ಎಲ್ಲ ಲೋಕ ಅದಾಲತ್ ಕೇಸಸ್ ಅಲ್ಲೂ ಅದೇನೆ. ಯಾಕಂದ್ರೆ ಪ್ರೀ ಕನ್ಸಿಲಿಯೇಷನ್ ಮೀಟಿಂಗ್ ಆಗಿರುತ್ತೆ, ಪ್ರೀ ಕನ್ಸಿಲಿಯೇಷನ್ ಡ್ರಾ ಮಾಡಿರ್ತಾರೆ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಅದಾಗಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಆಲ್ರೆಡಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಕನ್ಸಿಲಿಯೇಷನ್ ಅವ್ರು ಲೋಕ ಅದಾಲತ್ ಮಾಡಿದ್ರೆ ಇಟ್ ಇಸ್ ರೈಟ್, ಬಟ್ an application is filed under order 23 rule 3 compromise petition ಹಾಕಿದ್ದಾರೆ.
Now why do you want it to be tested there only? ಇಲ್ಲ ಹೇಳಿ.
ಎವಿಡೆನ್ಸ್ ಮಾಡಬೇಕು.
After 3 years.
Because it requires evidence.
On what ground are you now seeking recall?
My lord, kindly have a look at my review application.
Recall is on limited grounds.
Yes, my lord.
What are the grounds?
My lord, kindly have a look at my para 9 of the review application. I have stated how the fraud has been played. Lord, the
sign ಮಾಡಲಿಲ್ಲ.
Number of multiple.
See, coercion is a different thing.
Yes, my lord.
Fraud is a different thing. You can recall it only if there is
coercion.
Coercion requires evidence that you.
That is the reason, my lord, I have gone before the trial court. Kindly have a look at that, my lord. The number of complaints filed against me, I have given the list.
So what?
Ali, because my lord, the whole issue is this. He claims that he has invested money with me for a solar project. Adralli, 50 laksha he has given on account. For that, I have admitted and I have.
ಎಷ್ಟು amount settle ಆಯ್ತು?
2.5 ಕೋಟಿ.
2.5
total monthly 2% interest he has charged in that compromise petition.
ಯಾಕೆ ಒಪ್ಪಿದ್ರಿ?
ಯಾಕೆ ಒಪ್ಪಿದೆ ಅನ್ನೋದು because 3 criminal cases were pending. His uncle was in the verge of retirement. ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೂರಿಸ್ಕೊಂಡ್ರು. He had no other option. He agreed. And all these things, my lord, which requires evidence, that is the reason I filed an application for recalling.
Please come to the compromise petition. I will bereft of all those.
ಅಲ್ಲ ಅವ್ರು ಕಮೆಂಟ್ಸ್ ಮಾಡೋ ಮೊದಲು ಒಂದ್ ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತೀನಿ. ತಾವು ಸ್ವಲ್ಪ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ನೋಡಿ. ಅದು
ಅವರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಬಿಡಿ.
ಅದನ್ನೇ ತೋರಿಸ್ತಾ ಇದೀನಿ.
ಆಯ್ತು.
Please come to page 61, my lords, in the petition. In that, please come to para 4. ಒಂದನೇ ಪ್ರತಿವಾದಿ, your lordships have that, my lords.
ನೀಡಬೇಕಾದ 1,90,00,000.
ಒಂದು ಅರಂದು ರೂಪಾಯಿ 20 ಲಕ್ಷಗಳು ಸೋ ಅಂಡ್ ಸೋ ಡಿಡಿ ಸಂಖ್ಯೆ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ಕುವೆಂಪು ನಗರ ಮೈಸೂರು ಇವರ ಮೂಲಕ ಪಾವತಿಸಿದ್ದು. ಅಂಡರ್ ದ ಕಾಂಪ್ರಮೈಸ್ he pays 20 lakhs. So part settlement, there is part performance of the compromise. ಉಳಿದ ಹಣವನ್ನು ದಿನಾಂಕ 25/22 ರೂಪಾಯಿ 20 ಲಕ್ಷಗಳು ಡಿಡಿ ಮೂಲಕವಾಗಿ ಪಾವತಿಸಲು ಸಮ್ಮತಿಸಿದ್ದು. ಉಳಿದ ಬಾಕಿ ಹಣ 1,50,00,000 ಮಾರ್ಚ್ ತಿಂಗಳು 18ನೇ ತಾರೀಕು 55 ಲಕ್ಷ ಡಿಡಿ ಮೂಲಕ, ನಂತರ ಏಪ್ರಿಲ್ ತಿಂಗಳು 18ನೇ ತಾರೀಕು
40 ಲಕ್ಷ ನಗದು ರೂಪದಲ್ಲಿ ಪಾವತಿಸಲು ಸಮ್ಮತಿ ಸೂಚಿಸುತ್ತದೆ.
Then my lords,
ಈಗ ಇದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಇದರಲ್ಲಿ
20 lakhs he pays. Then my lords, when the settlement then I file execution in 2023. Please see the compromise. Award is at page 63 and the compromise at page 62 only. Please come to page 8, clause 8, my lords, before the award. ಈ ರಾಜಿ ಒಪ್ಪಂದ ಪತ್ರಕ್ಕೆ ಬೇರೆ ಯಾರ್ದೋ ಆಗಲಿ ಯಾವುದೇ ರೀತಿ signed by councils, signed by parties. Now the award is passed at Lok Adalat on page 63. In that, please come to page 64. In the presence, second parallel, in the presence of councils, and counsel for the defendant, the petitioner was C. Nagaraju. Your lordships have that.
Yes, I have seen. Yes.
After this, I sue out an execution in 2023. An order of attachment is passed. He appears in 23. Execution goes on. Then he comes before this court seeking a stay on the execution because an arrest warrant is issued.
ಅದು ಸ್ಟೇ ಆಯ್ತಾ?
ಅದಾದ್ಮೇಲೆ this honorable court directed him, we have filed along with our IA for stay, vacating stay, IA for vacating stay ಅಲ್ಲಿ. This honorable court directed him to deposit 50 lakhs in the executing court, and the execution was directed to be disposed of at an early stage. Your lordship may kindly come to page 6 of my vacating stay application.
Arrest warrant challenge ಮಾಡಿದ್ರಾ?
Arrest challenge ಮಾಡಿ.
That was pursuant to the execution. Now, please see page 4, my lord, sir.
I'm there.
Yes. So after this, he files a review petition after 3 years before the trial court seeking review of the compromise. And the allegation made is, please see the allegation what he now makes. Please come to page 9 of his petition, para 6. About 4th line from bottom, 4th line in para 6, my lords. 5th line. The respondent, in collusion with the then police official and advocate Krishna, who is no more. Some advocate is brought in now, who is no more. So we can't even question. There the advocate who appeared is somebody else. Now put a blame on some other advocate. And my learned friend goes on saying, I had filed criminal cases, not a single criminal case filed by me. What he's trying to say is he has duped several people. They have filed criminal cases against him. How much this kind of a award after 3 years?
Allah, Narayan Swami yaru?
Krishna.
Narayan Swami is the person who introduced the plaintiff.
His uncle.
Government servant yaru?
He is government servant. Narayan Swami is government servant.
Your uncle. What officer?
He is an executive engineer.
Which PWD?
PWD.
Public work ತುಂಬಾ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅನ್ನೋದಕ್ಕೆ ಆರ್ಡರ್ 23 ರೂಲ್ ಪಿಟಿಷನ್ ತಾವು ಸ್ವಲ್ಪ ನೋಡಿ ಇದರಲ್ಲಿ
ತೊಂದರೆ ಇಲ್ಲ.
Award, my lords, now the award is
ಈಗ
there.
why are you before the court? Lok Adalat ಅಲ್ವಾ? The court has rejected your
review petition on the ground that it is covered by Bhargavi construction.
Anything else? ಅಷ್ಟೇ ಅಲ್ವಾ? ಡಿಸ್ಮಿಸ್ ಮಾಡುವ. ಇದು ಎಂತ ಉಂಟು ಇದರಲ್ಲಿ? ಎಲ್ಲ ಐಸ್ ವೈಡ್ ಓಪನ್ ಎಲ್ಲ ಆಗಿ ಈಗ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬಂದಾಗ ಡಿಟ್ಯಾಚ್ಮೆಂಟ್ ಫ್ರಮ್ ಕಾಂಪ್ರಮೈಸ್.
ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಮಲ್ಟಿಪಲ್ ಕೇಸಸ್ ಹಾಕಿದ್ದಾರೆ. He was not able to contest anything.
That doesn't mean that you raise this. The petitioner is before this court calling in question an order of the concerned court dated 9/7/2025 rejecting review petition in review petition 1 of 2025 seeking recall of a compromise that was entered into in OS 44 of 2021. The heard the learned counsel are Nagendra Nayak appearing for the petitioner, learned senior counsel K. Panindra representing the respondent. Facts in brief germane are as follows. A memorandum of understanding is said to have been entered into between New Excellent Solara.
Now excellent.
Oh, excellence ಹೋಗ್ಬಿಟ್ಟಿದೆ. The entered into between Excellent Solar and the respondent to implement a particular project, drawing up certain terms and conditions. The dispute arose between the two, which led the respondent to institute a recovery suit in commercial OS, money recovery suit in commercial OS 44 of 2021 before the concerned court seeking recovery of 2 crore 36 lakhs so and so. Synopsis. In the said suit, a compromise is entered into between the parties on 12/3/2022. On 12/3/2022, the compromise is noted and the matter is referred to the Lok Adalat. Finally, the issue gets culminated before the Lok Adalat, recording the compromise and closing the proceedings. This happens in the year 2022. The petitioner does not honor the compromise or partially honors the compromise by paying 20 lakhs, the first chunk that was agreed on. Therefore, the respondent institutes execution proceedings. In the execution proceedings, an attachment warrant is issued. In the year 2023, the petitioner then approaches this court in writ petition 10908 of 2024. The court disposes, a coordinate bench disposed the petition by the following order.
Attachment and arrest.
Arrest warrant, attachment, arrest warrant.
Subsequent arrest.
So and so. The petitioner then files an application before the concerned court under Art 23 Rule 3, alleging that the compromise entered into was a fraud or out of coercion, and therefore the compromise order of the year 2022 should be recalled, having filed the said application 3 years after the compromise. The compromise entered into between the parties, the memo, the compromise?
61, page 61.
Reads as follows. Page 61, 62. Noticing the said compromise, the concerned court directs drawing up of a decree as the compromise was posted before the Lok Adalat and before the Lok Adalat it is settled. The decree so directed to be drawn is as follows, page 64 to 66. The petitioner at no point in time sought to project that it was a fraud or coercion while signing on the documents with eyes wide open. Circumstances may have been manifold, but the petitioner has signed on the dotted lines of the compromise so as the counsels representing the petitioner. 3 years thereafter, when the arrest warrant was sought to be issued in the execution proceedings, or now when the attachment warrant is sought to be issued is before the court before the court contending that the recall application should have been allowed as the plea projected by the petitioner would require evidence. In the light of the judgment rendered by the
I have that 2018-13 SEC 480.
In the light of the compromise entered into between the parties and signed by the parties, the person the signatory who is wanting to breach the compromise cannot be seen to contend that it was a fraud long after the said settlement and having proceeded further in the, having participated in the proceedings that have progressed in the execution and partially complying with the compromise, as 20 lakhs is paid in terms of the compromise. If it were to be a fraud, according to the learned counsel appearing for the petitioner ought not to have partially complied with the compromise and then projected plea of fraud 3 years later. Therefore, finding no merit to entertain the petition or any warrant to interfere with the order that is passed, petition stands rejected.
41.
This petition is against the orders passed by the trial court to appoint a commissioner, my lords. Lords, on an earlier occasion.
Oh, this is my order.
This is
Yes,
your
ma'am.
order, my lords. 26 rule 9 for appointment of court commissioner.
ಆಯ್ತು ಪಾಸ್ ಓವರ್ 5 ಗಂಟೆಗೆ ಆರ್ಡರ್ ಮಾಡೋಣ.
My lords,
Please.
ಇವತ್ತು ಸ್ವಲ್ಪ ಆಫ್ಟರ್ನೂನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಆಫ್ಟರ್ 2:30. ನಾಳೆ
Grateful.
ನಾಳೆ ಅದೇ ಟೈಮ್ಗೆ
ಆಗುತ್ತೆ.
To after 2:30. Great.
42.
Lords, I'm appealing to the petitioners. We filed this, we're filing a memo of withdrawal, my lords. We filed this petition seeking the direction of this honorable court to this honorable city civil court to permit the petitioners to file wakalat without an NOC wakalat nama. My lords,
ಕೊಟ್ಬಿಟ್ಟಿದಾರಾ?
my lords, yes, we've received the NOC wakalat nama, so we're filing a memo for it.
Learned counsel for the petitioner seeks leave of the court to withdraw the petition on account of redressal of the grievance of the petition. In terms of the memo, disposed as withdrawn.
Please.
43.
Case process has been paid, compliance has been done, copies are served. Documents freshly filed, my lord, today some documents.
PF ಅಂತ ಇದೆ.
ಅದು ಕಟ್ಟಿದೀವಿ sir. Process submission. Needful has been done in the morning when the list came.
The fourth occasion, the self-proclamation has been adjourning and obstructing by the petitioner
On
as well
merits,
as
my
the
lord.
respondent number
ಹೇಳಿ
2.
sir.
On merits, my lord, the matter pertains to an execution petition where I am the owner of the adjoining property bearing
What is the order
same
under
sur-
challenge?
my lord, the order challenged is the impugned order on IA number
Public
6.
auction.
My lord,
ಪ್ರಾಪರ್ಟಿ ನಿಮ್ದ?
ಇಲ್ಲ ನಮ್ ಪ್ರಾಪರ್ಟಿನ ಅಳತೆ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. All I am saying is if he wants to exclude it or if they want to include it, let a court commissioner be appointed. I made a similar submission before the trial court. That's what I would like to point out. This is the order sheet. My submission is on record.
ಮಾಡ್ಲಿ ಬಿಡಿ.
No, my
Let the
lord.
court commissioner be appointed,
The
let the demarcation be done. I have no
You
objection.
are not a party to the suit.
No, my lord, I have no objection. Let them sell the
No,
neighbor.
you are not a party to the
No,
suit.
my lord, but they want to involve my property.
No. Like, I have filed an objection statement along with the certified card. The petitioner himself did an JDR, my lord. The honorable
In which proceeding?
in OS number 449 of 1992, which is decreed in the year 1996, my lord.
That is not the subject matter of.
That is the very same subject matter in the whatever we are seeking for attached property to say.
Where is the order?
As it
ಓ,
is
ತುಂಬಾ
my-
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
Yes, my lord.
ನೋಡಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡ್ಬಿಡಿ.
No, they know very well about their judgments, my lord. They
But
filed an appeal before the
List
appellate
the
court.
matter on 10th in preliminary hearing.
Because of the, he himself and decreed judgment debtor.
10th in preliminary hearing. ಅವತ್ ಕ್ಲೋಸ್ ಮಾಡುವ.
I'll file the documents.
What on the registry?
IO may be extended.
The concerned, ಅದೇ deferring ತಾನೆ.
ಅದೇ ಅಷ್ಟೇ.
Fourth, every time, my lord, DHR getting 2 to 2.5 lakhs for proclamation costs in this case, my lord.
We will impose costs on him, don't worry. Yes.
My lord.
Oh, yeah,
For filing the petition, we will impose costs.
No, already stepped into the shoes of second respondent. He is trying to
We are
protect
not
the right
the
of
JDR.
JDR.
I just want to look into the papers and then come. That's all.
Kindly extend the interim order.
ಅದಾಯ್ತು.
44.
Respondents. My lord, the last date your lordships had directed me to serve and summons. ಆಮೇಲೆ complaints ಕೊಟ್ಟಿದ್ದೀನಿ.
of the compliance of the interim order has been done by under 39.
Lords, trial court has not granted him ex parte order. My lords have granted interim order. I have no objection if that is continued for a period of 2 weeks so that I can file my. Please.
The petitioner is before this court.
ಅವರು ಮಂಡೇಗೆ ಹಾಕಿಸ್ತೀನಿ ಅಂದ್ರು, ಅದಕ್ಕೆ ನಾನು ಸುಮ್ಮನೆ ಇದ್ದೆ. ಇವಾಗ ನೋಡಿದ್ರೆ ಹೇಳೇ ಬಿಟ್ರು ಅವರು.
ಅಲ್ಲ ಮಂಡೇ ಆದ್ರೂ ಅದೇನೇ ಆಗೋದು.
ಅದೇ ಆಗೋದು, ಮಂಡೇವರೆಗೂ ಇದ್ದಿದ್ರೆ ಆಗಿರೋದು ಅಂತ ನಾನು ಅನ್ಕೊಂಡೆ.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಅವತ್ತಾಗದು ಇವತ್ತೇ ಆಗ್ಲಿ, ಇವತ್ತಾಗದು ಈಗಲೇ ಆಗ್ಲಿ. Yes. The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff institute suit in OS 5912 of 2025 injunction, seeking injunction against the defendants. The concerned court only issues emergent notice, does not grant an ex parte injunction order as was sought for in the application of Order 39 Rule 1 and 2. Therefore, the petitioner is before this court. This court had granted an interim order which reads as follows. The counsel for the respondent is now represented, and both the counsel for the respondent and the petitioner in unison would submit that the concerned court be directed to dispose the application under Order 39 Rule 1 and 2, which is pending consideration. Next para. In the light of the said submission and the subsistence of the interim order, I deem it appropriate to continue the same for a period of 4 weeks from the date of receipt of the copy of this order.
Request for some 8 weeks, my lord, because they have not yet entered appearance.
My lords, I will enter appearance on 9th. My lords,
ninth ಇದೆ. ಆಮೇಲೆ I don't know what is their defense is. Based on that, I may have to amend my plaint also. That is what I'm saying.
That's a different. For within 4 weeks from the date of receipt of the copy of the order in accordance with law. The learned counsel P.N. Rajeshwar undertakes to enter appearance for the defendant in the said suit. The undertaking is placed on record. In the for the aforesaid reasons, the following order disposed. The interim order subsisting would continue for a period of 4 weeks. The concerned court is directed to hear the parties, dispose the application of Order 39 Rule 1 and 2 within an outer limit of 4 weeks, if not earlier, in accordance.
Great, please. From the date of receipt of the order.
Yes. Oh.
4 weeks.
Appear for the petitioner in this case.
Non-compliance of OO.
No, the office objection is with regard to parties in the case. Can I just take, my lord, first to the facts, my lord?
The office objections can sambandha.
Office objection is related to that.
Oh, related.
At the end, my lord, kindly see, the issue is, if my lord sees the cause title, we've named 2 Yatishas as respondents 1 and 2. It's actually the same person. But what happened, my lord, before the court below, we have described him wrongly. In the sense, we have described him as son of Sarojamma.
Yeah, urgency, yeah.
Oh, the interim order has been vacated by the court.
Vacated?
My lord,
39 for application?
No application. The court suspends it on the ground that Innovabandu, they file an application under Order 1 Rule 10 and say, no, you filed the suit against a wrong person, against a dead person. Therefore, suit is not properly laid. My lord, what has happened is, my lord,
where's the cause title in the suit?
My lord, cause title in the suit, my lord, suit is at page 169. The cause title, my lord, is at page 170.
ಯಾರು ಯತೀಶ್ ಯಾರು?
Yatish is the, my lord,
ಇವರು ಇಲ್ವಾ ಈಗ?
ಇಲ್ಲ ಇದಾರೆ. My lord, the person came to our place, tried to barge into the place, painted our boards black, etc. But my lord, because my lord, after we purchased this, my lord, I'll give my lord a brief background. My lord, petitioner is a school. We purchased a piece of property in about 26,000 square feet for the purpose of the school in 2022. And my lord, our vendors in title had purchased this property in 2018 from members of a joint family. My lord, all but 2 or 3 people of them did not join in the execution of their sale deeds. And what we did not know, my lord, was that there is an FDP proceedings that was pending pursuant to a partition. So now, my lord, after we have come to know of this, we have become parties to that FDP, and my lord, we are seeking equitable distribution and therefore, my lord, get our share allotted to us. Now, my lord, what has happened is on 10th of July, these people come to this place, break open the gate, paint the boards black, and my lord, attempt to barge into the property.
Who people?
My lord, this gentleman called Yatish.
How do you know?
Because, my lord, we have video footings of it. We have produced that also.
How do you know he is Yatish?
My lord, I know that he is Yatish because we knew, but my lord, we thought he is Yatish, son of one Sarojamma, who is also a party to the FDP. It appears that he is Yatish, but he is now, my lord, he is part of his parentage is different, but he is part of the same FDP, but the same Yatish. Now, my lord, kindly see, if my lord kindly sees page number 265, we will see this Yatish has now on, my lord, on 1/8/2025, Yatish files a police complaint against us. And there he describes himself, may not kindly see, he describes himself as
Which page is the order vacating the interim order? Or
order
suspending
vacating
it?
the interim order at page 31.
Who appears before the court?
My lord, a third person, one lady called Renuka appears, files an impleading application and then says, this Yatish is dead, therefore the suit is wrongly filed. So, my lord, the submission that we would, and we have now filed an application, my lord, to correct the father's name and address of this Yatish.
Where? Here?
In the court below. In the court below. In the meanwhile, my lord, the contention is that the suit is filed against a dead person and therefore the suit is not maintainable. My respectful submission that contention is not correct. May I just pass on the judgment of the Honorable Supreme Court?
What for?
On the ground, my lord, that when a person is wrongly described, it's a case of mere misdescription. It does not affect the validity.
Is it not too rudimentary?
My lord, it would seem so.
Yes.
So, my lord, on this ground, the interim order is not continued.
Yes. The petitioner is before this court calling in question an order of the concerned court dated 14/8/2025 passed 14/8/2025 in OS 5089 of 2025. The petitioner is an educational institution, purchases certain landed property in the year 2022 from their vendors who had then partition,
Who had in turn purchased it from the
who had purchased it from another joint family property, joint family members in the year 2018. Owing to certain disturbance by one Yatish, the petitioners file a suit, this said suit. In the said suit, an injunction is granted. On the next date of listing of the suit, a stranger appears before the court and files an application under Order 1 Rule 10, submits that the suit is instituted against a dead person, Yatish, against whom it was instituted was no more. Therefore, the concerned court vacates or suspends.
Does not extend the interim order.
The concerned court refuses to vacate the interim order on the score that the suit is instituted against a dead person. The learned senior counsel Arun Kumar, appearing for the petitioner, submits that this very Yatish registers a police complaint against the school
on
on
1/8/25.
On 1/8/2025, alleging
alleging that we are trying to put up construction in this premises and subject matter of FTP, etc.
All right. So and so. And the said Yatish is also a party to the final decree proceedings. The learned senior counsel submits that the petitioners were not aware of the pendency of the FDP and they have impleaded themselves in the FDP as well. In the light of the aforesaid circumstance, mere non-description, erroneous description of the father of a defendant or the parentage of the defendant cannot lead the court to not to extend the interim order which had been granted to preserve status quo. Therefore, I deem it appropriate to restore the order dated 17/7/2025 and stay the order dated 4/8/2024. 14/8/2024 till the next date of hearing.
Lord, address also is wrong. Not only the name, his address also was wrong.
Parentage and residence. Yes.
Grateful.
46.
In terms of
Hearing on IA 47.
47, my lord. For this
State.
please, my lord. This is, my lord. See,
review petition.
Please, my lord.
Karana.
Because, my lord, the covered judgment, my lordship, that is under TMC. Now, present petition is, my lordship, under BM Bangalore Mysore infrastructure corridor area.
ಯಾರ್ದು ಆರ್ಡರ್?
ನಿಮ್ದೆ. ಅದು ಕವರ್ ಮಾಡಿರೋದು TMC ಅಂಡರ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಅವರು
ರೆಡ್ಡಿ ಗನ್ ಹೌಸ್ ಪ್ರವೀಣ್ ಅಪಿಯರ್ ಆಗಿದ್ದು.
Samanth Nayak.
ಪ್ರವೀಣ್ ಸರ್ವ್ ಮಾಡಿ.
That is and the respondent ಅದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕಮಿಷನರ್ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ರೆಡ್ಡಿ ಗನ್ ಹೌಸ್ ಆಗ್ಬೇಕು.
ರೆಡ್ಡಿ ಗನ್ ಹೌಸಾ?
ಪ್ಲೀಸ್ ಮೊದಲು ರೆಡ್ಡಿ ಗನ್ ಹೌಸ್.
ಏನ್ ಡಾಬಾನ ಇದು?
ಪೆಟ್ರೋಲ್ ಬಂಕ್.
ಪೆಟ್ರೋಲ್ ಬಂಕ್. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಪ್ರವೀಣ್ಗೆ. Counsel for
27 days delay is there.
Condoned for the reason so and so. Petitioner to serve on Counsel S. Praveen, who had appeared for the petitioner in the petition, review of which is sought in the subject petition. List on 19th.
48.
For the petition.
ಎಲ್ಲಿ ನಿಮ್ಮ ಪ್ರತಿವಾದಿ?
ಪ್ರತಿವಾದಿ ಬಂದಿಲ್ಲ. ಅದ್ರಲ್ಲಿ ಮೇನ್ ಇಂಪಾರ್ಟೆಂಟ್ ಇವಲ್ಲ ಆರ್ಸಿ
ಪ್ರತಿವಾದಿ
48.1
ಅಲ್ವಾ?
ಅದು. ಅವ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ, ಬರ್ತಿದ್ರು ಲಾಸ್ಟ್
ಬರ್ತಾ
ಟೈಮ್.
ಇರ್ತಾರೆ.
ಅವರೇ ವಕಾಲತ್ ಗೊತ್ತಿಲ್ಲ. ಅವರೇ ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು.
ಅಭಿನಯ್ ವೈಟಿ. ಏನ್ ವಾಟ್ಸ್ ದಿ ಸೂಟ್ ಫಾರ್?
ಶೂಟ್ ಎಲ್ಲ we are not going to question the shoot you will answer.
You are not pursuing the suit?
ಇಲ್ಲ. I have challenged the local bodies order you will answer. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ 48.1 ನಲ್ಲಿ.
ಹೇಳಿ.
That is very important you will answer.
ಅಲ್ಲ ಆ ಕಡೆ ಯಾಕೆ ನೋಡ್ತಾ ಇದ್ದೀರಾ? ಭಯ ಪಡಬೇಡಿ.
ಬಂದ್ರೇನೋ ಅಂತಾರೆ.
ಪರವಾಗಿಲ್ಲ ನೀವು ಹೇಳಿ.
Your lordship, what happens to your lordship in this case is all the relevant documents, revenue documents stands in the name of the petitioner in 48.1 documents you will ask. And also there is permission from the Gram Panchayat to construct a house. You will also kindly be see the permission has been granted.
ಯಾರಿಗೆ? ನಿಮಗ?
ಹೌದು, petitioner.
ಆಮೇಲೆ?
ಹೌದು. ಕೊಟ್ಟಿದ್ದಾರೆ. Upon challenging the license granted by the Gram Panchayat, he filed an appeal before the Talak Panchayat. Talak Panchayat rejected the appeal. Then he entered into respondent number 1, Jilla Panchayat. Jinda Panchayat, without being considering all these documents, appeal has been allowed in favor of the respondent number 4. Upon the consideration of the order of the respondent number 1, Jilla Panchayat, the trial court pass an order in original suit you will ask. In original suit.
ಅದು ಬರ್ಲಿ ತಾಳಿ.
ಹೌದು. Stay there.
Password.
I have a matter. Next week.
No.
ಅಲ್ಲ next week.
Entry ಮಾಡ್ರೆ ತಗೊಂಡ್ಮೇಲೆ ರೆಡಿ ಇರ್ಬೇಕು.
ಅಲ್ಲ ರೆಡಿ ಇದೀವಿ ಬಟ್
vacating stay ಇದೆ. I will not adjourn it. Pass over.
49.
For respondent.
Here I sought to produce secondary evidence of a partnership deed copied out by a chartered accountant who was representing the firm. Last 25/7, your lordship passed an order to file the affidavit.
ಓ ಇದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಮೋನ್ 50 ವರ್ಷ ಹಿಂದೆ.
What happens is the person who copied it out is dead. His partner, who has also appeared for the partnership firm, filing the affidavit, my lord.
I need to see this document. There is how it right now.
My lord, the whole point is it's a probative value of that evidence. Tomorrow the court.
You want to mark this?
I want to mark the partnership, and we have got a host of other documents which show the existence of the partnership.
Suit for?
Partition of my share, including the share in the partnership business.
Suit
And D1 has now made an application to transfer.
Look into this.
Yes, I'll see.
You want to counter it? Counter it.
Please, your lordship.
Heard the learned senior counsel Srivatsa appearing for the petitioner. In terms of the order dated 25/7/2024, the petitioner files an affidavit. The learned counsel, Srimati Leela Devadiga, seeks
File objection.
10 days, 1 week's time. List on 12th. Next.
50.
Disposal.
Respondent has filed the application.
ಯಾಕೆ ಸರ್?
Lord,
Who has filed disposal?
I filed the application
Why?
for the disposal. Lord, that's challenging the non-consideration of IA.
What IA?
Miscellaneous appeal filed by them. Let it be considered, my lord, within the spirit.
That
within time frame, let it.
ಅಷ್ಟೇನಾ ಅಷ್ಟಕ್ಕೆ ಬಂದಿದೆಯಾ ಇಲ್ಲಿ?
Stick the file.
Prayer B, my lord. Prayer is concerned, my lord, so far as the application filed by the defendant.
ರೆಸ್ಟೋರ್ ಅದೆಲ್ಲ ಅಲ್ಲೇ.
My application for.
Application is still pending?
That application is still pending.
Thank you, sir.
May I produce the order sheet, my lord?
No
Lordship,
problem.
I kindly see page.
4 weeks I will direct the court to consider.
148.
The petitioner is before this court seeking the following prayer.
There is an interim order passed by this honorable court in the.
What interim orders?
That the interim order date.
ಆಯ್ತು 4 weeks continue
That-
ಮಾಡೋಣ.
Please.
The petitioner is before this court seeking the following prayer. Owing to the plea of the petitioner, the coordinate bench of this court had granted an interim order which reads as follows on 25/3/2024. The application seeking restoration of the proceeding in the miscellaneous appeal.
Not the restoration.
ಮತ್ತೆ?
IA1 for stay of the order passed by the trial court in allowing the application filed by the defendants vacate.
ಈ
the order of
MA1
temporary injunction.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲ.
Please.
An application in an application is filed seeking injunction, is it?
Stay of the.
Seeking stay of the order passed by the civil court in OS 177 of 2021 is preferred in MA 1 of 2024. The proceedings are still pending before the concerned court and the application is yet to be adjudicated upon. In the interregnum, the petitioner approaches this court and the aforesaid order is passed. In the light of the pendency of the application before the first appellate court, I deem it appropriate to dispose the petition with a direction to the concerned court to dispose the application filed in MA 1 of 2024. One other.
IA1, my lord.
IA1 in MA?
1 bar.
Annexure or page 129.
MA number 1 bar.
MA 1 of 2024 with an outer limit of 4 weeks. In the light of the interim order subsisting, the same shall continue till the period of 4 weeks. The parties are at liberty to seek appropriate orders before the concerned court. All contentions remain open, ordered accordingly.
51.
Before the petition in this case. Lord, the
Lord, I
order.
appear for respondent number 1. Lord, I filed an application, my lord, seeking for vacating of interim order dated.
Aditya sir, come on, merit.
Please, ma'am.
Yes, Shanti.
May I make submission? Lord, survey number 8, 2 acre 27 guntas was, if your lordship may kindly turn to my lord, page 25, my lord.
Where is the compromise petition?
Compromise petition is at my lord,
Annexure B, page 31.
Page 31.
31.
2007 na?
Please, my lord. May I just narrate the facts? my lord?
ಹೇಳಿ sir.
Please, my lord. Lot 7 number 8 of 2 acres 27 guntas was cultivated by one Madhuriga, my lord. Your lordship would get that, my lord, at page 25. Page 25, my lord, to an extent of 2 acre 27 guntas out of 5 acre 37 guntas, the inam abolition, my lord, under the inam abolition, his rights were conferred. It was conferred to Madhuriga. Please, my lord. Madhuriga, my lord, sold 1 acre 10 guntas in favor of Chikkamuniappa. The other 1 acre, my lord, he is sold to Chikkasonnamma. So total 2 acres 20 guntas, 2 acre. Lord, 1 acre 10 guntas was sold to Chikkamuniappa. Chikkasonnamma also sold the 1 acre in favor of Chikkamuniappa. So therefore, my lord, 2 acre 10 guntas totally belong to Chikkamuniappa. Lord, in the partition in the year 1984 between the children of Dodamuniappa, Chikkamuniappa, Siddappa, Munisamappa, all those partitioned the properties. In that 2 acre 27 guntas, even though it was a family property which was in the name of Chikkamuniappa, was fallen to the share of Dodamuniappa. Please, my lord, that your lordship would get it at page 66, compromise petition.
ನೀವು ಈ ಕಡೆ ಬಂದ್ಬಿಡಿ ಗವರ್ಮೆಂಟ್ ಕಡೆ ಇರಿ ಎಸ್
Lord, if your lordship could kindly turn to my lord, page 31, annexure B, the children of Madhuriga, who was the original grantee, my lord, and the children of Chikkamuniappa the children of Madhurika filed a suit against children of Chikkamuniappa. Compromised the suit. In the partition, these properties was fallen to my share without my knowledge. My lord, the suit was filed in the 2007. And if your lordship could kindly come
The
to
properties that fell to your share was a suit scheduled property in 2007.
Please, my lord.
You were not a party.
No, my lord.
All right. Yes.
My lord, thereafter, my lord, I filed a suit.
You filed a suit.
I'm sorry, the Doddamuniappa. Children of Doddamuniappa filed a suit in page 110, my lord, annexure P, to declare that the compromise decree dated entered between the children of Madhuriga and children of Chikkamuniappa was not binding on the children of Doddamuniappa.
Date ಹೇಳಿ, compromise date ಹೇಳಿ.
Compromise date, my lord, is page 66, 12/11/2007.
In OS?
In OS number 1036, page 33, my lord.
Not Lok Adalat.
Not local.
Before the court.
Please.
All right. 1036 of 2007. You are not a party there.
I was not a party.
Where is the suit schedule property in OS 1036 of 2007?
My lord, you'll get it at page 29, my lord.
ಇಲ್ಲ ಇದ್ಯಾವುದು 116 ಅಲ್ಲಿರೋದು?
Please, my lord.
116.
That is the suit which the children of Doddamuniappa filed.
ಇಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದು ಯಾವ ಸೂಟ್ ಅಲ್ಲಿ?
1036 ಅಲ್ಲಿ.
ಅದರದ್ದು ಕಾಸ್ಟ್ ಇದು ಸೂಟ್ ಶೆಡ್ಯೂಲ್
ಅದೇ
ಪ್ರಾಪರ್ಟಿ.
ಇಲ್ಲಿ ಪೇಜ್ 29.
ನಿಮ್ಮ ಶೇರಿಗೆ ಬಂದಿದ್ದು ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ.
My lord, we'll get it at, my lord, page 66, page 66, Vibhaga Patra. In this, page 68, A schedule property, my lord, fallen to the share of Doddamuniappa.
ಎಲ್ಲಿದೆ ಶೆಡ್ಯೂಲ್ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? 68 ಅಲ್ಲಿ ಇದೆಯಾ?
69.
ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ದೊಡ್ಡಮನಿಯಪ್ಪ. ಎಲ್ಲಿದೆ ಅದು ಶೆಡ್ಯೂಲ್?
69, page 69, last but one column. I'm sorry, no, that's not the one.
ಇಲ್ಲ ಇದಲ್ಲ, ದೊಡ್ಡಮನಿಯಪ್ಪ ಅದು ಬೇರೆ ಇದೆ.
That's not clear, my lord. It's there in the certificate copy.
ಎ ದೊಡ್ಡಮನಿಯಪ್ಪ ಇಲ್ಲಿದೆ 72.
Serial number 5. This was fallen to the share of Doddamuniappa.
All right.
Please, my lord.
ಏನಿದೆ?
No, this is it was not clear, my lord. Therefore, he produced the certificate copy.
All right.
The children of Doddamuniappa filed a
ಆಯ್ತು,
suit.
ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು. ಯಾವಾಗ? 2007 ಅಲ್ಲಿ.
2007.
When did you come to know of it?
My lord, compromise was dated.
ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಡೇಟೆಡ್ ಏನು?
Please.
2007. ಅಲ್ಲಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಡೇಟೆಡ್ ಏನು?
12/11/2007. Lord, coming to know that, Lord, we filed a suit on 18/12/2007.
ಅವಾಗ್ಲೇ ಹಾಕಿದ್ರ?
ಅವಾಗ್ಲೇ ಹಾಕಿದ್ರು.
Oh, you filed a separate suit
We filed a separate
to
suit.
recall the compromise.
Please,
Go before the same court.
please.
Lord, in fact, that suit is dismissed. Presently, my lord, RFA is pending before this honorable court. So this
What is
petition
right
will not
cannot
serve.
be taken away. Prosecuting before the wrong forum. In 23(3)(a,
Please.
ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಲಿ.
Please.
Let the issue be decided. Judgment ಅಲ್ಲಿ. The petitioner is before this court seeking the following prayer. Heard the counsel H. Shanti Bhushan appearing for the petitioner and I forget your name.
Lord, Yashwant.
Yeah, Yashwant. Yashwant representing counsel K.V. Narasimhan. The issue in the list revolves around a narrow compass at this juncture. The petitioner is not a party in a particular suit instituted in OS 1036 of 2007. In the said suit, the suit schedule property described is as follows. Learned counsel for the petitioner, Shanti Bhushan, takes this court through the documents appended to the petition to prima facie demonstrate that the suit schedule property of the OS 1036 of 2007 is the property belonging to the petitioner, which comes by way of a partition in the family. He would demonstrate it by placing reliance upon the schedule that fell to him in the partition. Though these are prima facie facts. The compromise was entered into between the parties in the suit OS 1036 of 2007 concerning the suit schedule property. The petitioner, coming to know of the compromise entered into of a property that belonged to him, immediately institutes a suit in OS 1185 of 2007.
In fact, it was the father of petitioner.
Father of the petitioner. All right. Father of the petitioner institutes a suit in OS 1185 of 2007. The concerned court, in terms of its order dated 20th December 2023, rejects the suit on the ground that the validity of the compromise cannot be challenged by filing a separate suit. The order of the concerned court would not. The order of the concerned court is in tune with law. The apex court.
Bhagavati Construction Center.
The apex court in 2018-13 SCC page 480 paragraph 31 to
36
has held as follows, para 31 to 36. In the light of the law as laid down by the apex court, admittedly a separate suit was not maintainable challenging a compromise decree. If the compromise decree on any ground or manifold circumstances had to be challenged, it ought to have been preferred before the same court which had recorded the compromise and closed the proceeding. In the light of the separate suit being filed which was not maintainable, the petitioner cannot be left without a remedy or high and dry. Therefore, while affirming the order passed by the concerned court, I reserve liberty to the petitioner to prefer an application under Order 23 Rule 3A before the same court which recorded the compromise.
Please.
Before the same court, my lord.
Same court, correct.
My lord, that OS, my lord,
My
which
lord,
is
he was not a party in that suit.
Correct. ಅದಕ್ಕೇನೆ ಹಾಕ್ಬೇಕು ಅಂತ.
No, my lord. He'll have to file an application to recall that order along with an impleading application.
Correct, sir. In accordance with law, ಅದನ್ನು ನಾನೇ ಹೇಳ್ಬೇಕು. The petitioner is at liberty to take steps to get himself into the suit and seek necessary orders at the hands of the court. Reserving such liberty, the petition stands disposed.
So one submission, my lord, 2012-2023, the dismissal of trial court is being challenged, my lord, in RFA which is pending before this honorable court. In RFA 79 of.
ಅದನ್ನು withdraw ಮಾಡಿ ಅಷ್ಟೇ.
Please.
That is for declaration for 2 acres. That is insofar as
Challenging the dismissal of the OS.
The learned counsel for the respondent submits that challenging the very order of dismissal impugned in the subject petition, RFA is preferred.
I am not preferred. These petitioners have not preferred.
ಹೇಳಿದೆ ಮತ್ತೆ ಇದನ್ನ ಅಲ್ಲ ಹಾಕಬಾರ್ದಷ್ಟೇ. So
sorry.
The learned counsel appearing for the respondent would at this juncture submit that that challenging the impugned order, an RFA is preferred and the same is pending. The learned counsel Shanti Bhushan submits that the petitioner has not preferred the said RFA. Be that as it may, the right of the party cannot be stifled just because he has prosecuted the petition before a wrong forum. More so in the light of the fact that without the petitioner being a party to the proceedings in 1036 of 2007, his property is allegedly compromised. Yes. Ordered accordingly. Yes. Closed.
To my lord, for the petitioner, I pray 1 week time. I will have to submit.
Vacating stay, sir.
Vacating stay ಇದೆ. ನಮ್ದು ಅವರು ಸಿಗ್ನೇಚರ್ ಅನ್ನ ಡಿನೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಕನೆಕ್ಟೆಡ್ petition that petitioner he was the attested witness to the will, in my will.
Hmm.
Now he says that it is not my signature, you have forged the signature.
Hmm.
So ಅದರದ್ದು ಅದೇ signature ಅನ್ನ ಬೇರೆ document ಅಲ್ಲಿ ಅವರು ಹಾಕಿದ್ರೆ ಅಂತ ಹೇಳೋದಕ್ಕೆ I will collect and submit.
Why are you
those
before the court?
documents.
Why are you before the court, sir?
No, they have filed this, earlier I have filed P and C 261/14.
GMRES ಯಾಕೆ?
P and C. We one CR
482 na?
probate petitioner ಗೆ
482 is tagged with this?
no, tagged 482 tagged. ಅಂದ್ರೆ ಅವರು Sukumar, he was the attested witness to the will. And the probate petitioner was allowed, and against that, the respondent number 1 filed RFA before this on the court, and RFA was remanded. ಇವಾಗ ಅವರು ಏನು ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸುಕುಮಾರ್ ದ ಅಟೆಸ್ಟೆಡ್ ವಿಟ್ನೆಸ್ ಆ ಸಿಗ್ನೇಚರ್ ಅನ್ನ ನೀವು ಫೋರ್ಜರಿ ಮಾಡಿದಿರಿ ಅಂತ. ಸೊ ಅದರ ಬಗ್ಗೆ ಅದೇ ಸೇಮ್ ಸಿಮಿಲರ್ ಸಿಗ್ನೇಚರ್ ಅವರು ಹಾಕಿದರೆ ಸಮ್ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳೋದಕ್ಕೆ I will obtain and I submit by next week on 12th.
ಇದು 2023 ಇದು ಸರ್.
ಅಲ್ಲ ಇದೇನು
ಇಲ್ಲಿವರೆಗೆ ಏನು obtain ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ obtain ಅಂದ್ರೆ ಇವರು ಬಂದು ಇವಾಗ ಹೇಳ್ತಾ ಇರೋದು. ನಾವು they are telling that.
ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಳ್ಳಿ ಅಲ್ಲ.
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಬಂದು ಹೇಳಿದಾರೆ. ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಬಂದು ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಂದ್ರೆ
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದೆ. ನಾನು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದೆ, ಅಡ್ಜರ್ನ್ ಮಾಡೋದೇ ಇಲ್ಲ.
2 days ಕೊಟ್ಟು.
No,
2 days.
Yes. Come on, merits. Yes. ಸ್ಟೇ ತಗೋಬೇಕಾದ್ರೆ ಇರೋ ಉತ್ಸಾಹ ಆಮೇಲೆ ಇರಬೇಕು.
ಅಲ್ಲ ಇದು
ಎಸ್.
ಸೊ ಮಧ್ಯಾಹ್ನ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ ಅದು ಹೇಳಿ ಮೆರಿಟ್ಸ್. ಹಂಗಾರೆ ಕೇಸ್ ಇಲ್ವಾ ಮೆರಿಟ್ಸ್ ಮೇಲೆ? ಮತ್ತೆ ಹೇಳಿ.
ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೇನೆ.
ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀರಾ? ಈಗಲೇ ಹೇಳಿ. ಮಧ್ಯಾಹ್ನ ಆಗೋಗಿದೆ. 12 o'clock ಆಗೋಯ್ತು.
ಈಗ ಅದು ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಆ ಸಿಗ್ನೇಚರ್ ಅನ್ನ ನಾನು ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀನಿ.
ಇದು ಇಂಡೈರೆಕ್ಟ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಪಾಸ್ ಓವರ್ ಅದು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ಗೊತ್ತಲ್ಲ.
ಇಲ್ಲ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ತಗೋಬಹುದು 2:30.
ಎಸ್ ವಿಘ್ನೇಶ್, ವಾಟ್ಸ್ ದ ಮ್ಯಾಟರ್? ಟೆಲ್ ಮಿ.
Short point is involved in this matter, my lord. There's a P&C petition, my lord, pending before the court immediate below. Wherein, my lord, my lord, respond number 1. Respond number 3 filed an impleading application before the court immediate below, my lord, that order has been passed, page number 36. Impleading application has been allowed. That application, my lord, that order, my lord, as held before this honorable court. My respectful submission before this honorable court is, my lord, that impleading application filed by the, my lord, some securitator, some bank, wherein, my lord, I don't need their support. At the most, my lord, the writ petition may be allowed. My lord, that, my lord, kindly come to the prayer which sought before this honorable court at page number 9. Pursuant to order passed, my lord, at page number 36. The suit pending before, my lord, filed by, my lord, the petitioner against me in the P&C proceedings.
ಯಾವ ಪಿಟಿಷನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
My lord, the first petition. WP number 17795. My lord, I nothing to do with the, my lord,
other one.
Quashing petition. Additionally, my lord, respond number 1. Respond number 3 is a securitator. He filed an impleading application before the, my lord, court immediate below, wherein court immediate below passed an order and allowed their impleading application. That is at, my lord, page number 36. Kindly come to, my lord, that document for a moment. I'll just point out, my lord, page number, my lord, 39. IA number 1 of 2024 filed by the proposed defendant under order 1 rule 10(2) section 1.
Who is the proposed defendant?
My lord, there is some, they are also appearing through, my lord, their counsel. They are the, my lord, securitator. They are, my lord, advance certain money to, my lord, to the, my lord, subject property. That my lord, I nothing to do with that. My lord, here, the what assailed before this honorable court is, my lord, the order passed by the, my lord, the court immediate below in respect of, my lord, impleading application. My lord, I don't have any problem, even, my lord, that writ petition is allowed also. My lord, I will justify, my lord, my title before the court immediate below. My lord, matter can be remanded to the court immediate below.
ಅಲ್ಲ ಅಲೋಡ್ ಅಂದ್ರೆ ಈ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಬೇಕು.
ಮಾಡಬಹುದು. ನನಗೆ I don't have objection. My lord, I don't need bank support to, my lord, justify my title in this.
Who is that impleading applicant?
Bank.
Bank.
ಹೌದು.
They are not necessary parties and they cannot implement.
Bank ಯಾಕೆ ಬರ್ಬೇಕು? You initiate other proceedings in other fora.
My lord, what had happened, my lord, earlier, my lord, in a pending suit, my lord, there summons me, my lord. That suit has been remitted, my lord. Thereafter, I file application, my lord. It may be allowed or not.
Only, my lord, only one indulgence I am seeking. In time, this matter pending from 2014, one of the other reason, my lord, matter is
6 months we will direct disposal. ಇದಕ್ಕೆ ಟೈಮ್ ಬೇಕಾಗಿತ್ತು.
In probate proceeding.
Probate proceeding ಬಗ್ಗೆ ನಾನು ಏನು ಮಾತಾಡಲ್ಲ.
They cannot implement as
ಅದ ಅವರೇ ಅಲೋ ಮಾಡ್ಲಿ ಅಂತ ಇದ್ದಾರೆ. ಇದಕ್ಕೆ ಟೈಮ್ ಮಧ್ಯಾಹ್ನ 1 ವಾರ.
ಇನ್ನು ಈಗ ಅರ್ಥ ಆಯ್ತು ನನಗೆ.
ಈಗ ಅರ್ಥ ಆಯ್ತಾ? ಅದು
ನನಗೇನಿಲ್ಲ.
It will go before the regular court. ಅದು delinked and posted before the regular. Interim order ಇದೆಯಾ ಅದರಲ್ಲಿ? ಹಾ ಸರ್. 50 dealing 52.1 post the matter before the bench having roster. 52 ಅಲ್ಲಿ ಆರ್ಡರ್ ಬರ್ಕೊಳ್ಳಿ. the petitioner institutes a suit. P&S na suit?
P&SC, earlier P&SC, it was converted into suit.
Converted to suit.
Suit.
Institutes a P&SC proceeding owing to the dispute therein. The P&SC proceeding is converted to OS 711 of 2023. The issue is not with regard to the merit of the matter. In the said suit, a secured creditor, the bank, files an application under Order 1, Rule 10, seeking which bank nimdu? Canara Bank. Canara Bank.
Savarda cooperative.
Savarda cooperative.
Nationalize ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ. Savarda Cooperative Bank files an application under Order 1, Rule 10, seeking to implead in a P&SC proceeding or the suit that is converted from a P&SC proceeding. The concerned court allows the application and permits the bank to come on record in a P&SC proceeding. The order of the concerned court on the face of it is illegal and contrary to law. The learned counsel appearing for the respondents would admit the fact. In that light, without delving deep into the veracity of the order, I deem it appropriate to set aside the said order as it is trite law that in a P&SC proceeding, which is no doubt converted into a suit, it is between the members of the family or the legal heirs. The bank cannot intrude into those proceedings. However, the bank would always have liberty to initiate such proceedings in accordance with law and not come into these proceedings. In that light, the petition deserves to succeed. The learned counsel appearing for the respondent submits that the case is languishing before the concerned court since 2014 as the P&SC is of the year 2014. In that light, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to dispose the subject suit in OS 711 of 2023 arising out of P&SC 261 of 2014 within an outer limit of 6 months from
10 months, sir. 10 months. I can witness.
3 months.
10.
6 months from the date of receipt of the copy of the order, if not earlier. All contentions remain open. Allu adjournment ಕೇಳ್ತಾ ಇದೆ. 6 months ಅಂದ್ರೆ 10 months. Yes.
Witness ಗಳನ್ನ ಕೆಲವು.
ಅದು ಹ್ಯಾಬಿಟ್.
ಅಲ್ಲ ಕೆಲವು ವಿಟ್ನೆಸ್.
ಆಮೇಲೆ yes.
52.1 entry order ma'am.
ಅದರಲ್ಲಿ ಡೀಲಿಂಗ್ ಅಲ್ಲಿ
Lord,
yes.
Respondent 1 has filed the vacating.
ಹೇಳಿ
Filed the vacating the stay application, madam.
Madam,
The respondent number, suit for partition and separate possession, madam.
Order challenged.
Order challenged, my lord, order 41, rule 5, my lord. I filed the RA 37 of 2024, my lord. Order 41, rule 5 challenged, my lord.
ಏನ ರಿಸೀವರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಳಕ್
ಅಲ್ಲ
ಮತ್ತೆ
stay of the execution.
ಸ್ಟೇ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ವೈ
Why, my lord, in the FDP proceeding.
ವೈ ಅಂದ್ರೆ ನೀವು ವೈ ಅಂತ ಕೇಳಿದ್ರೆ
My lord, I am extremely apologetic.
ಹೇಳಿ ಸರ್ ಪರವಾಗಿಲ್ಲ.
In the FDP proceedings, my lord, court commissioner report is challenged, my lord. Basing on that, I filed the RA number 37/2024 along with the interim application for stay of the proceedings and also stay of the execution. They have filed the execution proceedings on the basis of the decree in OS 73 of 2010, my lord.
ಆ ಡಿಗ್ರಿ ಏನಾಯ್ತು?
ಆ ಡಿಗ್ರಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಅದರಲ್ಲಿ 1/6 share allotted to the respondent.
Decree has become final?
My lord, what happened thereafter, my lord? In that decree, my lord, the respondent number 1 not made the mother-in-law as the party, my lord.
Oh.
Subsequently, mother-in-law filed the OS number 12 of 2013, my lord. In that proceedings, my lord, the shares of the parties is modified. 17 upon 16th share is allotted, my lord. Challenging the same, my lord, both respondent number 1 and respondent number 4 preferred a RA number 3 and RA number 4, my lord. In RA number 3 and 4, confirmed the judgment of the OS number 12/2013, my lord. In the said, the respondent number 1, modified judgment ಪ್ರಕಾರ ಅವರು FDP ಫೈಲ್ ಮಾಡಿಲ್ಲ. ಅವರು 1/6 ಶೇರ್
ಆಯ್ತು, ಈಗ ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ನಮ್ದು ಅವ್ರು ಮಾಡಿಫೈಡ್ ಶೇರ್ ಪ್ರಕಾರ ಮಾಡ್ಬೋದು ಒಂದು. ಎರಡನೇದು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ನಾವು FDP ಫೈಲ್ ಇದು RA ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಅದ್ರಲ್ಲಿ
ಆಗೋವರೆಗೂ FDP ಆಗ್ಬಾರ್ದು ಅಂತ.
ಎಸ್ ಮೇಡಮ್ ಅಷ್ಟೇ.
ಮಿಲಾಡ್ ಪೇಜ್ 66 ಮಿಲಾಡ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಹಳೆ OS ಮೇಲ್ ಅಂತ. ಆಕ್ಚುಲಿ ಇಟ್ ಇಸ್ ಬೀನ್ ಮಾಡಿಫೈಡ್ 17/60th ಶೇರ್ ಅಂಡ್ 7/60th ಶೇರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮದರ್ ಇನ್ ಲಾ ಮತ್ತೆ ನಂದು
ಆಯ್ತು, ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. No, he submitted about the modified decree. All right, ಅದ್ರ ಮೇಲೆ RA ಹಾಕಿದಾರಾ?
ಮಾಡಿಫೈಡ್ ಡಿಗ್ರಿ ಮೇಲೆ RA ಅಲ್ಲ ಸರ್, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟು ಕೇಳಿದ್ದಾರೆ. ಮಾಡಿಫೈಡ್ ಡಿಗ್ರಿ ಮೇಲೇನು ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಅದನ್ನೇ ಕೇಳಿ, ಮಾಡಿಫೈಡ್ ಡಿಗ್ರಿ ಮೇಲೆ RA ಹಾಕಿದ್ದಾರೆ, ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ. This is the third round of litigation, my lord. 2009, I'm a widow. My husband's brother.
Don't go into the facts, merits.
Commissioner report page 82, my lord. Petition alli clear ಆಗಿ ಹೇಳಿದ್ದಾರೆ. They have not raised any
Now
objections.
commissioner report is accepted, everything is acted upon. ಆದ್ರೆ RA ಏನಾಗಬೇಕು?
Just to protract, they have been filing this.
Protract ಇಲ್ಲ, will direct closure.
3 months, my lord, please. 2009 ಇಂದ ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ.
ಅಲ್ಲ, one interesting aspect, my lord.
Interesting?
Yes, my lord.
ಇದೆಲ್ಲ ಕೇಳಿದ್ ನಂದು partition ಆಗೋಯ್ತಲ್ಲ.
ಅಲ್ಲ, recently, my lord, I filed the memo with the documents, my lord.
What is interesting in this?
My lord, one more suit is filed, my lord. Injunction operating against me and respondent number 1 also, my lord, not to alienate the property.
ಅದು ಇನ್ನೊಂದು ಸೂಟ್ ಇದೆಯಾ?
ಇನ್ನೊಂದು suit
quite interesting. ಏನಾಗಿದೆ?
My lord, ಅದು kept in abeyance ಅಂತ ಇದೆ, my lord, page order copy ಇದೆ.
ಅಬೇನ್ಸ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಸೂಟ್ ಏನಾದ್ರು ಹಾಕಿದಾರಾ?
ಅಲ್ಲ, same court, by the, not by the kindly.
ಅವ್ರ ಅತ್ತೆ ಕಡೆಯಿಂದ ಹಾಕಿಸ್ತಾರೆ.
ಅಲ್ಲ,
ಮದರ್ ಇನ್ ಲಾ.
ಅಲ್ಲ, ಮದರ್ ಇನ್ ಲಾ ಅಲ್ಲ,
ಕಡೆಗೆ ಹಾಕಿಸ್ತಾರೆ. RC ಎಲ್ಲ ಆದ್ಮೇಲೆ
ಮತ್ತಿದೆಯಾ ಅದರ್ ಇನ್ ಲಾ?
ಇಲ್ಲ, ಅವ್ರ ಪಿಟಿಷನರ್ದು ಸೋದರತ್ತೆ.
ಇರ್ಲಿ ಬಿಡಿ, ಎಸ್ ಕಾಂಪ್ಲಿಕೇಟೆಡ್.
ಮಿಲಾಡ್, RC ಡಿಸ್ಪೋಸ್ ಆಗೋವರೆಗೂ ತಾಯಿ ಹೇಳೋದಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡ್ ಮಾಡಲ್ಲ ಅಂತಂದ್ರೆ ನಮ್ದು RAದಲ್ಲಿ ಅವರೇ ಇದ್ ಮಾಡ್ಬೋದು.
ಎಷ್ಟು ವರ್ಷ ಅಂತ ಹೀಗೆ ಮಾಡಿಸ್ಬೇಕು ಸ್ವಾಮಿ?
3 ತಿಂಗಳು.
ಪ್ಲೀಸ್.
Will direct the appellate court to decide the RA in ಯಾವ ವರ್ಷದ RA?
RA number 24 ಮೇಲೆ.
24? ಯಾಕೆ ಅಷ್ಟು ಲೇಟ್ ಆಗಿ ಹಾಕಿದ್ದೀರಾ?
37/20 ಅದು ರಿಮೈಂಡ್ ಆಗಿ ಬಂದಿದೆ.
ಮುಂಚೆ ಒಂದು
ರಿಮೈಂಡ್ ಫಸ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್.
Will direct then closure of the appeal proceedings.
Keeping all contentions open.
Everything. ಎಲ್ಲ ಇಲ್ಲೇ ಹೇಳ್ಬೇಕು, ಅಲ್ಲೂ ಹೇಳಿ ಸ್ವಲ್ಪ. Yes. The petitioner is before this court. ಇದು ನಾವು 2 ವರ್ಷದಿಂದಾನೇ ಹೇಳ್ಬೇಕು ತಾನೆ, ಸ್ಟೇ ಇದೆ 1 ವರ್ಷದಿಂದ. The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief, germane, are as follows. OS 73 of 2008 is preferred by the first respondent seeking partition and separate possession. The said suit comes to be decreed on 18/12/2009. Aggrieved by the said judgment and decree, it transpires that the petitioners have preferred a regular appeal in RA 21 of 2010. The matter reaches this court and the matter is remitted back to the hands of the concerned court to hear RA 21 of 2010 afresh. In the interregnum, the final decree proceedings are instituted in terms of the decree so passed in OS 73 of 2008 or the modified decree thereafter. The first appellate court is, the matter before the first appellate court is pending adjudication. The petitioner files an application before the court in FDP proceedings, seeking stay of FDP proceedings by an application under Order 41 Rule 5. The said application comes to be rejected, the rejection of which has driven the petitioner to this court in the subject petition. In the light of the matter remitted back to the hands of the concerned first appellate court by this court and the matter pending, which would now become dependent for all the proceedings that are instituted, i.e. the FDP or another suit. Interesting point, ಯಾವ್ದು ಕೊಡಿ ಅದು.
Memo with the document file.
Or another suit that is now instituted by the parties. To resolve the issue, I deem it appropriate to direct the first appellate court, which is hearing RA
37 of 2024.
RA 37 of 2024, which is now after the matter was remitted back by the adadu
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು
Remitted
RA
back ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಅದು.
RA ಏನ ನಂಬರ್
37 of 2024.
RA 37 of 2024. ಅದು ಯಾವ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ
Page FDP ಮೇಲೆ. FDP
in which the FDP proceedings in 18 of 2010 is challenged and pending, be disposed with an outer limit of 4 months from the date of receipt of the copy of the order, as everything is now dependent upon the first appellate court passing necessary orders on the application considering the appeal. All the contentions urged before this court of both the parties shall remain open to be urged before the concerned court in the first appeal, in the appeal RA 2024.
3724. RA 3724 FTP ಮೇಲೆ ಹಾಕಿರೋದು ಸರ್. RA 2110 ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ, ಅದು RSL ಕನ್ಫರ್ಮ್ ಆಗುತ್ತೆ. This is then he files RA 12/2013 which gets remanded. And this is RA
ಒಂದೇ ನಿಮಿಷ
37.
ಫಸ್ಟ್ ಅಪೀಲ್ ಯಾವ್ದು ಹೇಳಿ?
Kindly peruse the page number
Wait.
87 ಮೇಲೆ.
First appeal RA 21/2010.
This
That
gets,
is dismissed and challenged in RSA 1970 of 2011.
that is also dismissed.
That is also dismissed. Then final decree 13/12/2012 ಅಲ್ಲಿ FTP finalize ಆದಾಗ ಅದನ್ನ 2013 ಅಲ್ಲಿ RA 12/2013 ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ. That gets remanded.
Remanded to the first appellate court.
ಅವಾಗ mother in law files the suit and
ರಿಲೇಶನ್ಶಿಪ್ ಹೇಳ್ಬೇಡಿ. ಎಸ್ ಅಲ್ಲೊಂದು ಪ್ಯಾರ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
Page number 87 ಮೇಲೆ.
The appeal filed in RA 21 of 2010 against the judgment and decree in OS so and so 2008 comes to be dismissed. The dismissal of which is challenged before this court in a regular second appeal, which also comes to be dismissed. After the dismissal, FDP proceedings are instituted by the decree holder, seeking to execute the decree so passed. Challenging the said decree, a regular appeal is filed before a number
12/2013.
in RA 12 of 2013. Idu dismiss aita?
That gets remanded.
The first appellate court reminds the matter in FDP to rehear the FDP, right?
Yes.
To rehear the FDP. This is what ಮತ್ತೆ ಈಗ ಪೆಂಡಿಂಗ್ ಇರೋ RA ಯಾವುದು?
ಅದಾದ್ಮೇಲೆ OS mother in law ಹಾಕಿದ್ಮೇಲೆ that RA is challenged by mother in law and myself. Then that gets confirmed.
Which is that OS?
That OS is 73 bar 12/2013.
12/2013 filed by the mother in law.
It transpires that that another member of the family institutes another suit in OS
12/2013.
12/2013.
Who is R4 here, Milo?
The other member, which is fourth respondent herein. And all the matters are now pending before the first appellate court in RA 7 of 2024. 37 of 2024. In the light of the maze of facts that are narrated by the petition, by the parties to the list, I deem it appropriate to direct the concerned court to dispose the appeal in RA 37 of 2024 with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier. All contentions remain open.
Interim order.
ಏನು interim order ಇದೆ?
ಅದರ execution not to proceed execution.
The learned counsel appearing in the light of the interim order subsisting as granted by the coordinate bench of this court, the same would continue for a period of 6 months. Yes. / till the disposal of the suit.
Sorry, the outer limit is to
6 months.
three,
ಬೇಡವಾ?
3 months.
6 months ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬರುತ್ತೆ ಒಂದು. ಇಷ್ಟೊಂದು ನೀವು ಮದರ್ ಇನ್ ಲಾ ಅವರು ಆ ಸೂಟು.
ಮದರ್ ಇನ್ ಲಾನು ಆರ್ಯ ಹಾಕಿ ನಾನು ಆರ್ಯ ಹಾಕಿ ದಟ್ ಗೆಟ್ಸ್ ಕನ್ಫರ್ಮ್ಡ್ 17
ಆಯ್ತಾ ಜಡ್ ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ ಬಿಡಿ.
Petitioners. Lords, the challenge here, my lords, is to the dismissal of the application under 1 Rule 10 for deletion that is filed, my lords, by the petitioners. Petitioners, my lords, are some of the defendants in, my lords, the suit. Suit, my lords, is for recovery of money. It's a money suit.
Commercial OS.
Commercial OS.
Yes, sir.
Lords, the entire genesis, my lords, of this dispute appears to be, my lords, that there was the plaintiff in, my lords, the suit, and, my lords, the defendant numbers 1 and 2. 1, my lords, is a company, 2 is, my lords, the managing director of that company. The defendants, my lords, were looking for certain investments. The plaintiff, my lords, claimed to be in a position to bring in those investments. There was, my lords, some services agreement that was executed. Further, my lords, the plaintiff also said, well, I will, to increase the valuation of the company, I will place some of your employees.
Why you should not be a defendant in that?
Because, my lords, insofar as, my lords, the plaint is concerned, and, my lords, the petitioners before, my lords, there is, my lords, nothing, my lords, made out against them. Lords, insofar as, my lords, the petitioners are concerned, no, my lords, major allegations, my lords, are made against them. In fact, some of the petitioners before, my lords, there is not even, my lords, a mention of them, my lords, in the plaint. The major allegations, my lords, in the plaint are, my lords, against the defendants 1 and 2, who, my lords, are not before my lords.
Yes, man.
My lords, I have a list of all the allegations that I have made.
In defamation, I don't know.
No, my lords. This is
money recovery.
Money recovery.
Breach of contract, cause of action 1. That contract, my lords, is between plaintiff and defendant number 1. The plaint is at page 220. The second cause of action, my lords, is tort of inducement of breach of contract. My lords, deliberately, the directors of, my lords, I have, in short, the facts are an Indian company, defendant number 1 comes to me saying, please find me an American or some good investor where my shares will get high valuation. I say, all right, I'll offer those services. There is an exclusivity. Knowing fully well there is an exclusivity, they breach the contract. Each one of the directors of the Indian and the American entity know that there is an exclusivity provision. They deliberately, in bad faith, breach it. Therefore, my lords, my cause of action against them is tortious interference or tort of inducement of breach of contract. Lord, on that point, not so far as the other defendants are concerned, that is category 2, directors. Category 3, my lords, are people. So what they do, my lords, is they say,
category 3 na?
They are category 2 and 3.
Of all of them.
They are category 2 and 3. Category 1 is the company and its managing director. They have not filed an application under 1 Rule 10. Category 3, my lords, are persons who, pursuant to me, got interviews and their visa applications got approved. Lords, approval of visa application results in increasing the valuation of defendant number 1 company. And had they been placed in the United States, a portion of their earning would have come to me.
You're a travel agent.
Lords, I am a services company. I am a lords help in mergers and acquisitions.
What is Apta Mitra?
Oh,
yes.
Lords, I help a lords in these mergers.
Apta Mitra help madlebekala. Yes.
I help in these mergers and acquisitions. Therefore, my lords, I get visas. It's a difficult thing.
Visa?
Lords, US visa.
Oh, US visa. Now very difficult.
That too for employees. For employees. I get those visas because if they get placed, I also get a portion of the contract fee.
Commission.
Please. And it's all in black and white.
Well, who said otherwise?
No, means, my lords, it is all permissible.
All
is what I meant. Therefore, my lords, these are the 3 categories. Now, my lords, the question that I have to answer is there any possibility that they will,
Now, contract is entered into between whom?
my lords, between plaintiff and defendant number one. Defendant number one is not before, my lords.
All right. Plaintiff and defendant number one for the purpose of generating visa.
Not for the purposes of generating visa and for the purpose of getting defendant number one investors.
All right.
Two sets of contracts. There is also a non-disclosure agreement.
That is defendant number one.
Therefore, my lords, so far as defendants number 3 to 24 are concerned, my case, my lords, 3 to 12 is tortious. And I have said so in my plaint. Your lordship may kindly see, my lords, just one or two allegations.
Tortious.
Tortious claim.
Very cautious. Yes.
My lords, I have specifically pleaded that there is a tortious claim against them. And I have, my lords, extracted the pleadings against each one of them. Therefore, my lords,
Now, they are not parties to the contract.
They're not
Defendant
parties.
number one is a party to the contract.
Please,
You may imagine so many things for breach of contract. ಅವ್ರನ್ನೆಲ್ಲ ಕರ್ಕೊಂಡ್ಬರ್ತೀರಾ?
my lords, there.
Unless there is a specific act on these petitioners, they are neither proper nor necessary. How do you tortious according to you? Maybe.
Lords, they are directors.
XYZ have induced these people to breach the contract.
My lords,
You may bring all and sundry.
my lords, I bow down.
Then
They are directors, my lords.
they are directors.
They are directors. So they are not unrelated persons. In the plaint itself, I have described them. They are either directors of defendant number one or directors of the target company, the acquirer. They are directors of one of the two. Therefore, they are not unrelated. Now, my lords, on that point, there is some law. But even before I come there, Lord, may I respectfully say this. Traditional 1 Rule 10 jurisprudence, my lords, is that whether I have pleaded a cause of action, not whether I in point of fact have a cause of action. My lords, with respect to commercial courts, that becomes even more accentuated because of 13A. 13A provides, my lords, summary judgment. Summary judgment is pre-trial, pre-framing of issues precisely on this point that there may be, because the submission was some sprinkling averments are there, serious averments are not there. That is precisely to be dealt with in a 13A application, not in a 1 Rule 10 application. Because, my lords, here I have sought prayer. Prayer is there against all defendants. Averments are there. Tortious liability averments are also there. On that point, my lords, may I just submit? In UK, my lords, the law that is formulated is that if a person, which one are you getting? If a person, my lords, bona fide, if a servant, my lords, I understand that a servant or an agent of a corporation.
Alla United Kingdom, India dilva.
My lords, this Sayadwar's, this principle may not have been in as many words incorporated in Indian law.
King's Bench.
Yes, my lords. And this first judgment, that is Sayad versus But, it looks like it has been followed consistently. It is now more than 100 years old. The principle, my lords, is at page 10. The second paragraph from top. I hold that if a servant acting bona fide within the scope of his authority procures or causes the breach of a contract between his employer and a third person, he does not thereby become liable to an action of tort at the suit of the person whose contract has thereby been broken. There are two conditions, my lords, therefore a servant or an agent must meet. Condition one is he must be acting bona fide. Second, he must be acting within the scope of his authority. If those two conditions are met, for breach of contract, a person who has procured the breach, whether he be an agent or a servant, is not liable. My respectful submission, my lords, is whether he has acted bona fide, whether he has acted within the scope of authority, is a matter for trial. The second judgment, my lords, is a more recent judgment. In this, your lordship may kindly see running page 21, para 26. It looks like, my lords, that authority has held. The rule in Sayed versus But and the circumstances in which a director can be liable. There, my lords, it was a case of a servant. Here it is director. Can be liable for inducing a breach of contract by the company of which he is a director. The same principle is reiterated. Therefore, my lord, my respectful submission is it is not as if these proceedings cannot begin at all. These proceedings can begin. Then your lordship may for a moment kindly see para 33 of the same judgment. The only submission I wish to make on para 33, my lords, there is, they refer to the English Companies Act, section 172, which is similar to 166 of our Companies Act, to determine what actions would be bona fide, what actions would be mala fide, what actions would fall within scope of authority, what actions would not. And one of the provisions of the English Act at least is to respect contracts with third parties. Therefore, my lords, a deliberate action of disrespecting a contract is a tort. Section 166, in a more terse form, incorporates the very idea of 172 of English Companies Act. The last extract, my lords, is of Winfield, where Winfield also says, now this is an accepted tort. In these circumstances, my lords, my respectful submission is that whether this matter has to go to trial could also be decided under 13A. My respectful submission would be for a point saying this tort should not be allowed in India, or this tort should not be allowed unless averments of so and so nature are present in the plaint. That, my lord, in my respectful submission, would more appropriately fall within 13A. On 13A, my lords, and on general principles of 1 Rule 10, I will not, my lords, read out except to point out on 13A, my lords, I will not even read out. Only on 1 Rule 10, there is one judgment, only one judgment, my lord, that I could find. The first three are on 13A. The larger list of authorities, my lords, is on 1 Rule 10. In this, may I respectfully request, my lords, to kindly see only one judgment at serial number 9, page 78.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
No, to them. Give. Only one judgment at serial number 9, page 78. Calcutta, my lords, seems to have accepted the principle of tortious interference so far as to say even breach is not essential. An attempt to interfere even short of breach is actionable in tort. Para 13 at page 81. And they follow, my lords, long-standing English judgment.
If you take that in Winfield,
please,
even silence can be breach of contract, is what is said. Winfield book, no?
Yes.
Even say staying silent where you had to act,
please,
in terms of a contract, will also become a breach of contract.
Therefore, my lords,
if there are positive acts, yes, we'll see. Even remaining silent sometimes can
amount. And here, my lords, I have produced.
That is what is said.
Great.
Winfield andralla.
I have produced an extract, my lords, on this tort. That all standard textbooks.
Winfield law school al yes.
To say, my lords, that all standard textbooks today accept this tort as imposing a liability on a director as well as an employee, subject to two conditions. If they have acted within scope of authority and bona fide, then they are not responsible for breach.
We'll see. Yes, Vivek.
But so far as the directors are concerned, in fact, just taking my lords his own extract that my lords was produced today, I'll just take my lords to what, according to him, my lords, are the allegations. Could I just request my lords to look at serial number 2? Serial number 1, my lords, is the company, my lords, the company that my lords acquired the shares.
Yes.
Now, my lords, they are saying, my lords, initially there were no allegations even against the third defendant, which is the first petitioner before my lords. That is the company that my lords acquired the shares of the first defendant. But there was, my lords, some amendment where, my lords, this whole tortious interference claim, my lords, was brought in. The amendment appears to have been allowed. I'll, my lords, skip that for the moment. Let me, my lords, go in respect of, my lords, those employees and not directors. So there are, my lords, again, two categories. One is, my lords, the directors. Two is, my lords, the employees. So as far as the directors are concerned, first is, my lords, at serial number 2, my lords, in this Pinkesh Shah. Page number Zilla, I'm sorry.
Pinkesh Shah.
Yes, the name.
Aptamitra, Pinkesh Shah, what is all? Yes, it's all right. Names. Page, Vivek, sir.
Lords, I'm sorry, the page number Zilla, I think it is.
Idral page number is there. This I have. What are you reading?
ಇದ್ರಲ್ಲೇ.
ಇದ್ರಲ್ಲಿದೆ ಇಲ್ಲಿ ಬನ್ನಿ.
So a serial number 2 ತಗೊಂಡ್ರೆ
ಅಲ್ಲೇ
that is,
ಇದೆ.
that pinkish sharp.
I am there.
In fact, with regard to some of the other these things, in fact, they are silent. In fact, ತಾವು petition ನೋಡಿದ್ರೆ as to who has filed, who are before my lords. There are some of the directors in respect of whom they have not even said anything in this. They come under a general this thing where there are allegations saying defendants have done X, Y, or Z. So, otherly they are lumped. But coming specifically to who they say that there are specific allegations, kindly look at this too. So, this pinkish. So, they say in para 30, what they say is prior to M&A conclusion, plaintiff was strategically deterred from legal action by the second defendant's continuous false promises. Once the M&A was finalized and the plaintiff's requests were blatantly ignored, they were left with no option but to approach the 10th defendant. So this 10th defendant is this Pinkesh Shah. Director of Physical Design at Max Linear at Bengaluru. This decision was taken in an effort to seek resolution.
One clarification. Defendant number 3 is also the director of Max Linear.
Please, Lords. But again, there are no Lords allegations against him. What they say is.
Just wanted to know the position. He is the director.
He is the director of Max Linear. Max Linear, my lords, is the acquiring, the company my lords, that acquires, third defendant. And my lords, first petitioner before my lords. So therefore, my lords, kindly, my lords, look at the last 2 lines, my lords, here. However, Pinkesh's response, strikingly akin to that of a comrade in arms of the defendant.
Pinkesh is 10th defendant?
He's the 10th defendant.
All right. Yes.
Now, Pinkesh is, my lords,
He's the third defendant.
he's my lords, a director of physical design. He is, my lords, akin to, my lords, actually an employee. He's akin to, my lords, an employee. Anyway, his status is not some director of physical something. But though, anyway, lords. And my lords, it says that he obfuscated the path to justice. Now, my lords, my lord, my lords, stop here for a minute. I don't know what, how, my lords, that constitutes anything, my lords, that would make him either, my lords, a necessary or a proper party. Ultimately, my lords, it is this. Today, we are, my lords, in an application, my lords, under 1 Rule 10. The test, my lords, leaving aside everything else, is, my lords, is he a necessary party? If he is not, is he a proper party? If he is neither, then, my lords, he has no role, my lords, in that suit. Now, the only allegations against this fellow is, well, they wrote something to him. He acted like some comrade in arms and obfuscated the path to justice. Then, my lords, look at 4, which is this Prashant Murthy.
Manu,
not my play. Similarly, in fact, there are three of the defendants who are actually made party twice because they are once they're arrayed as director of one company, the second time they're arrayed as a director of the second company.
But anyway, as far as you are concerned, only one.
Idare ಕೆಲವರು ಇಬ್ರು.
Oh, ಇಬ್ರು ಎರಡು ಸರಿ ಮಾಡಿದೀರಾ?
There are some errors.
The second petitioner is in fact one of those dual
all right, yes.
persons. Then, my lords, we look at 4. 4 says para 16A. Similarly, plaintiff again on so and so wrote a reminder email to the defendant for signing MSA agreement, which was replied by the same director, that is defendant number 11, stating that defendant number 2 is working on the same and that he will check it with him. My lords, again, I'll just point out there is one judgment of this honorable court, my lords, very detailed.
1 Rule 10.
1 Rule 10. It's just, again, my lords, it.
ಇವರೇನೋ 1 Rule 10 ಮೇಲೆ thesis ಬರೆಯಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Yes.
Because what ultimately, my lords, it is this. Court simply says, look, if he is a necessary party, yes. If he is a proper party, all right. But if he is merely being brought in as a witness, if ultimately his role is simply to justify something or the other, his role is that of a witness. That does not justify his this thing. Para 22, my lords, at page 17. This is His Lordship Justice Chauhan's.
Yes.
It's a single bench.
Yes, so what? Yes.
The principles, my lords, have been summarized.
This court?
This court, my lords.
Then
court.
yes.
The question of impleadment of a party has been decided on the anvil of Order 1, Rule 10. The question of impleadment would revolve around 2 issues. Namely, is the impleader a necessary party or is the impleader a proper party to the suit? A necessary party is one without whom no order can be made effectively. Proper party is one in whose absence an effective order can be made, but whose presence is essential for the complete and final decision on the question involved in the suit. What makes a person a necessary party is not merely that he has relevant evidence to give on some of the questions involved. It would make the party merely a witness in the case. It is not only merely that the party has an interest in the correct solution of some questions involved and is in a position to advance relevance arguments. Even this would not make the person a necessary party. What makes a person a necessary party is that he would be bound by the results of the action. Therefore, the question to be settled must be a question in the action which cannot be effectually and completely settled unless he is a party. I'm not again pausing here for a moment. And not 8 also. Most importantly, interpleader must have a direct and legal interest in the action. The direct and legal interest would be if the order passed either in favor or against the plaintiff would be binding on the impleader. Even if the impleader has different cause of action against the plaintiff, impleader cannot be impleaded in the suit. So the controversy in the suit cannot be enlarged by introducing a different cause of action in which the impleader may be interested. So, my lords, ultimately, my lords, it is this. Their entire cause of action today, my lords, is twofold. One is they say, look, we entered into this contract with defendant number 1 and defendant number 2, who was the managing director of defendant number 1 at that point in time, and agreement was entered into. They say there is a breach for which, my lords, they are claiming damages. The second limb is now they say, look, there is tortious interference with the inducement to breach contract, whatever it may be. That is the second limb. Now, the main allegations appear to be against defendant number 3. There is nothing, my lords, with regard to the directors. Ultimately, my lords, it is this. Merely, my lords, being a director does not, my lords, require them to be a party. It's one thing, my lords, if as a director they have not done some action, they, my lords, on an independent basis, my lords, are either, my lords, a proper or necessary party. And then, my lords, there are those employees. Employees are those defendants numbers 14 to 24 are those, my lords, H1B1 visa whose applications are, they are, my lords, employees of defendant number 2. Now, my lords,
on that, my lords.
Defendant number?
14 to 24.
14 to 24, my lords. That is
Yeah, that is also allowed?
Lords?
That is also allowed?
Everything is, my lords, rejected.
Everything is? No. Deletion, everything is rejected.
Everything is rejected.
Now, 14 to?
That is defendant numbers 14 to 24, my lords. That is petitioner 7 onwards, my lords. 7 to
Adu beka?
17.
14 to 24. There is
14 to 24 will.
not much.
I am grateful.
Will answer others.
May I just say only 2 things, my lords. In this list, I have set out the main allegations and allegations against defendants in general, both. Second, my lords, my prayer is against all. So if the standard test is applied, they are necessary, not even proper.
But 14 to 24 will say you have accepted. All right?
Please.
Or, yes.
Then, my lords, the rest are, my lords, again.
Rest will see, will answer. Heard.
There's also, my lords, the memo that those 2 agreements are before my lords, which show, my lords, that I am not a. There's a memo, my lords, of 18, 12, 24.
No, you are not a signatory to the agreement is an admitted fact. It's an admitted fact. Yes, heard, reserved.
Grateful.
Hearing for respondent number 1.
Petitioner.
Suit for vacating tenant melons.
Tenant?
Yes. I am not the tenant, my lord. I have vacated the premises. I have handed over the keys also, my lord. And all the things were settled. In fact, they have admitted that. Subsequently, there was a respondent number 2, my lord, in this case is none other than my wife. We have a matrimonial dispute which is going on. So in this regard, she has come and occupied the premises, my lord, without my knowledge and with her consent, with the consent of the respondent 1. Therefore, my lord, the lease period is over. I have handed over the keys. I have handed over the vacant possession. They have written an email stating that thanking me for handing over the keys. Subsequently, they have come, the respondent number 2 has come and occupied the premises as per the suit. And therefore, my lord, now the previous counsel, there was a miscommunication between me and the previous counsel, and therefore he could not come and cross-examine the witness, PW1. Now, immediately after I filed my NOC Vakalat, I filed my application for recall. And that came to be rejected, my lord, and this is the.
Yes, sir, will permit.
My lords, my.
You
there's
are
a con-
landlord, huh?
My lords, I'm the landlord, myself, senior citizen, my lords. My request.
Landlord, senior citizen yakke?
My lords, he is.
Landlord.
My lords, yes, my lords. My lords, page number 15, the conduct of the petitioner may kindly be seen, my lords.
Conduct of the husband.
Yes, my lords. He has appeared before the honorable court on 2019 itself, my lords, and filed his written statement, 27/3/2019. Thereafter, he never appears before the court. In 2024, my lords, I filed an application to deposit the rent before the court. That honorable trial court, my lords, passed an order to deposit the rent by the defendant number 1, that is a petitioner hearing. My lords, immediately he comes before this court and takes a stay. Then he kept silent for another 5 months, my lords. Then the matter.
You have vacated the premises.
Yes, my lord, I have vacated.
But you put in your wife there.
My lord, the divorce proceedings is pending.
Ade divorce agilwala.
Agilla.
Then.
ಅಂದ್ರೆ ನನ್ಗೆ ಅವ್ರದ್ದು ಇದಿಲ್ಲ ಸರ್.
It was not vacated.
Lease agreement was
Wife is
entered
there
between
only.
me and.
Wife is there only. She has not vacated. They both were living together.
Both are living together.
No, ma'am.
They were living and he left the
Again
wife.
ಗೊತ್ತು?
Lords, he left the wife and went. The
Who you left?
And the premise was not vacated. He left, handed over one key there and.
Where is that thanking message?
Yes. One email have filed along with a memo, my lord, on the previous date of hearing.
Oh, in this case. No.
Advocate.
My lord, I'll file it.
ಏನ್ ಹೇಳುತ್ತೆ?
ಇಲ್ಲ
ಕೊಡಿ.
ಕೊಡ್ತೀನಿ. In fact, my lord.
July 24, 2017.
Thank you for vacating the flat. And
I read it.
Yes, and even in fact, there is a legal notice, my lord, which is produced as exhibit P8, my lord, in the case.
What does that say?
Adrallu, they have admitted that my client states that the lease period expired.
Why is the notice then?
Since it is not vacated, my lords.
5/8/2017.
Yes, ma'am.
Why should the notice be issued after thanking him?
My lords, it was not physically handed over, my lords, because there was his wife and.
One minute. I hereby confirm the receipt of the following keys. Main door keys, bedroom keys.
My lords, one key is handed over, but duplicate key along with there are 2 keys, my lords. That wife was using it and it has not been vacated.
So it's not vacant at all.
It was not vacant, my lords.
You have not instituted anything against the wife?
It is both, sir. It is both against wife and husband.
Joint and several.
Joint and severally.
Lord,
Lords, from 2017, there is no rent, a single piece of
Lord,
rent
I
has
will
been
cross-examine the
Matrimonial proceedings ಯಾವಾಗಿಂದ ಇದೆ?
It's
What proceedings are pending?
divorce proceedings are pending. ರಾಜಸ್ಥಾನದಲ್ಲಿ ಫೈಲ್ ಆಗಿತ್ತದು.
MC.
ಹೌದು ಸರ್. ಇದು
MC.
ಇವಾಗ presently it is now transferred to Bangalore.
MC.
Yes.
Of which years?
MC.
ಅಲ್ಲಿ ಹಾಕಿದ್ದೆ ಯಾವಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಯಾವಾಗ? ಈಗ when will both of you vacate the premises?
My lord, I have already vacated, my lord. I am not staying in that premises. All I want
When
is,
will you ask your wife to vacate the premises?
there is a mediation which is scheduled on 20th of September.
more than 30 lakhs 24,000 rent is pending, my lords.
All I am seeking is cross permission.
Husband and wife cannot play hide and seek with him.
No, my lord,
Husband hides and
my
wife
lord,
seeks.
it is our contention that this is a collusive suit, my lord, which they have filed against
I'll
me.
produce 2.
Yes, my lord.
Collusive suit.
ಹೌದು ಯಾಕಂದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ they have extracted admissions. They ಚಾನ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ.
When is the mediation?
20th of September.
I am for the
Produce 2 documents.
in this case, my lords, wife.
Who are you?
I am the wife, my lords, representing second respondent.
Oh, you are the wife.
Yes, my lords. My lords, DV proceedings were pending. When the suit was initiated because the husband.
Both of you are staying together.
No. He has left me in 2017. 2017, he is not coming to my
Where,
house.
where are you staying?
I am staying in this rented premises where I was living prior to he leaving me.
Then pay rent.
My lord, sir, the rent has to be paid by the husband, my lord, because
Why rent has to be paid by the husband? You just now said he is gone.
he has gone, but the rental.
Then you are squatting over the property without paying rent.
My lord, I am not a party to the.
Don't tell me all this.
My lord, one second, my lord. I will say.
Documents also.
Now both of you are, both of you are together hoodwinking this poor landlord.
His
Mane kottidalde idu bere.
daughters
He
are
also
living
fees
in
5
Bangalore,
minutes.
in a rented house.
No, no.
And he wants that property for his personal
Anyway,
use. He is not able-
the entire proceedings are not before me. Stay ideyalli.
Yes, sir.
We'll vacate the interim order, direct the court to dispose the suit in
It is posted
6
for
months.
now, final argument, even argument is also over, my lords, it's posted for
One
judgment.
chance for cross.
All chance.
Cross
No
examination.
chance.
PW and cross examination ಮಾಡಿಲ್ಲ.
Nothing. Yes.
My lord,
ಎಲ್ಲರೂ ಸೇರ್ಕೊಂಡಿಲ್ಲಿ this landlord is taken for a ride.
No, no, my lord.
my lord, I have discharged all my liabilities, my lord. I have paid the security, whatever the rent.
Until your wife is out of your life, you will have to pay everything. Yes.
My lord, DV
My lord,
court
at least-
has directed, my lord.
At least, my lord, we'll have it after 20th, my lord, because the mediation is coming up, my lord.
We'll give one chance. 20th ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು, I'll post it on
I will also file my.
22nd. I will dismiss it on 22nd, not dispose it. Yes.
Yes,
Even the maintenance
I-
fees also, my
I-
lord, for all these years paid by the landlord.
Wife ನೀವ್ ಯಾಕೆ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ
ಅಲ್ಲಿ
ಇದ್ದೀರಾ?
ಅವರು ಡಿಮಾಂಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, so this poor guy is
His
paying.
wife, why are you paying maintenance?
I produce the documents also for that, for 4 lakhs 50,
The
40,000.
cat is out of the bag. Anyway, let's see.
Neither he has come to
If you are paying maintenance to his wife.
Not maintenance, land maintenance.
Order of the learned magistrate in DV case.
All
And
right.
he
Yes.
is working.
List on 22nd.
He is earning around
Preliminary
5
hearing.
towards salary.
Under the caption interlocutory applications. Yes.
Grateful. Stay may be extended.
Interim order subsisting would continue to the next date of hearing on the score that the mediation between the parties is slated to be held on 20th September.
Grateful.
I am permitted to file my counter within time, my lord. In the meanwhile.
ಎಲ್ಲಿ mediation ಅಲ್ಲ?
ಅಲ್ಲ, ಇಲ್ಲಿ court ಅಲ್ಲಿ.
ಹಾಕಿ ಸರ್.
Yes.
56.
Please. Not the petitioner, but is the owner of the property, having purchased in 2006.
Impleading ಏನು?
But impleading what has happened is not lok adalat mein they obtain in a local award, but without notice to me, without making me a party. Mother and son. Mother sells the property to me. Son files a suit, my lord, in 2024. Sailed it in my favor in 2005. And my lord, the award is obtained. There's an interim order granted by the Honorable Court. After which, my lord, they sell the property.
You are hypnotizing me?
No, no, no. Let him complete his submission, because insofar as suit schedule property is concerned, survey number 11/1, and their claim is survey number 11 as per their sale deed.
Post lunch.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಯಾಕೆ ಊಟ ಮಾಡಲ್ವಾ ನೀವು?
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದ್ರೆ
ಊಟ ಮಾಡಲ್ವಾ ನೀವು?
ಹಂಗಲ್ಲ,
ಆಗೋಗಿದ್ಯಾ?
ಆಗೋಗಿದ್ದಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡ್ತೀನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. ಅಬ್ಜೆಕ್ಷನ್
330 ಯಾವ್ದಿದೆ ತಗೊಂಡ್ಬಿಡಿ. ನಿಮಿಷ ಅದು ಯಾವ್ದು serial number? ನಮ್ಮಿ 157 ಆಲ್ಸೋ ಅದು ಕಾರ್ಗಿಲ್ ಬರ್ತಾನೆ ಇದೆ. ಹಾ
I have purchased the property from the
petitioner. ಒಂದು ನಿಮಿಷ.
I have purchased the property, my lord, by sale deed dated 2010-2005 from the mother, my lord, of the first respondent. That is not the second respondent herein.
Now it is compromised without.
He files a suit in 2024 and says, my lord, mother and sister will get 10 lakhs. He will get the rights in the property. 2024 suit is filed. Thereafter matter is compromised.
Now why are you here?
But I am challenging the order passed, my lord, in the Lok Adalat.
Lok Adalat.
And my lord, what they do is, the Supreme Court granted an interim order, staying the order of the Lok Adalat. After which, my lord, they sell the property. And that is why I filed an application for impleading, my lord, and interim relief.
Better.
See, they are claiming that on page number 25 that they have got sale deed. That is, my lord, one Asghar Jan.
Asghar?
Asghar Jan. Page number 25. Absolute sale deed. Which Asghar Jan has got GPA. And he has GPA of Kempoma, that is first respondent here. And he has, and Itta Ma, Ipper Sheri. Our party sale ಮಾಡಿದ್ದಾರೆ, that is
Yes, one moment. Whose property was that?
Property Kempoma mother in the father of the property.
Kempamma's property.
Yes.
Who is the GPA holder?
GPA holder that they have Asghar Jan.
Asghar Jan.
Yes. And
Asghar Jan sells it to whom?
that is petitioner. That's Mukram Jan.
When?
That is Lord,
2005.
2005.
2005.
Yes, one moment. Suit schedule.
Please.
Sorry, in the sale deed schedule.
Sale deed, not to get it, not page 25.
20?
25, not the sale deed starts. Not take notes to schedule.
Straight away to the schedule.
Yes. Page 39.
1 acre 38 guntas, survey number 11. Dodballapura.
Howd.
Yes, sir. Amale.
Plain schedule, not to get it, page 58.
Page?
Page 58.
58.
It is not their case that she owns any other property.
Statement of objection ಹಾಕಲಿಲ್ಲ, ಅವರು impleading application ಹಾಕಿದ್ದಾರೆ.
So property is the same.
Property is the same, Lord. Only difference is now they say it is 11/1 instead of 11.
11/1.
ಪೋಡಿ ಯಾವಾಗಾಯ್ತು?
ಪೋಡಿ ಯಾವಾಗಾಯ್ತು? ಅದೇ ನಿಮ್ದು ಪೇಪರ್ಸ್ ತರಿಸಿ objection ಹಾಕ್ತೀನಿ ನಾನು. ಯಾವಾಗಾಯ್ತು?
ಮತ್ತೆ ಯಾಕೆ ಸೇಲ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ? ಅಗ್ರಿಮೆಂಟಾ?
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್.
After the interim order, why?
Interim order ಅಲ್ಲ. This is Lord 5/5/2025.
Interim order 29/4/25.
29/4/25. Were they on caveat?
No, they were not on caveat.
And what have you sought now?
But I have sought an order of injunction, but insofar as not the respondents and impleading not the subsequent purchaser and not some more persons who have joined the respondents 1 to 3 to sell the property. Their family members they have included.
Will
And not amendment.
Because the original owner is party before your lordship.
Who has sold the property?
Original owners have sold.
Urene, that is Kempamma. Not property belongs to the mother, Kempamma. Son files a suit.
ಅದೆಲ್ಲ ಗೊತ್ತಾಯ್ತು, ಮತ್ತೆ don't go back to history.
Kempamma and her children have sold the property in favor of Raghunath Reddy. And they
ಅಲ್ಲ ಅದಾಯ್ತು. ಈಗ one moment sir, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಸೇಲ್ ಮಾಡಿದೀರಾ?
ಹೌದು.
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಒಬ್ಬ ಮಗನಿಗೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಆಗಿತ್ತು.
ಅದಕ್ಕೆ ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ ಅದು ಇದೇ ಪ್ರಾಪರ್ಟಿ ಮತ್ತೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. This property suit is filed for partition, lords. Son files against mother and sister.
Correct, sir. It is compromise. Compromise decree is passed.
Yes.
Then after that, what is the portion that he sells now?
So
He or
that
she?
is the entire property, my lord, is sold.
Entire suit property?
Yes, entire property.
Yes, sir.
Page 23 of my application. Not
The petition.
I am not the owner, that I am appearing for.
ಈ ಸೇಲ್ ಮಾಡಕ್ ಹೋಗಿದ್ಯಲ್ಲ?
ಅಲ್ಲಲ್ಲ, ಈಗ entry ಮಾಡ್ರೆ ಅವ್ರು amendment ಮಾಡಿ subsequent purchases ತಂದು party ಇದ್ರೆ, yes.
Why are you worried? You have sold it, leave it. Parallel. Don't get worried about your purchasers. We will restrain them by the interim order. You don't worry about it. Yes. The petitioner is before this court calling in question a compromise entered into between the parties in OS 638 of 2024, whereby the property that is owned by the present petitioner is made the suit schedule property in a suit for partition long after the said sale, and the matter is compromised. Matter closes on entering into a compromise, whereby the respondent gets the share of the property of which the petitioner is the owner. All of this happened without the petitioner being made a party to the proceedings. Therefore, the petitioner has preferred the subject petition recalling the compromise as it was entered into and closed before the Lok Adalat. The learned counsel for the petitioner, Manmohan, further submits that despite the grant of an interim order on 29/4/2024, the respondent has again sold the property to third parties, and therefore he has filed applications seeking to implead those third parties and the parties who were responsible for the said sale as party respondents to these proceedings. The impleading application on the aforesaid score requires to be allowed. Therefore, the impleading application therefore requires to be considered. Issue notice on issue notice on the impleading application.
Number 1.
As observed here and above, the interim order was granted on 29/4/2024. The 2025, and the sale deed is entered into on 5/5/2025. Therefore, the sale is admittedly contrary to the interim order that was granted. Be that as it may, after the appearance of the impleading applicants, the issue whether the respondent who has now sold the property in favor of the purchasers is guilty of any contempt would be noticed. In the light of the sale taking place after the interim order, as also the act of the respondents as noticed here and above, what stay have you sought?
But I have sought for injunction not to interfere with my possession.
Idin sell madidal in the so and so the respondents, the present respondent or the other impleading applicants who are now wanting to claim their right over the sale that is made after the interim order are restrained from interfering with the possession of the petitioner. List the matter on yes, list the matter. Other notice ಹೇಳಿದ್ನಲ್ಲ, impleading applicants ಗೆ emergent notice IA ಯಾವುದು sir?
IA number 1.
IA1 emergent notice on IA1 seeking impleadment returnable by the 19th of September.
But the earlier interim order also may be extended.
The interim order that was subsisting shall also continue till the next date of hearing.
Great.
ಇದಕ್ಕೇನ್ why are you here? 39(1) consider ಮಾಡಿಲ್ವಾ? The petitioner is before this court seeking the following prayer suit for
declaration and
the plaintiff institutes OS so and so seeking relief of declaration and injunction. He is at the doors of this court on the circumstance that the concerned court does not grant an ex parte interim injunction temporary injunction as prayed for answering application order 39 rule 1 and 2. The respondent is now represented. The coordinate bench of this court and then order. coordinate bench of this court had protected the interests of the petitioner with grant of an interim order. Status quo, by grant of an order of status quo. In the light of the respondent being represented today, I deem it appropriate to dispose the petition with a direction to the concerned court to consider the application, which is, consider the application order 39 rule 1 and 2, which is pending in accordance with law after hearing both the parties. In the light of status quo operating in the subject petition, the same shall continue subject to further orders to be passed by the concerned court, ordered accordingly. The concerned court shall consider.
8 weeks, my lord.
ಯಾಕೆ ಸರ್?
Senior is appearing in the trial court, sir.
ಸೀನಿಯರ್ 8 ವಾರದವರೆಗೂ ಬರಲ್ವಾ?
It's Shumaga, sometimes it.
ಶಿವಮೊಗ್ಗನಾ?
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಶಿವಮೊಗ್ಗಲ್ಲಿದಾರ? ಓವರ್ ನೈಟ್ ಬರಕ್ ಹೇಳಿ. I'll direct court to pass necessary orders in 2 weeks. Yes, sir.
My lord, that
What
matter is.
ಶಿವಮೊಗ್ಗ story you are telling?
ಸೀನಿಯರ್ ಇಲ್ಲಿ ನಾವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇರೋದು ಅಲ್ಲಿ ಸ್ವಾಮಿ, ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಇಲ್ಲಿಂದ ಶಿವಮೊಗ್ಗಕ್ಕೆ ಹೋಗ್ಬೇಕಾ?
Please.
ಸ್ಯಾನ್ ಫ್ರಾನ್ಸಿಸ್ಕೋ ಅಲ್ಲ ಸರ್. Yes. 2 weeks ಅಲ್ಲ, 4 weeks ಅಂತ ಹಾಕಿ. Whatever application, yes.
My lordship, the petitioner counsel not in session.
Not in session, what?
My lordship, the connected matter. Connected
matter not in station?
Clubbed with, along with this petition, please.
Huh?
Clubbed along with this matter.
Clubbed ಏನ್ನ ಕ್ಲಬ್ ಮಾಡ್ಬೇಕು?
Connected matter ಇನ್ನೊಂದಿದೆ ಸ್ವಾಮಿ, please sir. WP number 1879 of 2025, same party.
You not had lunch? Had alla. So be a little loud, sir.
This matter may be disposed is my humble request, my lords, because
Which
this
matter?
interim order is operating against me, my lords. I have filed vacating stay application. Lords, the
ಕ್ಲಬ್ ಮಾಡ್ಬೇಕಾ?
Please.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ವೆಕೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲಬ್ ಮಾಡ್ತೀವಿ. ಆಗ್ಬೋದಲ್ಲ?
Lords, in fact, this interim order, may I make submission? This interim order is obtained by suppressing that similar application. This is an injunction application, trial court granted injunction, lords, not tailnet. Appellate court reversed it, against which they came here. Lords, similar application is again filed before the trial court, and that was rejected. After rejecting of that, suppressing that, lords, they obtained a status quo order without disclosing that. I have produced along with that vacating stay application. 39-192, one more they filed before the trial.
ಹೇಳಿ.
Kindly call on Monday, please. Your
No, sir. Where is your senior?
Delhi.
Delhi?
Yeah, Delhi. Lokesh Kumar case.
Idu
Lokesh Kumar case. Yes.
Lokesh Kumar. Who is Lokesh Kumar?
Advocate.
before the appellate court also, my lords, it was just dragged like this, my lords.
My lordship, Monday. Kindly call on.
No clubbing, only Monday.
Please.
List on Monday. Or his instruction only to clubbing. Yes. List the matter on Monday. It is made clear no further adjournment would be granted in the event no submissions are made. The interim order would stand vacated.
Very
Yes.
Respondent by me.
Suit for
execution petition, my lords.
execution. Yes.
Section,
What
28
stay? What application?
Section 28 application for rescission of contract is filed by me.
In the
JDR,
execution?
In the execution proceedings.
Anything else, sir?
And that application was dismissed on the ground that that there was no direction insofar as decree holder is concerned. I would like to take your lordship to the operative portion of the judgment. My lords, impugned order is at suit for specific performance. Decreed.
What?
Ex parte decree was granted in favor of the plaintiff, my lords.
Ex parte order.
Ex parte order. And suit was filed after 7.5 years of the agreement. Agreement
So
is that.
711 ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
Swami?
Rejection of plaintiff ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
Alla, we were placed as ex parte. No notice was served upon us. And we were placed as ex parte. After 7.5 years of the agreement, suit came to be filed.
What steps have you taken to get the suit restored?
I have filed a miscellaneous petition,
That is
which is pending adjudication. My
I will direct consideration of that.
Lord, so far as
ಇದು ಬೆಂಗಳೂರದ ಪ್ರಾಪರ್ಟಿ?
ಇಲ್ಲ, ದೊಡ್ಡಬಳ್ಳಾಪುರ.
ಸರಿ ಆಯ್ತು ಬಿಡಿ. ಓಕೆ, ಬೆಂಗಳೂರು ರೂರಲ್
ರೂರಲ್.
ಸೋ ಕಾಲ್ಡ್. ಎಸ್.
My lords, insofar as
ಅಂದ ತಕ್ಷಣ BBMP ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ ಇರಬೇಕು ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, rural district. Now, after lapse of 7.5 years, suit was filed seeking specific enforcement of the agreement dated 13/6/2012, my lords.
ಈಗ ಈ ರಿಜೆಕ್ಷನ್ ಬಿಡಿ, I will direct the miscellaneous appeal application to be considered
Yes.
within next 8 weeks. Till then, execution will not proceed.
Lord, may I make a submission?
Expert.
No, may I make a submission?
Yes.
What has been challenged before this honorable court is rescission of contract, my lord. And
that challenge. of
Section
course,
28, my lord.
That challenge is difficult, but since MA is pending.
No, miscellaneous, they are contesting, it has been persuading, but ultimately, my lord, they are dragging on the matter of this miscellaneous petition also.
Dragging
Execution petition, now.
I will direct him to, you have not challenged the miscellaneous here?
No, we have not challenged the miscellaneous here. All
Or
that we
you
have
have not challenged the non-consideration of miscellaneous petition?
No.
ಅದು ಬಿಟ್ಟು ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಏನು ಉಪಯೋಗ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ my lords,
ಈಗ if you resign the contract, everything will go ಅಂತ ಯಾರೋ ಐಡಿಯಾ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವೇ ಕೊಟ್ಟಿರ್ತೀರ.
But
Fairly on the point, my lord, Supreme Court has said, when there is no mode
You are
of
on
payment.
you are on a wrong prayer here. Rescission of contract because it is an after the decree you can't seek all this.
My lords, though there was a direction to pay the balance sale consideration amount within the period of 3 months, which he did not do so. And after lapse of more than 1,000 days, 2.5 years, I filed this application seeking rescission of contract after the decree is passed.
He is the plaintiff, right?
He is the plaintiff.
Correct.
And
Now,
decree is passed on 15/10/2022. And thereafter, 3 months' time was stipulated for
I will
payment of the
permit you
balance
to urge
consideration.
everything in the miscellaneous application.
My lords,
This you can't interfere.
my lords, I'm relying upon some judgments of Apex Court, wherein it was.
Breach of contract leads to its rescission.
Yes.
Correct. No problem.
And the execution petition is kind of continuation of the suit insofar as specific.
No problem, sir. No problem. But the suit is decreed already.
Suit
All
is
right,
decreed.
suit is decreed and there is a direction in the suit, whatever, 1, 2, 3. You have filed an application seeking recall because it is an ex parte decree.
Yes, ma'am.
We'll direct that to be considered if that is here. Otherwise, rescission difficult.
I'll take your lordship to, I have already placed it before the court.
Now, what was the direction?
Direction,
Not to deposit it before the court.
What is the decree of specific performance?
yes, my lords. Your lordship would find in page number 32, wherein the operative portion of the decree has been extracted in the application order, my
Please,
lords. My lords, the defendant are hereby directed to execute the registered sale deed in respect of the suit shall properties in favor of the plaintiff after receiving the balance consideration within 3 months from the date of this order.
Balance consideration was not paid?
I was placed ex parte. I was
All
placed
right.
ex parte.
All right. Amal.
So it is a contingent upon the payment of the balance consideration. I was supposed to execute a sale deed.
All right.
My lords, even after the lapse of 3 months, it is not the case of the plaintiff, decree holder, that he has made effort to pay the consideration and get the sale deed executed in his favor. And he kept quiet and thereafter he files the execution petition.
How long did he keep quiet?
After 3 months, he filed execution petition, my lords. And he kept quiet for 1,000 days, more than 1,000 days, 2 years, 8 months.
Where?
To pay the, till now after the order of this, on impugned order, he has paid it before the court. He has paid the balance consideration before the court.
Now
Till such
property
time-
value has increased.
Till such time, my lords, more than that, the agreement was cancelled long back by issuing a notice. By suppressing all these aspects, he files his specific performance suit, my lords.
Well, there's an interim order here.
Interim order is operating.
Interim order is operating.
Oh, understanding ಬರೋ ಏನು ಹೇಳಿದ್ವಿ. List the matter on 10th. Interim order subsisting will continue to the next date of hearing.
Wait,
In preliminary hearing, next.
My lord, matter will be listed on 10th, which interlocutory application or preliminary hearing, my lord.
Preliminary hearing,
Please.
yes.
60.
Respondent number 2 to 6, my lords. Short password, my lords.
Serial number 60, I am appear for the petitioner, my lord. Kindly 1 week time may be granted to take the steps to R7 and verify for the R7 debt, my lord.
Yes, sir, what is it?
My lords, we have filed vacating of the interim order, my lords.
Ah.
May be passed over, my lords. Senior is held up in another court, my lords.
Anjaneya Swami temple, da.
Please, my lords.
Yes, my lord.
We'll take it on 10th. List on 10th in preliminary hearing.
Kindly extend the interim order.
Interim order subsisting would continue till the next date of hearing.
Obliged, my lord.
I may request this matter to be taken up with serial number 143. Both are
All right,
connected.
143. If you reach 143.
It may be tagged minutes and listed another date.
Will 143 one that. First submission first.
62.
I
That's
appeal for yes, my lord.
Wait, urgency idea.
But urgency ಏನಿಲ್ಲ.
So why did you move it?
Lords, it was not moved, my
Oh,
lords.
date.
This date given.
Previous bench date. Anyway, will, can it be on 21st? 21st?
Much obliged.
Yes.
April, my lords.
21st, madam. ಏನದು?
Lords, interim order.
One minute. Thursday, ಯಾವತ್ತು, madam? 18th, sorry. Yes.
Lords, interim order.
That
Interim
will
order.
continue. Interim order. Both. 63 also.
63 also, interim orders to be extended.
Interim
18,
order.
my lord?
18th.
18.
Yes.
Obliged.
64. Preliminary hearing.
For the respondent. In the writ petition, we are respondent, that's why I should tell.
Oh, CRPL stay there.
CRP, I am the petitioner.
CRPL, you are for the petitioner.
For the petitioner.
Yes.
Writ petition only respondent.
You are with Manian, sir.
Yes, my lord, I respect.
Yes.
I have the privilege of.
No, the privilege is all mine. I mean, I'm grateful for the opportunity. Of course, there can be no question about that.
Yes, sir. Then we will hear the CRP first or writ petition?
Anyone. Whatever you.
CRP.
Well, at writ petition, I have a preliminary objection. A writ against the Bowring Institute.
Huh?
The respondent is the Bowring Institute.
CMCPC, civil courts order.
No, my lord. Writ petition is filed directly before you, not a civil court's order. They are asking for a mandamus.
Direct,
My lord.
directly filed.
Yes. Yes, my lord.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರ?
ಇಲ್ಲ CRP ಇಲ್ಲಿ ಬೇರೆ ಆರ್ಡರ್.
Other
CRP is a
directions.
different issue.
CRP is all right.
Writ petition is filed directly for a mandamus.
Mandamus ಈಗ.
Huh.
For what? To consider what?
Issue writ in a nature of mandamus or any other appropriate writ directing the honorable court in OS number so on to dispose of the
ಅದಕ್ಕೆ
application.
ಬರುತ್ತೆ.
That I have no objection to prayer number 1, but prayer number 2. In
ಇಲ್ಲ,
respect to a
convening
general-
ಒಂದೇ ಕೊಟ್ಬಿಟ್ರೆ 2 ಬರೋದೇ ಇಲ್ಲ. Yes.
But
will-
then, for that, my lord,
CRP
you
should
may
be
look
heard.
at the CRP.
ಸರಿ, ಅದಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
Very-
Yes.
Where the problem may kindly be looked at, my lord.
Ah.
CRP, they got an interim order staying proceedings. Where subject matter, general body proceedings is also a subject matter there. One of the relief is sought for injunction restraining not to proceed with the land deal is concerned, which is proposed to be proceeded with the boring club. I may not go there because proceedings are stayed. SGM is convened on 31st Sunday. Therefore, I made a 31st
ಗೊತ್ತಾಯ್ತು.
special general
Yes,
body meeting.
ಆಯ್ತು.
It was convened on Sunday. Thursday, my lord, we viewed the matter at 2:30. Other side have appeared, they said a general body, the next day date is given.
ಆಯ್ತು, ಅದೆಲ್ಲ I know
So
what has
many
happened.
things have happened, I don't want to. Now
No.
we have no remedy so far as making an application before the trial court. In CRP,
You are correct. Suit is stayed. That is why you have filed the
correct,
speedy disposal.
absolutely, that's my submission.
No problem about it.
Correct.
Speedy disposal we will consider. First CRP consider ಮಾಡಬೇಕಲ್ಲ.
Yes.
Yes.
Please look at the plaint, my lord. I am the defendant in the suit. If your
Yes.
lordship will kindly see the plaint, my lord. Kindly see the prayer. My lord, in the CRP, if your lordship will kindly see the.
I am holding the CRP.
Very. My lord, if your lordship, the plaint begins, my lord, at page 15.
Restraint on suspension order.
Declared that the suspension show cause notice unilaterally issued by defendant number 2 to the plaintiff violating the rules and bylaws of the defendant number 1 institution as null and void. Now, my lord, that prayer does not survive at all because we have withdrawn the suspension. We have filed a memo.
Revoked.
Yes, my lord. Not revoked, we have kept it in abeyance, my lord.
Abeyance ಅಂದ್ರೆ ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಬರುತ್ತೆ.
Navagar baro. But we lordship may kindly see the memo that we have filed. Where is the memo?
Yes, sir.
We have filed a memo saying, my lord, that your lordship may kindly turn to last, my lord, there is a memo. I don't know this number. After.
Memo dated
11th of July 2025. Which is this one? This one.
That's.
31st of July 2025.
Yes.
First defendant has wide notice dated 5/7/2025 withdrawn the suspension. So therefore, my lord, it's withdrawn, not even kept in abeyance. So therefore, my lord, so far as the first pair is concerned, it is.
So there is no suspension today.
No suspension now. Now, my lord, kindly see the permanently restrained defendants 1 and 2, their men so and so, from interfering with the free movement of the plaintiff in defendant institution to enjoy them, no problem, my lord, because the suspension was of the membership. Therefore, if he was not a member, he could not come to the club. Now that the suspension has been withdrawn, of course,
So he can have a free walk.
He can have a free walk. My lord, there's no difficulty.
Yes.
Of course, my lord. Like all of us, he should behave himself. Then, my lord, 3.
Yes.
Restraining defendant number 2, who are in hand in glove with defendant number 2, from initiating with the purchase of the land for establishing a boring institute without following the rules and regulations. We have followed. We convened a general body meeting. There is a report filed. General body has passed a resolution. Whatever the resolution is, it will be done. Then nothing more survives. If the general body is wrong, if the general body resolution is illegal, then, my lord, the recourse, of course, my lord, my learned friend knows better as to what he should do. This is not the remedy. That's all that there is in this case. Therefore, my lord, we told the court, please close this suit. And it is in that context your lordship granted a stay. So what remains in this for my learned friend's client to make an application here? This is all the matter, my lord. Kindly see the order that has been passed.
So suit according to you is rendered infructuous.
Completely. On the admitted fact, on the basis, without going into the allegations, prayer A and B definitely goes. See, my lord, in accordance with the bylaws of defendant number 1 institution, a meeting was convened, a resolution has been passed. Now, my lord, that resolution may be legal, may not be legal. That's not the subject matter of the present suit. That has to be independently adjudicated elsewhere if my learned friend's client chooses to do so. So therefore, my lord, there is nothing more that survives in this case. That's all that.
We'll hear it.
Of course.
This suit was instituted on 5/7/2025.
5/7?
2025.
Correct.
The first prayer, my lord, we sought for declaration. That is concerned, my lord, we made an application for injunction also. While injunction is a copy of the application served on them, they made a submission there. They revoked the very suspension order, they withdrawn it. Immediately, we also filed a memo saying that this application for injunction does not serve for consideration. Consequently, the prayer number A is also, of course.
Gone.
If it is not if it is permanently withdrawn, it is all right.
It temporarily withdrawn.
It's only kept in abeyance according to them.
His senior counsel said it is withdrawn.
Yes. Yes.
All right. Even doesn't matter, my lord. If first prayer goes, then, my lord, the prayer C would remain still now. Permanently restraining from, they should act in terms of the so and so. Now, the question would be,
purchase the land.
Yes, purchase land is concerned. This was, my lord, the proposal was there. Then they filed a memo before the trial court saying that the issue have been referred to the high power committee. They are examining the matter. High power committee resolution is now placed before the general body, which was held on 31st 8/2025. There, my lord, nothing whispered about that. What happened in the general body? What is the things we don't know? Nothing is placed before this honorable court. So far as prayer 3 is concerned, my lord, the permanently restraining the defendant number 2 and other members who are in hand in glove with the defendant number 2 from initiating with the purchase of the land for establishment of Boring Institute without following the rules and regulations and bylaws of the defendant number 1 institution, etc. My submission would be, my lord, mere general body resolution itself is not suffice to proceed with the matter. There are other formalities are required to be done. Even, my lord, this prayer is it cannot be considered to become infectious because whether all these things have been followed by rules and regulations have been strictly followed or not. This question still remains for consideration.
Stay is granted on the ground that prayer 1 and 2 definitely have gone.
No, absolutely no grievance at all. No grievance.
Only the third prayer.
Third prayer. Third prayer. Now general body have taken place. Now, my lord, the general, after taking general body also, we could be able to contend before the trial court by placing the material. Court can take subsequent events also, while considering this prayer is concerned in view of the judgment in Simply Corporation case. Now, general body have not taken place before instituting the suit. After instituting the suit, general body have taken place. We could be able to supplement the very general body where decision is taken that is not correct. We can contend before the civil court.
So what is all this about general body?
All the general body, 100 acres, 24 acres.
Oh, this is that 100 acres.
Yes, Bagapalli.
I tell you, Rachel, what has happened. But the committee felt that the facilities at the club are not sufficient to meet the large number of members. Therefore, my lord, it was proposed that we will have Boring Institute 2. Now,
Boring part 2.
Boring part 2. Therefore, it was for Boring part 2, we had to acquire land and do all that. Therefore, that process has started.
Elli boring part 2 ಮಾಡಬೇಕು.
But we are just before, my lord, just before Nandi Hills.
Bagapalli Taluk.
Bagapalli is not before Nandi Hills.
No, before. It is. I tell you, Lord, I show you.
Bagapalli is.
No, it's not in Andhra Pradesh. It's in Karnataka.
Andhra Pradesh ಅಲ್ಲ ಹೇಳಿದ್ದು. ಕರ್ನಾಟಕನೇ. ನಂದಿಯಿಂದ ಆಚೆ ಇದೆ.
Nandi Hills. Therefore, my lord, we had to acquire a large area of property.
How many acres?
To provide for all.
How many acres?
How many?
24 acres.
24. But in any event, that wisdom of the policy has been gone into by number of committees. It has been examined. Now, my lord, we said, okay.
ಈಗ purchase ಮಾಡಾಯ್ತಾ?
No, my lord. We have in fact, a high-powered committee was appointed comprising of 9 other members. They have made a report that was placed before the general body. General body has now taken a resolution, passed a resolution on 31/8. It has to go on. So therefore, that instance of one person, it can't be stopped like this. It may be right, it may be wrong, but that is no, one member cannot say in a members club.
No, but in Bagapalli, 24 acres, 100 crores.
No,
10 crores advance have been paid.
That has also been gone into.
24 ಎಕರೆಗೆ 100 ಕೋಟಿ ಅಲ್ಲ.
No, that has also been gone into. That has also been gone. Anyway, I don't know those details. Those are all matters which is left to the wisdom of the members.
So it is wisdom of the members, true.
Yes.
It is the members' fund in the institution.
Members have resolved it.
So every member has a right to ask.
No problem. There was a general body meeting convened only for that purpose. How else will a society, a members club function, excepting at a meeting convened? Meeting was convened. They have all discussed it threadbare and passed a resolution. Now, my lord, my learned friend's client might have been present at the meeting. He would have expressed it. If he was able to persuade the other members, say, do not. Then, my lord, I'm sorry, my lord. I'm sorry. I'm very sorry, my lord. I'm very sorry.
Petition dismissed.
I know, my lord. I apologize.
Yes.
My lord, therefore, my lord, if my phone is also misbehaving. No, therefore, my lord, if that resolution is wrong, well, my lord, that is an independent cause of action. In fact, my lord, the first principle for any suit is the cause must arise before the action. Here, the suit was filed on 5th of July. My lord, thereafter, my lord, all that he says, please don't do it in accepting following the rules and regulations. We have followed the rules and regulations. Meeting was convened. Resolution has been passed. Now, my lord, if he thinks that the resolution is wrong, it is for my learned friend's client to then, my lord, take appropriate steps.
Sorry, sir.
He should take appropriate steps.
ಅಷ್ಟಲ್ಲ?
My lord, there is an application filed under Order 7 Rule 11 is also pending at their instance before the trial court.
Correct.
Yes. Then, my lord, this issue whether general body it is not a
No,
subsequent.
711 is rejected or what?
No,
It's
no,
not
my lord.
rejected.
My lord, I must tell you,
They
lordship.
sought for a
that-
declaration of your lordship.
I must tell your lordship without wasting your lordship's time. All the order has been passed, we will hear the matter further on Order 7 Rule 11. So, my lord, that can be heard. But in any event, my lord, I ask myself, is this a suit now which is worthwhile taking the time of the court? We have to take the time of the trial court, take your lordship's time. In a 227, my lord, your lordships can always look at it and say, well, having regard to what has happened, none of this survives. And close this so that we save everybody's time. If my learned friend's client, my lord, is aggrieved by any other action that has been taken post 5/7/2025, he has a new cause of action. Who is saying he can't?
My lord, the development which have taken place, whether it is in continuation of earlier things or it's a fresh one. There was a decision by the managing committee to go ahead with the transactions are concerned. When it was complained, my lord, they wanted to suspend me, show cause notice was issued. I resigned from the office of the Adhyaksha, President, on the very same reason. Then the suit is filed, where one of the priorities they are proceeding with the transaction in related to purchase of a property, which is a loss to an exchequer of the club is concerned. Then that player still alive.
What is the market value according to you?
Market value, my lord, at advance 10 crore they have paid, that itself is sufficed to purchase
24 acres.
It appears in Bhagyapalli.
I can produce proof to show what is the guidance value there.
My
There's no
submission-
difficulty.
My lord,
These
my
are all
sub-
matters cannot be gone into in
That's what we are telling. I am not asking your
That
lordship
is why
to go
committee
on.
was constituted.
Just to be gone into there.
Yes.
and said.
Yes,
Trial
exactly.
court
It has been examined by a committee.
Now doors
Of
are
members.
closed by your lordship because of an interim order. Keep it open, we will go there. Trial court will decide.
711 application
How
pending.
do you there?
Yes, man.
ಎಲ್ಲ
That
decide
can be
ಮಾಡ್ಲಿ.
gone into
My
under.
lord, insofar as prior says, my lord, the
A and B ಆಗೋಗಿದೆ.
the only request I have to the court is, my lord, the courts are as it is burdened with so much of work. Now, my lord, when we are on the face of it, nothing survives. I ask myself, is
So I
it-
can't say nothing survives. It is for the court to say, because what is challenged here is something that I can answer, that's all.
I have no problem.
711,
my lord. I
you
have
are-
no,
See, you are here in this CRP.
yes, man.
Calling in question that there is no cause.
Actually, my
Or
lord,
contending that there is no cause.
actually, my lord, I must, my lord, in all fairness tell your lordships, my lord.
711 is
Not even
pending.
that, not
No,
even
your 711 application is pending.
Pending.
His suit, whatever he has said is pending.
So let it
Let
be
the
decided,
court
my lord. I have
decide.
no problem. Let it be decided. In fact, the order, my lord, only says adjourned for hearing. That, I don't think I should, I will not, I can't, well, let it be heard, no difficulty, but it can't be. Now today one writ petition is filed.
Today,
Today, one more, that connected writ petition.
hypothetically,
No, it's there before your lordship.
actually,
Actually fine.
which
That
writ petition?
petition also we sought for direct.
PD disposal.
Yes,
Yes. ನಾನು ಯಾವ್ದು-
our
I
application
thought
to be
third
disposed.
petition is
ಇಲ್ಲ
pending.
ಇದೆ.
We sought
It
for
is
the disposal of our application. I cannot,
I will direct the court to dispose the application in 2 weeks.
very, very.
Yes, but no problem.
As simultaneously hear your application under 711.
Yes.
And we may be given liberty to supplement the pleading
Yeah,
because of.
ಅದೆಲ್ಲ,
such-
yeah, liberty ಎಲ್ಲ ಕೊಡಿ.
I am not,
Subsequent development.
I will not say anything. Both of you have every liberty to
Exactly.
urge anything there.
Exactly.
That has to be kept open at least.
Of that way,
Very-
everything is, where am I closing anything?
No, I'm not complaining.
The reason, my
I-
lord, is the moment your lordship said that is kept open or liberty is given.
Contentions are- Contention and liberties are always
Of
kept
course, my
open.
lord,
I
you
can't
always
say.
say. But the moment your lordship says it, trial court will think, high court,
No,
you know,
whatever, see, this
all
is,
rights of the parties are kept open,
no,
no problem.
what went before the court by the petitioner was suspension. But the case shrouds with suspicion. That's the whole problem.
Yeah, is a suspicion.
Very lightly.
24 ಎಕರೆಗೆ 100 ಕೋಟಿ.
No problem, my lord.
ಬಾಗೇಪಲ್ಲಿ-
We will give
ಅಲ್ಲ,
abundant
ಅಲ್ಲಿ ಕೋರ್ಟ್
material.
ಕೊಟ್ಬಿಡಿ
Exactly.
ಅದೆಲ್ಲ.
Suspicion ಏನಿಲ್ಲ ಇದು. ಇದು ಅದು. Yeah. My lord, it all depends upon the type of glass that my learned friend's clients wears. Color of the
No,
glass.
no, any kind,
Color of glass.
any color will not be 100 crores for 25
But
acres.
we show proof that it is so.
I convey back.
And I will show how much was the offer, how it has been negotiated, Everything will show.
I would
No
convey my
difficulty.
best wishes to Raghavan's client in showing that, my lord.
Yeah, we'll do. I will do it at the appropriate, but nothing new. It is all part of the report of the 9-member committee, which has been filed before the
We
general
don't know,
body.
whatever it is, let the court decide.
That's right.
What strikes to this court is the 2400. ಅಷ್ಟೇ ಅದು ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ.
Disposal of applications, my lord, the general body resolution would not be given effect.
That relief, whatever you want, you seek there.
At least for a week, my lord.
No, I have serious objection to any order being passed, because that would mean that the writ is maintainable against a private club. That cannot be done.
Objection also be
Writ
recorded.
is for speedy disposal, it is
That's all. That's why we
maintainable.
do that. I have no problem on that.
You file an application tomorrow itself, I have
Very
no
well.
problem. Yes.
Very
Because there is nothing before me to say so. The petitioner, first CRP order tholli madam. The petitioner is before this court seeking the following prayer. The heard the learned senior counsel KG Raghavan appearing for the petitioner along with KBS Manian, learned senior counsel MR Rajagopal representing the respondent. The petitioner is Bowring Institute, hereinafter referred to as the Institute for short. They are before the court calling in question the very institution and continuance of the suit in OS 4804 of 2025 instituted by the respondent, the plaintiff. The plaintiff institutes the aforesaid suit seeking the following prayer. What triggered the institution of the suit is the suspension of the plaintiff from membership.
From the membership. The suspension was for membership.
From the
Contemplating inquiry, membership is
membership, contemplating initiation of an inquiry in terms of the rules and bylaws, the plaintiff was placed under suspension. The suspension during the subsistence of the suit stood revoked on a representation being made by the petitioner.
No, we have
But
not.
ಅವರೇ ಮಾಡಿದ್ರ? During the subsistence of the suit, the suspension comes to be revoked on their own volition. The learned counsel, the second prayer was to restrain the defendants 1 and 2, the petitioners herein, not to interfere with the free movement of the plaintiff in the institution and enjoy all the facilities of the club. In the light of the suspension being revoked, the free walk of the petitioner and usage of the facilities in the club would not become an impediment. Therefore, the two prayers that are sought by the plaintiff in the said suit have as on today rendered infructuous. The learned senior counsel MR Rajagopal submits that they are indeed rendered infructuous and would not survive for consideration. The third prayer is to permanently restrain the defendant number 2 or other members with regard to certain purchase of land. The purchase of land appears to have become the bone of contention in the list. Be that as it may, the present petition being preferred on the score that there is no cause left for the plaintiff to continue with the suit is sans acceptance in the light of the fact that prayer C is still subsisting according to the plaintiff. The learned senior counsel for the respondent submits that an application under Order 7 Rule 11 is also filed by the present petitioners, which is pending consideration. Likewise, the application filed by the respondents under Order 39 Rule 1 and 2, the plaintiffs, under Order 39 Rule 1 and 2 is also pending adjudication before the concerned court. In that light, I deem it appropriate to dispose this petition with a direction, these petitions with a direction to the concerned court to answer the application filed under Order 39 Rule 1 and 2 and Order 7 Rule 11 seeking rejection of the plaint, within an outer limit of 2 weeks. With an outer limit of 2 weeks from the date of receipt of the copy of this order. The parties to the list are at liberty to seek any appropriate relief from the hands of the court. Yes. Ordered accordingly.
IA1, at least for a week, my lord, that resolution should not be given effect. That protection your lordship extended on the basis of the gentleman's submission made by Mr. Manian.
No. What did he do?
Gentleman's submission made by Mr. Manian.
You mean he is not making now?
I'm not saying, let his gentleman character could be continued for a week, I request.
I think it's all right, but let it not be recorded, my assurance, because it should not, how can I say this?
No.
I'm sure nothing will happen.
He can't.
Yes, then I
Mr.
grateful.
Rajagopal can be rest assured.
I'm grateful to Mr. Manian. I'm grateful.
He's right. No, because having done this, I cannot pass that. He's.
Very
My lord
well.
has also
Certainly, I'm not
It is
insisting.
definitely gentleman's submission.
My lord, the scrutiny has to be by the court, and we
Yes.
stand by it.
Yes.
I might be wrong.
No, that's all right.
I pursue to record that because let there may be a compliment, judicial compliment about its fairness.
No
It
problem.
would be beneficial for him.
No, it is already recorded.
That's all. If it is on record, that
is already
compliment having more value than that. That's what I
Sir,
wanted.
I am live. It is already recorded.
Very well, grateful, well. I am grateful.
That is advantage of.
Yes, advantage of being live.
Yes, my lord.
So everything is recorded.
Grateful.
Yes.
Great.
Both petitions stand disposed with
Yes,
this order.
please. Yes.
Yes. Further hearing ಕರೀರಿ. ಎಷ್ಟಿದೆ ಇನ್ನು preliminary ತುಂಬಾ ಇದೆ ಮೇಡಮ್. Preliminary so many matters are there.
Further hearing at 3:30 PM, 161.
Clerks Association ಇಲ್ಲ ಬಿಡಿ. Yes, 162 Saravana.
162.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಅದು 4 o'clock ಇರುತ್ತೆ ಬಿಡಿ. Yes. Continue the list. ಇನ್ನೊಂದು ಫರ್ದರ್ ಹೆಂಗೆ ಕಂಟಿನ್ಯೂ ಆಮೇಲೆ ಕರೆಯೋಣ ಬಿಡಿ. ನಾವು ಕಂಟಿನ್ಯೂ ದ ಲಿಸ್ಟ್ ಅಂಡ್ ಫಿನಿಶ್ ಆಫ್. Yes.
My lord. In an execution petition, executing court reserves a liberty to the decree holder to file a FTP proceeding without any decree in his favor. The operative portion at page 39, my lord.
What is being executed?
My lord,
What is being executed?
he got a decree for a specific.
ಈಗಲೇ ಡಿಗ್ರಿ ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ ಆ ಡಿಗ್ರಿ ಇಲ್ಲ ನಂದೊಂದು ಡಿಗ್ರಿ ಇದೆ ಆ ಡಿಗ್ರಿ FDP ಹಾಕಿ ಕ್ಲೋಸ್ ಆಗಿ ಹೋಗಿದೆ ಆ ಡಿಗ್ರಿಯಲ್ಲಿ FDP ಹಾಕುವಂತ ಈ ಲಿಬರ್ಟಿ ಕೊಡ್ತಾರೆ
ಅದು ಹಾಕ್ದಾಗ ನೋಡ್ಕೊಳ್ಳೋಣ ಬಿಡಿ.
ಅಲ್ಲ ಆ ಲಿಬರ್ಟಿ ಕೋರ್ಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕೋರ್ಟ್ ಇಸ್ ನೋ ಪವರ್
ನಾಗರಾಜ್
ಬಿಯಾಂಡ್ ಡಿಗ್ರಿ ಮೇಲೆ
ಹೂ ಇಸ್ ರೆಸ್ಪಾಂಡ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇರ್ಲಿಲ್ಲ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲ ಅಂತ ತಾವು ಇವತ್ತಿಟ್ರಿ ಇದನ್ನು
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಫ್ ಎನಿ ಅಂತ ಹೇಳಿ.
ಹೌದು ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅವರು.
There is no representation on behalf of the respondent. In the event there would be no representation, appropriate orders would be passed list on 12th. Yes, next.
66.
I have served the copy to my learned friend who is appearing for the defendant in trial court, my lord.
In suit for?
Suit for declaration and possession.
Why are you here?
My application for impleading application filed by the second defendant has been allowed on 1/6/2023, my lord. She is my ex-wife.
Ex-wife?
Ex-wife.
Barli bidi.
Allah, the property purchased
belongs
by-
to present wife.
Not present.
Husband obre tane? Yes.
See, myself and my sister have purchased the property out of 8 acres.
Oh, you did not marry again?
ಇಲ್ಲ.
So, ಹೇಳಿ.
ಆಕೆನೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ಟು she has impleaded. So against that I came to this order.
Suit for what?
Suit for declaration and possession, my lord.
Who is the defendant?
First defendant is my ex-mother-in-law.
Ex-mother-in-law. Oh. ನೀವು ಬರೀ ಮದರ್ ಇನ್ ಲಾ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗ್ ವೈಫ್ ಬರ್ಬೇಕು ತಾನೆ?
ಅವರಮ್ಮ ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಅಲ್ಲಿ ಇದ್ ಮಾಡ್ತಾ
ಇದ್ದಾರೆ. ಇಬ್ರು ಇರ್ಲಿ ಬಿಡಿ.
2009 ಇಂದ ನಾನು ಒಂದು
How can you permit only the mother-in-law, sir? Wife also should come. Wife
ಡಿವೋರ್ಸ್
first.
ಆಗೋಗಿದೆ. ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. 498 ಪೆಂಡಿಂಗ್ ಇದೆ. ನಂದು ಅದರಲ್ಲಿ ಕಾಫಿ ತೋಟ ತಗೊಳ್ಳುವಾಗ ಫಂಡ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ she has also impleaded.
ಫಂಡ್ಸ್ ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅವ್ರು ಹೇಳೋದು ಥ್ರೂ ಬ್ಯಾಂಕ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ, ಬಟ್ ದೇರ್ ಇಸ್ ನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಬಟ್ ದಿ ಒರಿಜಿನಲ್ ಸೂಟ್
Purchase ಮಾಡಿದ್ದು ಯಾವಾಗ?
2009 ಮೈಲ.
ಮತ್ತೆ ಫಂಡ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮದರ್ ಇನ್ ಲಾಗ್ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಅವ್ರು ಅಲ್ಲಿದ್ದಾರೆ, ಅಲ್ಲಿದ್ದಾರೆ.
Possession
ಪವರ್
ಇದ್ದಾರೆ.
ಆಫ್ ಅಟರ್ನಿ ಕೊಟ್ಟಿದ್ದೆ ನಾನು. ಲೇಟರ್ ಆನ್ ಐ ಹ್ಯಾವ್ ಕ್ಯಾನ್ಸಲ್ಡ್ ದಿ ಪವರ್ ಆಫ್
ಪವರೇ ಕೊಟ್ಮೇಲೆ ಮುಗೀತು ಬಿಡಿ, ಇನ್ನು ವಾಪಸ್ ಬರ.
That has been misused by that lady by taking a crop loans out of 14
ಎಷ್ಟು ಎಕರೆ ಇದೆ?
8.5 acres ಮೈಲಾಡ್.
ಈಗ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
ಸ್ಟೇ ಅಲ್ಲಿ ಏನಾಗಿದೆ 23/9 ಇಟ್ಟಿದ್ದಾರೆ. ಐದರ್ ಐ ಶುಡ್ ಗೆಟ್ ದಿ ಸ್ಟೇ ಆರ್ ಐ ಹ್ಯಾವ್ ಟು ಸ್ಟೆಪ್ ಇನ್ ಟು ದಿ ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ಫಾರ್ ದ ಟೈಮ್ ಬೀಯಿಂಗ್, ಬಿಕಾಸ್ ಮೈ ಸೂಟ್.
ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ಸರ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
ಆಗಿದೆ ಸರ್.
The learned counsel for the petitioner submits that the counsel for the respondent has been served. The petitioner institutes a suit in OS
53 of 2021.
53 of 2021 seeking declaration and injunction.
Possession.
Declaration and possession. The correct injunction. Declaration and possession. The respondent, the defendant is one Srimati Jyoti, said to be the mother of the second respondent herein. The second respondent is said to be the wife of the first petitioner, and the marriage has ended in a divorce. But the land that is said to be belonging to the petitioner is in the custody of the respondents. Therefore, the suit for declaration. In the said suit, the wife of the wife that divorced, former wife of the respondent, ex-wife of the first petitioner, files an impleading application on the score that the mother-in-law, her mother, is made a party. The court allows the application. The matter would require consideration whether the second respondent would be a necessary party or otherwise. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List on 19th.
67.
That's 67, that's the
Tender.
notice, dedication notice.
Alla, idu compounding.
Yes, man.
Compound. Because that and
Yes.
The learned ASG wanted
We'll
to be
dispose
present.
it.
My lords, it's come up about 6
We'll
times.
dispose
already.
it, sir.
My lords, may
Dispose,
pass this
yes.
matter over till 4:30. The ASG wanted to be present for the.
ASG wants to come.
Yes, my lords.
Why?
He's in Court Hall 1. He
I'll
wanted
dictate
to-
in the chamber. He wants
wanted
to
be
come.
present for.
My lords,
yes,
may I
lords.
may I respectfully make a submission, my lords? Both parties have
Of course,
already
sir.
filed.
We agreed on that. No problem.
Yes, my lords. We've already
Only
filed.
compounding. I am not going to restrict his powers on initiating any other proceeding except this compounding.
My lords had already expressed that prima facie view during the hearing that you will not comment on.
Anyway, we'll
possibly
see the
not.
timestamp and check.
My lords, there's also another prayer in the same, in both the writ petition, my lords, to consider the application to shift the registered office of both of the entities.
That
in
was
both the
not
writ
agreed
petitions.
upon.
My lords, that was also argued on that day, my lords.
Argued
Actually,
but not agreed.
your lordships had said your lordships might give them 3 weeks instead of the statutory period of 15 days.
We'll see. Yes.
My lords, both sides have already filed the written submissions. Your lordships may
My lords,
reserve.
he filed it, but the ASG had actually, because this is the third time it will be passed over. If it's passed over to the next day, NC wanted to ask if you could pass it till 4.
My lords, it's always a
He's in
privilege
Court
to
Hall 1,
assist
my
you
lords.
during
He'll come
dictation, my
here.
lords, but this matter has come up about 6-7
Just till
times
4:30,
just
my
for
lords.
dictation, my lords.
No, sir. It has come up. That's all. No
Very well.
dictation.
Third consecutive day, my lords. He'll be out by 4:30.
Take it as disposed. Let him come. We'll see. Yes. Next. Both.
68.
The last occasion, my lords had permitted me to serve copies of the petition on the council.
Interim order there.
We have served copies.
List after 2 weeks. Interim order subsisting, awaiting the representation of the
Interim order
respondent.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
When ಕೇಳಿಲ್ವಾ?
Because
Awaiting the
my
appearance of the
application
respondents. List the
in
matter.
terms of sale warrant has been rejected.
List after 2 weeks. Interim order. Sorry. List after 2 weeks. Yes. Next.
69.
for the petitioner, the dispute is between the land tribunal.
Learned counsel so and so undertakes to enter appearance for the respondent. Registry to print the name of so and so is appearing for the respondent.
The matter
Interim order there.
land tribunal.
I received the papers today afternoon, my lord.
Oh, this transfer to the land tribunal.
Yes.
The section 10
Dispute
application,
is there, madam.
in an OS, they have filed application under section 10. In view of the pendency before the land tribunal, they want to stay the OS.
Oh, yes, yes. List on 22nd objections, if any, by then. Next.
70.
Place synopsis on record. So there, madam. Let's go.
Early synopsis. Suit for?
Partition.
Why are you here?
Okay, ಇನ್ನೊಂದು copy there.
Synopsis.
Ticket. Let's go. Let's plain scheduled property measuring 22.79 cents. Petitioner and others respondents filed a suit for partition. Then, my lords, on 31/7/2003, suit was decreed holding that plaintiff and defendant number 1.
2003.
Correct.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ನಡೀತಾ ಇದೆ?
Lords, final decree proceedings has been initiated.
ಯಾವಾಗ?
Lords, final decree proceedings pending consideration.
Who are you?
My lords, I am one of the plaintiff in the original suit.
What is the problem now?
Lords, the problem is this. In the final decree proceedings, my lords, commissioner has came to be appointed.
So what?
There is no dispute with regard to the appointment of court commissioner. Court commissioner submits the reports that the property is not divisible. Therefore, it has to be sold. The FDP court has accepted the commissioner report holding that the properties cannot be divided.
Auction ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ.
Auction ಮಾಡ್ಲಿಕ್ಕೆ order ಬರ್ದಿದ್ದಾರೆ.
3 and 4 ಪ್ರಕಾರ you want to
Yes,
purchase it.
my lords, I filed a memo before in the FTP proceedings saying that
First option
53
ನಿಮಗೆ
people,
ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
yes. That is one
Under the
thing.
Partition Act.
Under the Partition Act, because major shareholders can always retain the property.
ಇವ್ರು ಯಾರು?
My lords, he is a person who is contesting, saying that, my lords, the property should be auctioned. Because what, my lords, kindly have a look at this.
So first option ಇವ್ರಿಗೆ 3 and 4 of the Partition Act.
Yes.
My lords, in addition to this, the court commissioner has been assisted by a private surveyor, where no permission has been secured from the court, my lords, before taking the assistance from the private surveyor. My lords, private surveyors, my lord, holds a digital survey.
ಇಲ್ಲಿ stay ಇದೆಯಾ?
There is a stay of the proceeding.
Yes.
Kindly see, my lord, with page number 288, my lord.
List the matter on 24th.
Right.
Interim order subsisting will continue till the next date of hearing. You accept for the sale, we will close it. He has a right to seek for
To retain the
right of
It is
first
a extent, my
3
lord,
and 4.
ಅಲ್ಲಲ್ಲ 10 extent ಇದಾವೆ property, 10 separate properties. My lord, each property is having a minimum extent. My lord, he wants to keep the certain survey numbers to him, remaining value ಇರಲ್ಲ. So that is what he wanted to make it. My lord,
It is ultimately indivisible, impossible to divide.
My lord,
That is accepted. Now one chunk ali one should sell the property.
please, my lord.
If you want to keep something and sell something, that's also difficult.
Remaining extent, my lord, it will not have any value because it is by the side of the road, it is there. Naturally, he
You
will.
take everything.
No,
My lord.
the extent is, it is a compact block, extent is
My lord,
22 acres and odd.
Different
Well,
survey number,
53 people who
different
are-
survey numbers,
Coffee
my lord. It is
plantation.
not single survey number, 9 survey numbers.
Agricultural land.
Agriculture.
Land.
53 people want
Alla.
to retain the property. My lords,
ಅಲ್ಲ
the
ಅದರಲ್ಲಿ
court is well discretion
certain
to retain-
petitioners, my lord, they have filed a
They want to
memo
sell the
for
property,
withdrawing
there
the
is no
petition.
dispute.
ಆಯ್ತು, we'll see.
Let's-
ಇದೇನ್ 2033 ಅಲ್ಲೂ ವಾಪಸ್ ಬರುತ್ತೆ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
71.
Last occasion, I have already served the notice to the trial court advocate, my lord.
Suit for
Court for declaration.
Huh?
Declaration, my lord.
application.
Application, Order 1, Rule 10, my lord.
Whom did you want to implead?
But the petitioners, my lord.
You are the impleading
Please,
applicant.
my lord.
Who are you?
And whereas regarding defendants, respondents are only our neighbors of the property, my lord. They are colluded with government officials, they have transferred the cost in the name of themselves. I am in positions last 20 years, my lord.
The petitioners awaiting the representation of the respondents who have been served in terms of an order dated 18/8/2025, lest the matter on 24th, further proceedings before the concerned court shall remain stayed. On the score of the submission of the learned counsel for the petitioner that they are the necessary parties to the list, as they are in possession of a property which is now the subject matter of the suit, where declaration is sought since 20 years. Yes.
72.
Next.
And for the petition, already served the copy to the trial court advocate. His name has been
Shona.
shown.
Madan Gopal.
Madan Gopal.
ಏನು ಹೇಳಿ?
ಅಲ್ಲ ಇದರ it is a simple suit, my lord.
Simple suit.
ಅಲ್ಲ ಸಿಂಪಲ್ ಅಂದ್ರೆ ಇಂಜಂಕ್ಷನ್ ಸೂಟು. ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ದ ಪ್ರಾಪರ್ಟಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು ವೆಳ್ಳಿಯಮ್ಮ. ವೆಳ್ಳಿಯಮ್ಮ ತಮಿಳಿಯನ್ ವೆಳ್ಳಿಯಮ್ಮ.
ಅದು ಗೊತ್ತಾಯ್ತು ಹೇಳಿ.
ಅದು ಆದ್ಮೇಲೆ ವೆಳ್ಳಿಯಮ್ಮ ಹ್ಯಾಸ್ ನೋ ಇಶ್ಯೂಸ್. ಅವರ ಅಕ್ಕನ ಮಗಳಂದ್ರೆ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ಮಿಸ್ ಮಂಜುಳಾ ಸಾಕ್ ಮಗಳಾಗಿದ್ಲು. ಈಗ ಮಧ್ಯದಲ್ಲಿ ವೆನ್ ಶಿ ವಾಸ್ ನಾಟ್ ಕೀಪಿಂಗ್ ಗುಡ್ ಹೆಲ್ತ್.
Who was not keeping good health?
That lady ವೆಳ್ಳಿಯಮ್ಮ.
All right.
1974 ಅಲ್ಲಿ ಅವ್ರು ಕೊಂಡ್ಕೋತಾರೆ ಸ್ವಾಮಿ. ಅವರು 2009 ಅಲ್ಲಿ she got the
suit injunction
ನಾನ್ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದ್ದೀನಿ. ಗಿಫ್ಟ್ ಡೀಡ್ಸ್ ಇದೆ, ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅಪ್ ಆನ್ ದಿ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ.
ಗಿಫ್ಟ್ ಡೀಡ್ ಡೇಟ್ ಏನು ಸರ್?
ಗಿಫ್ಟ್ ಡೀಡ್ 2019 ಒಂದಿದೆ, 2009 ಒಂದಿದೆ. 2009 ಒಂದು, 2019 ಒಂದು.
ನೀವು ಯಾರು?
ನಾ ವೆಳ್ಳಿಯಮ್ಮ ಅವರ ಸಾಕ್ ಮಗಳು ಅಂತ.
ಕೇರ್ ಟೇಕರ್.
ಕೇರ್ ಟೇಕರ್ ಅಂಡ್ ಆಲ್ಸೋ ಡೈರೆಕ್ಟ್ ರಿಲೇಟಿವ್. ರಿವರ್ಷನರಿ ಇದ್ರಲ್ಲಿ ಅವ್ರ ಅಕ್ಕನ ಮಗಳು ನಮ್ದು.
ರಿವರ್ಷನ್
ಅಲ್ಲ, ರಿವರ್ಷನರಿ ಇದಕ್ಕೆ ಹೋದಲ್ಲಿ ಸೆಕ್ಷನ್ 15 ಆಫ್ ಹಿಂದೂ ಲಾ, ದೇ ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ಡ್.
ಕೇರ್ ಟೇಕರ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್.
ಕೇರ್ ಟೇಕರ್ ಅಲ್ಲ, ಕೇರ್ ಟೇಕರ್ ಮದರ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್ ದ ಫಸ್ಟ್ ಕ್ಲಾಸ್ ಲೀಗಲ್ ಹೇರ್ ಅಂತ.
ಅದೊಂದೇ ಬಾಕಿ ಇರೋದು. ಕೇರ್ ಟೇಕರ್ ನ ಲೀಗಲ್ ಹೇರ್ ಅಂತ ಮಾಡೋದು ಒಂದೇ ಬಾಕಿ. ಎಸ್.
ನಾಳೆಗಿದೆ ಸರ್, ಲೆಟ್ ಇಟ್ ಬಿ.
ಇರ್ಲಿ ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ ಲೆಟ್ ಇಟ್ ಬಿ ಸ್ಟೇಡ್ ಅಂತ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್.
The awaiting the list the matter on 24th. Yes.
ಅಲ್ಲ ಸ್ಟಿಲ್ ದೆನ್ ನಾಳೆಗಿದೆ ಸರ್. ನಾಳೆ
ಕೇಳಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಅವರು ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ ಹಾಗೆ ನಮ್ಮ ಕ್ಲೈಂಟ್.
ಅದು ಇವನ್ ಅದರ್ವೈಸ್ ನಾನು ಹಾಕ್ತೀನಿ ಈಗ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾರೆ. ಎಸ್ 24th
ಆಗ ಕೇಸ್ ಅಲ್ಲ ಸರ್ ಅದರಿಂದ.
ಅದಕ್ಕೆ 24th ತಗೋಣ. ಎಸ್.
For petitioner, my lord, there is senior engagement. Senior was present at the court morning. Now he had gone to Delhi, so accommodation next week any day.
What's the matter? Where is your file?
It is a suit for.
File is with senior. Yes.
And eviction.
Suit for?
Arrears of rent and eviction.
You are the tenant.
No, I am the
owner. Claims to be the owner. And
you are the tenant.
I'm supposedly the tenant.
Both of you are in doubt. Who are you?
Your Lordship, we had assumed that he was the owner and we were paying him rents. Then the Muzrai department issued a notice stating that is not the owner. We are the owners of the property.
Government property.
And therefore,
Muzrai temple.
No, it's a mutt. And the mutt, the last pontiff of the mutt had given it to the Muzrai department and for the successor for almost now 90 years now. But these people claiming to be the owner have been squatting in these premises. There are already litigations between the Muzrai department and them. They have written to the Muzrai department to consider them as a tenant. In that being the case, now to ask for me to pay rents to them, that has been rejected by the lower court, and rightly so, with all the documents seeing that the lower court has held that even assuming you can't even be a sublessee.
Yav temple is?
Mutt, Your Lordship.
Yav mutt is?
This is the Goduraya mutt.
Under the control of Muzrai department.
Under the control of?
Muzrai department. Your Lordship, in my objection statement, I filed all the documents. Now I have to pay rents to the government, not him. And therefore
Don't pay.
No, that is not the issue. Now their application has been rejected by the lower court, stating
Seeking
that
payment of rent.
seeking payment of rent, stating that you are not the owner. So the question of they depositing rents
So
in
the
your name does
interregnum
not.
illa alle suit nadili.
Yes,
We'll close it.
Please.
My lord, there is an order by this honorable court.
ಅದು ತೋರಿಸ್ಬಿಡಿ ಅಲ್ಲಿ.
In WP 27453.
Page.
543. This honorable court only has.
Page.
I will read the order. Page number 34, my lord.
Nande order.
Of this honorable court.
Have you seen this order?
I have seen this order, Your Lordship.
No, there appears to be some observation in RFA 97
Correct.
of 96 saying that government is not in possession of the property. A government does not hold, it's not a Muzarai temple, Muzarai property.
Your Lordship.
Where is the order of declaration? Under the act?
Objections.
Under the act, objections, Allah. What is the date of declaration?
Your Lordship, one is at page 15 and one at page 29, Your Lordship.
One moment, madam.
Objections.
Objections, I am there only.
And this, and at
15/3/1987. Unauthorized, it has come to the notice of the government that VC Renukaradhya is unauthorizedly collecting rents at few shops which he has few rooms which he has converted into shops. Action be taken under the public
The
premises.
mother and the son, Your Lordship. At page 30 is the Supreme Court order. Here there is one.
I'm not going to interfere with this order, sir. Alle suit tirman agli. Suit ಯಾವ ವರ್ಷದ್ದು? Suit ಯಾವ
They
ವರ್ಷದ್ದು?
have filed a suit before the trial court.
ಅದನ್ನೇ ಹೇಳಿ.
No,
ಅದು ಯಾವ
there is no
ವರ್ಷದ್ದು?
stay, nothing is there so far.
They have filed a suit.
No.
No, Muzarai department has filed.
Muzarai department file ಮಾಡ್ಲಿ. Muzarai department deliberately they will take all these wrong steps.
Your Lordship, there is a understanding there.
Allah, they
and that is
deliberately take this wrong step of filing a suit for eviction.
Sir, this is a suit.
When it is clearly observed by the apex court that they should be evicted on a public premises.
Correct.
Question of
ಇದೆಲ್ಲ
ownership
deliberate.
does not arise at all, my lord.
Ada-
Here it is only
Let this suit be decided. Yes. The petitioner is before this court calling in question. ಎಲ್ಲಿದೆ order? Mandamus.
The last portion.
Prayer
Page 110.
No. Prayer in the petition is from Mandamus. Mandamus ಅಲ್ಲಿ set aside. ಸರಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. A petitioner is before this court calling in question an order dated 19/11/2024 by which the concerned court rejects the application of the petitioner, the plaintiff or defendant?
Plaintiff.
Petitioner, the plaintiff seeking deposit of rents from the hands of the respondent. The petitioner claims to be in possession of certain shops which are rented out, which were initially rented out by one Sri B.C. Renukaradhya. The petitioner is the wife of late B.C. Renukaradhya. The issue, Renukaradhya, the learned counsel for the petitioner submits that an application was preferred before the concerned court in OS 872 of 2024, seeking deposit of rents, praying for a deposit of rents, taking cue from the orders passed in the RFA or a writ petition, interim order passed in a writ petition which is appended to the subject petition. The learned counsel appearing for the petitioner submits that the petitioners ought to pay rent to to the present petitioner, for they are squatting over the property belonging to the petitioner without payment of any rent. He would submit that payment of any rent. The learned senior counsel Srimati Lakshmi Angar appearing for the respondent would submit that the property the property belongs to the Muzarai department, for it having been declared way back in the year 1980. Initially, rooms were rented out to these petitioners, and those petitioners have converted into the rooms into shops and lent it out. She would take this court through a particular order passed by the passed by the department way back in the year 1987 to prima facie demonstrate that the petitioners are holding the property unauthorizedly. Be that as it may, there is no warrant of interference to the order passed by the concerned court which rejects the application seeking deposit of rents by the respondents to the hands of the petitioner. By the reasons so rendered by the concerned court are cogent and coherent. In that light, the petition lacking in merit stands rejected. All the contentions of both the parties are left open to be urged before the concerned court in the pending suit, ordered accordingly.
Appearing for the petitioners in this matter, my lord. My lord, we had filed a memo acknowledging that we have served the copy of.
What's the matter, madam?
It is a partition suit, my lord.
Application yenu?
The application was for amendment, my lord.
Suit of
2018, my lord.
Issues framed?
Issues has been framed, my lord. Evidence has been led. It has gone. The defendant evidence has also been led, my lord.
Who files an application?
The plaintiff files an application, my lord. We are for the respondents for the defendants in the trial court, my lord. My lord, I would like to humbly submit that there are talks going on for settlement, my lord.
Yes. Interim order called. Learned counsel appearing for the petitioner submits that talks of settlement between the parties are afoot AFOOT. In that light, lest this matter, after 2 weeks, parties are at liberty to move the matter in the event there would be any settlement between them. Yes, next.
Grateful, my lord.
75.
This case, my lord, in the trial court, my lord.
Withdrawal memo idea.
Withdrawal memo hakidini. This suit has been dismissed, my lord, rejected even before issuance of notice. The surface ಆಗಿರೋದ್ರಿಂದ withdraw ಮಾಡಿ ಅಂತ.
Correct. Doubt ಇಲ್ಲ.
ಅದಕ್ಕೆ withdraw ಮಾಡ್ತೀನಿ. Kindly grant me liberty to file a fresh writ petition, my lord.
Liberty is always. Learned counsel of the petitioner seeks leave of this court to withdraw the petition and avail of such remedy as available in law.
Permitted to file writ petition within a period of 4 weeks, my lord.
All liberties available to the petitioner. All liberties available in law is available to the petitioner.
4 weeks alle anta. And it may be observed, impugned order, my lord, should not come in the way to consider my writ petition, my lord.
ಯಾವ impugned order?
ಯಾಕೆಂದ್ರೆ ಅದು ಡಿಲೇ ಮೇಲೆ
ಅದು ಅಲ್ಲಿ ಕೇಳಿ ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. Yes.
ಯಾಕೆಂದ್ರೆ ಅದು ಡಿಲೇ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡೋದ್ರಿಂದ.
The aforesaid observation petition stands disposed. Next.
76.
Respondent, lords, the differentiate amount has been deposited, my lords.
What?
Differentiated amount has been
ಎಷ್ಟು madam?
deposited. 32 lakhs deposit.
ಮಾಡಿದಾರಾ?
Alla, 32 alla, Swami. This is with respect to the 50% of the deposit.
13 lakhs, madam.
For further hearing, only we will.
Oh,
converse
this matter division bench ಅಲ್ಲಿ pending ಇರೋದು.
Oh, liberty may be given to us the balance before the division.
Liberty?
My lord, the division bench had ordered that.
So that I know. I passed this order. What did you ask now?
They have deposited.
Praise time.
ಅಯ್ಯೋ ಇಬ್ರು ಹೇಳ್ಬೇಡಿ.
Arguments ಗೆ one short accommodation.
You praise time, I grant time. Wait. Yes.
My lord, the division bench had ordered that 75% has.
Correct. 75% if the amount would not be paid within 2 weeks.
They had not paid it within 2 weeks.
Division bench will calculate.
We have paid.
How can I interpret division bench order and now say something? Praise time.
Please.
Grant. List after 2 weeks. Yes.
77.
My lord, as per the direction of this court, I have served the copy to trial court.
Suit for
partition in respect of maternal grandfather properties, my lord.
Application.
No application, my lord. In fact, the trial court has denied to mark the certificate copy of the will. I am not a direct beneficiary of the will. My vendor is the direct beneficiary of the will, my lord. This is the will, my lord.
Well, let the respondent come.
My lord, interim order, my lord.
No, sir. Yes. List on 22nd. Yes, next.
78.
In this case, my lord, the publics have been filed this suit for eviction.
Publics?
In the interest of capacity of the public litigation, my lord, against the unauthorized occupants, the suit is came to be decreed. And decree copy is produced also in the page number 66, my lord.
ಈಗ ಯಾಕೆ why are you here?
Directions is given to the deputy commissioner and the tahsildar of Davangere to evict them the respond number 6 to 41s. Thereafter also
Respond 6 to 41.
6 to 41s.
Once.
And thereafter also the tahsildar has came to the trial court and given the undertaken to evict them within 1 month. Thereafter
month.
2 chances have been given.
All right.
Thereafter also they have not been evicted. And they are been dragging the matter, my lord.
You are
And
the complainant, huh?
I am the plaintiffs, my lord. Petitioners are the plaintiffs.
Decree holder.
Yes, ma'am, decree holders. So that the trial court has been rejected the application
For
to,
what?
for order for seeking for the order for arrest the JD them 1, 2, 3s. As because they have not
Who
been
are
complied.
JDs 1, 2, 3s?
Yes, ma'am, as they have not been complied the trial court order, despite they are giving the chances to the JD number 6 to 41 to allow them to continue in the premises, my lord. Therefore, the application is came to be rejected, and further I requested this honorable court as a prayer of this petition, my
Yes,
lord,
sir.
direct the tahsildar,
ಒಂದು ನಿಮಿಷ.
please.
Kindly see the prayer, my lord.
You prayer ಬಿಡಿ ಯಾಕೆ ಅವ್ರನ್ನ evict ಮಾಡಿಲ್ಲ?
JDR 6 to 41 ಗೆ ಇದ್ ಮಾಡ್ತಾ ಇದ್ದೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಕರೆಕ್ಟ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ.
I will get instruction on that.
ಅಲ್ಲ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಒನ್ ಆಫ್ ದಿ ಅಫೆಕ್ಸ್ ಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ಸ್ ಏನಂತ ಹೇಳಿದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್ ವಿತಿನ್ 6 months. Otherwise,
ಏನ್ ರಾಹುಲ್ ಶಾನಾ?
presiding officer.
ರಾಹುಲ್ ಶಾ.
Yes, ma'am. Yes, ma'am. Presiding officer is making to be liable for the answerable for the not
Making for the answerable for the what, sir?
for the non-disposal of the execution petition matter.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಸರ್.
Allah, there, yes, ma'am. I am permitted to read the affairs court judgments at the.
No presiding officer will function ಅಂತ.
That's the only thing is, my lord, the PO has been unnecessarily adjourning the matter and rejecting the application, and not that order is passed on March of 2025, my lord. 4 months has been elapsed, my lord, to the
Yes,
July.
government.
Please, sir.
I'll take this on Wednesday next.
Please.
List on 17th. If no instructions come, order will come. List on 17th. Yes. Yes, Raishwar.
79.
Appear for the petitioner, matters. Respondent. Suit for declaration mandatory injunction, matters. Temporary injunction not to put up construction rejected. Appeal filed, my lords. Appeal rejected. Against that, I am before my lords, my lords. This is a case where, my lords, I had earlier.
Objections are filed.
Objection filed. I have filed vacating stay application also. Construction.
He is a pendent hereditary purchaser against the first defendant.
More or less
Suit for what, sir?
Suit for declaration that the schedule in his sale deed is artificially created so as to encroach upon my property.
That's a matter of evidence.
Therefore, the court said, my lords, in the meantime, my lords, the construction cannot go on. For this reason, my lords, he purchased the property when I had taken an injunction against his vendor. During the pendency of my suit against his vendor, my lords.
And subsistence of the interim order?
Please, my lords, there was an injunction order there and police protection order there in the other suit.
That's the observation of the trial court.
I care some parted matters.
And they're proceeding with
List
construction
on
in spite
10th
of my
in
lords.
under the caption interlocutory applications. Mele Bharat.
Interim order, kindly.
Interim order will continue to the next date of.
Spite of their undertaking, my lords, they're proceeding with construction.
That's not a right submission.
I
That's
can
a wrong
produce- I can
submission.
produce, my lords,
I can
the
file affidavit also.
photographs and the
What we are
report
doing-
made by the
10th,
police.
That's a wrong
Therefore-
submission.
10th.
Great. Sorry, not wrong, incorrect submission.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ. ಎಲ್ಲ ಒಂದೇ ಇಂಡೈರೆಕ್ಟ್. ಇಲ್ಲ KADB.
Yes, my lords, on
ಇದ್ಯಾಕೆ ಇವತ್ತು ಬಂದಿದೆ?
19th matters, on 19th of the previous month, the matter was been listed. I sought for 4 weeks of time. Orally, my lord has submitted on, was given on 23rd.
Supposed to be listed on
of this month.
23rd, my lord.
List on 16th.
23rd, put it. 23rd.
23rd.
23rd it was.
List on 23rd.
Lord, one more submission. The order sheet, it's noted as B date may be corrected to KDB.
KADB ಅಂತಿದೆ?
Previous dates.
ಆಯ್ತಾಯ್ತು. Yes. List on 23rd.
81.
For the petitioner, my lord.
Accept notice. I'll accept notice. I'll accept notice.
Yes.
Please.
Learned Counsel A. Chandrachud accepts notice for the respondent. ಯಾರಿಗೆ Chandrachud?
Both respondents. Both respondents.
R4 ಈಗ?
ಅಲ್ಲ ಇಬ್ರೇ.
ಇಬ್ರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೆ. What's the matter? Why are you here?
My lords, we are aggrieved with the order passed on the interest calculation. I'm the decree holder, my lords, before the trial court.
Then let him come. Yes. File objections if you want.
I'll do.
List on 24th. Objections if any by then.
Please, ma'am.
Next.
82,
I appear for first respondent. ma'am.
Suit for injunction, bare injunction, my lord. The respondent filed 39 rule 1 and 2. The defendant filed application 39 rule 1 and 2, my lord, allowed. Then I have filed MA is rejected.
Concurrent.
Yes. The respondent is the defendant, my lord. The defendant is not maintainable to 39 rule 1 and 2, my suit. Full bench judgment, my lord. The suit is a separate suit file ಮಾಡಬೇಕು.
Appeal ಹಾಕ್ಬೇಕು ಅಂತ.
ಅಲ್ಲ, separate suit file ಮಾಡಬೇಕು. Counter claim along with 39 rule 1 and 2 is not maintainable, my lord.
Doubtful.
I have filed the suit for injunction, my lord.
Let me see. List on Monday in preliminary hearing.
Copy ಕೊಡಿ sir.
83,
I appear for the petitioner. In the last occasion, my lord, that I have been directed to serve copy and the plaintiff counsel.
Sir ಮಾಡಿದ್ದೀರಾ?
The plaintiff counsel is no more. That the plaintiff is not.
Hand summons ತಗೊಂಬಿಡಿ ಹಾಗಾದ್ರೆ. Who is the contesting
The
respondent?
contesting now, my lord, is the respondent number, the defendant number 2 and respondent number 1. They are 1 to
Partition?
4.
Suit for partition. Why are you here?
That some defendants are no more, my lord, but without bringing the LRs, the suit is being prosecuted. That's only. Earlier, I filed an application to transpose. At that time, the plaintiff opposed. That my application rejected. Now the plaintiff
Will
is
you
not
serve
coming.
by way of hand summons?
Please, my lord, that to the
Contesting defendants.
contesting defendants, I will serve.
The learned counsel for the petitioner is permitted to serve the contesting defendants hyphen defendant numbers.
1 to 3, my lord.
ಬರ್ಕೊಂಡ್ರಾ madam?
Defendants 2, 3, 4. But one is no more. The
2,
LR.
3, 4.
2, 3, 4.
List the matter on 17th.
Oh, bless.
Preliminary hearing. Next.
84,
Appear for my lord.
It is a family dispute, my lords.
I filed
The
application
defendants,
for vacating stay.
Suit for?
injunction, my lords. Defendants are the stepmother and stepbrothers of the plaintiff, my lords.
Hmm.
The family had undergone a partition back in 1989, my lords.
Hmm.
This suit is for injunction to restrain them from interfering with my allotted share of the partition, my lords.
That's what is challenged now?
My lords, the learned trial court refused to grant ad interim injunction on the
Now
ground
both
that,
are represented. Go there.
my lords, with the status code, I can,
That will continue for 4 weeks.
please, my lords.
My lord, even suit summons are the step suit summons, my lord, they have approached the disarmed court. Even process also are not paid.
We'll see. 4 weeks. Now you enter
Literally,
appearance
there
there.
is no property belongs to them. That has
ಅಲ್ಲ
been.
ಅಲ್ಲಿ sir. I'm not, ಈಗ ಕೊಟ್ಟಿರೋದ್ರಿಂದ we'll just continue it for 4 weeks.
Because in my suit, there are already injunction against them. In
Let
respect
the
of
court
very same
consider
property.
everything.
Even I was having an injunction.
The petitioner is before this, petitioner is the plaintiff, institutes suit in OS 3330 of 2025 seeking injunction,
Injunction.
for injunction. He is at the doors of this court on the score that the concerned court refuses to grant ex parte temporary injunction, answering an application under Order 39 Rule 1 and 2 of the CPC. This court, in order to protect the interests of the petitioner, had directed the parties to maintain status quo in terms of the order dated 18/6/2025. The respondent has now entered appearance. In the light of the respondent entering appearance, I deem it appropriate to
In service ಆಗಿಲ್ಲ notice better, only myself. Others are.
which respondent?
I appear for respondent.
So entered appearance. In that light, I deem it appropriate to dispose the petition, directing the concerned court to consider the application that is pending under order filed under Order 39 Rule 1 and 2, seeking temporary injunction. In the after hearing all the parties to the list at any rate within an outer limit of 6 weeks from the date of receipt of the copy of the order. In the light of the interim order of status quo directed to be maintained by an order dated 18/6/2025, the same would continue till continue for a period of 6 weeks from today. Yes.
Grateful.
All contentions.
All contentions of both the parties shall remain open to be heard before the concerned court. Next, ordered according.
Petitioner by me. The RFA, which is pending, is posted for final argument on 15th
Then
15th of this month.
list the
before
matter on 24th. Yes, next.
86.
Each time in the granted, I need to produce the acknowledgement for having acknowledgement ನಾನು produce ಮಾಡಬೇಕು ಸರ್ವ್ ಆಗಿದೆ
Learned counsel for the petitioners entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ sir. ಅದು
Petitioner seeks a week's time to file an acknowledgement of service of notice upon the respondent. List on 17. Next.
please
87.
appearing for the petition appellants, Your Honor. This is an execution petition filed before the commercial court. Now, the issue is that, only the JDR 1 and the respondent are the parties before the arbitration. Now, 2 to 9 are being added by the commercial court. Now, what is happening?
The execution.
Execution, yes.
Why?
Execution petition only.
In the execution, why they have added? They are added.
Because, the JDR is no more, that got merged with JDR 4. Transferring company is JDR 4. Now, now what happened, on 22nd of this month, last month, I filed another application requesting the court to remove JDR 2 to 9. Now
That is rejected.
No, that is rejected, but the court says, no, they are not the parties in the execution petition.
Yes.
So court says they are not the parties in the execution petition because, there is a recent Supreme Court judgment which says.
Who is the contesting defendant there? The respondent?
That is.
Degree holder yaru?
Degree holder, Marula Concepts Private Limited.
Illi yaru, sir?
Respondent, Your Honor.
Which respondent, sir?
1 to 9 are the petition
yes.
appellants.
You serve on the respondent. What is the next date there?
There it is 27 of this month, Your Honor.
27th of this month?
Yes, Your Honor.
September, yes. The petitioner to serve on the counsel who represents the decree holder before the concerned court lists the matter on 24th.
Now the issue is, Your Honor, since 2 to 9 are not parties, now the court itself can take it further. Only thing, the problem is.
You serve on the decree holder and get him, yes.
Now the stay can be granted in the meantime, Your Honor.
27th alva?
27th.
24th is before 27th.
Fine, much all better.
68.
Two matters, not one. The first one, not I present the petitioner. The second matter, not of LB. But I represent the contesting respondent, not on the last date of hearing. Not the counsel for the respondent number 5. But I submitted a detailed report, not your lordship.
LB matter act agagide?
This was a matter where
To save
there
on
is
not
a,
property, where not.
this is a matter, my lords, where beyond the sanction plan, my lords, a construction has been put up, complained by the neighbor. The neighbor has also preferred a suit for injunction. And the injunction was granted as against that. Yes, my lord. So both the matters.
Floors.
5 floors.
5,
Yogesh Naik. So the report is also there to that effect, my lords.
The Anekal Planning Authority.
Exactly.
Yes.
First, please direct.
Yes.
Not, may I just not make one submission? Not the report, my lord, of the Anekal Planning Authority. But idರಲ್ಲಿ the FER, my lord, that is given to us. But may I just not.
ಇದು ನಾಳೆ ತಗೊಳ್ಳೋಣ. I'll just go through it and.
Please.
Yes. Let's tomorrow.
Please.
In preliminary hearing.
Please.
Yes.
Instead of tomorrow, my request on Monday.
ಮಂಡೇನೂ ಆಗ್ಬೋದು.
Please.
ಮಂಡೇನೂ.
Please. Oblige.
ಅವ್ರೇನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಲ್ಲ ಬಿಡಿ, ದಿನ ಇರ್ತಾರೆ. ಅವ್ರಿಲ್ಲಾಂದ್ರೆ ಅವ್ರು ಇರ್ತಾರೆ. ಯೋಗೇಶ್, ಮಂಡೇ.
Please, my lord, I have filed report, my lord, lordship direction given to us.
ಮಂಡೇ ನೋಡ್ಕೊಂಬ. Vikram sir, what is this?
This is number 89, my lords. A suit for partition filed in 2017, my lords. I've challenged an order now, my lords, at the stage of final arguments, arraying me as defendants. Now, the background to this simply is, suit was filed for partition by the daughter of the sole defendant.
Who are you?
I am the sibling of the sole defendant. Now, my lords, earlier there was a partition suit where among the siblings, my lords, FDB proceedings were drawn up. The whole issue, my lords, is with regard to one joint development agreement which were entered into as a family along with the sole defendant with a developer. Now, my lords, after in the joint development agreement, 66 flats were to be assigned to the developer, 24 to the family. I'll just explain this, my lords.
Why
It's
are they
slightly different.
Why are they necessary parties?
They're not, my lords. What has happened is those 66 flats, the developer walked out on us. We asked our brother, would you be willing to invest? We are constructing. He says no. We construct the 66 flats out of our own money. And now, my lords, the daughter of our brother.
That's the mistake you did. Yes. Heard the learned senior counsel Vikram Holygold appearing for the petitioner. The petitioner is before the court calling in question orders passed under Order 1, Rule 10, impleading defendants 2 to 9 on IA 13 in a suit for partition in OS 6066 of 2017. The concerned a perusal at the order of the concerned court would indicate that it is prima facie in error, permitting the defendants to come on record. In that light, the order dated 20th March 2025 shall remain stayed till the next date.
Yes, or could the interim order as prayed for, because we've asked
Proceedings
for proceedings.
Therefore, there shall be an interim order of stay as prayed for at first bed, madam. As prayed for till the next date of hearing, 24th preliminary hearing. Next.
90.
I'm for the petitioners in this case.
Amale.
The notice have duly served to the petitioner respondents.
Yes.
Same as returned to the sender, Your Honor.
Send.
Return to the sender.
Return to the sender.
Please.
Oh. In suit in.
Suit for injunction, my lordship.
You are the husband.
No, my lordship. I am the absolute owner. I'm grandson of the granted property of one Maleshappa Gondir.
Who filed application 1817?
1817 filed by us.
Whom did you want to recall?
For further cross-examination of the defendant, DW1.
What is stage of the proceeding?
For argument.
The
listed on 6-9, Your Honor.
List the matter on 17 in preliminary hearing. Further proceedings before the concerned court shall remain stayed. Yes,
my lordship, the matter is listed in on 6-9 for argument in the trial court.
Say badwa.
Please.
Kotnala.
91.
Yes.
For the respond in this case, my lordships.
Petitioner.
Suit is
next week, my lord.
Why, sir?
Next week, my lord. Council, my lord.
Interim order the next week.
Next week, my lord, any of their file statement of objections.
Small submission, my lordships. Suit is of the year 2006, my lordships. Execution petition is of the year 2011, my lordships.
What is the stay here now?
Execution petition has been stayed, my lordships. Because FDP proceedings is parallelly conducted, my lordships.
My lord, there is a finding, my lord, in the appellate court, please, my lord, that he cannot seek for a specific share is concerned. At earlier point, it is only
just on 10th in preliminary hearing, it is made clear. Vacating stack is there, madam?
Objection, the objections.
The list on 10th in preliminary hearing made clear no further adjournment will be granted in the matter. Interim order subsisting will continue to the next date. Yes.
92.
My lords, I'm appearing for the petitioner, my lords. The
respondent
here is my lord.
Yes, madam.
Only against that respondent. The respondent here in my lord plaintiff filed a suit for recovery of security deposit amount. It was partly allowed in OS number 5796 of 2011, my lords. In page 44, lords may kindly see observation in issue number 2, para 23, my lords, inner page 31. The plaintiff had claimed page 44, my lord, inner page 31, ink page 44. Para 23, my lords.
Yes.
The plaintiff had claimed the interest-free security deposit amount given to the first defendant to 2 occasions and also claimed
future
as
interest.
partly declared in respect of interest, my last. Therefore, I am reading this one.
Yes,
all their claims
restricted 18%.
Yes, 18% except second defendant. None of them have contested the suit. The contents of the second defendant is already rejected by this court under the circumstances. All the defendants 1, 5, and 7 are liable to pay the future interest in the plaintiff is a company registered under the Indian Company Act. Only in respect of interest, my lord. Suit, my lord, in execution petition, they have not taken proper step to other judgment debtors. They have taken only against the D2, my lords. Ink page, kindly see ink page 74. the application was filed.
Hmm.
Yes, my lord. Earlier, sorry, my lord, before that, my lord, in phase 60. In
Yes,
phase
madam.
60, my lord, last steps taken, reissue EP notice to judgment letter 1-3 to 6. 3 dictate holder consent, so and so filed
No,
application under
paid,
21 rule 11.
madam. Have you paid your share?
Yes, my lord, I have paid 1 lakh, my lord. Let me kindly see the order sheet, my lord, which I have produced.
Joint and several.
Giant and server.
ಇಲ್ಲ joint and several ಇಲ್ಲ ಅವ್ರೇನು.
ಎಲ್ಲಿದೆ ಜಾಯಿಂಟ್ ಅಂಡ್
Last
ಸೆವರಲ್? ಎಸ್ ಸರ್.
That
ಬೇರೆಯವ್ರ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಆಗಿ ಇವ್ರು ಕೊಟ್ಟ ಮೇಲೆ ಇವ್ರದೇನು?
I'll file memo of calculation.
ನೋ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
That ಅವ್ರು 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. Only 1 lakh.
ಬೇರೆಯವ್ರ ತಗೊಳ್ಳಿ ಸರ್. ಯು ಡೋಂಟ್ ಸರ್ವ್ ಅದರ್ಸ್ ಅಂಡ್ ಹೋಲ್ಡ್ ಆನ್ ಟು ಒನ್ ಪರ್ಸನ್ ಅಂಡ್ harass him.
You need the degree.
I have furnished the address also, my lord. Now they have filed the application to break open my.
I'll file it in. Second JDR, what is the due? I will file it a memo.
ವಾಟ್ ಯು ಇಲ್ವೇ ಇಲ್ಲ. ಇವ್ರದ್ದು ಏನಿದೆ ಅದು ತಗೊಂಡಿದ್ದೀರಾ, ಬೇರೆಯವ್ರ ಮೇಲೆ ಪ್ರೊಸೀಡ್ ಆಗಿ.
I paid 1 lakh.
Others have served, now appeared.
Others have served, you take, in so far as this petitioner is concerned, nothing.
Adan today, with interest, that calculation 10 lakhs is there.
ಅದು ಬೇರೆಯವ್ರು ಕೇಳಿ ಸರ್, ಇವ್ರು ಕೊಡೋದು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ.
Only 1 lakh has paid recently.
In execution, I will record that he has paid everything, not harass.
Everything he has not paid, only 1 lakh has paid.
ಎಷ್ಟು total?
1, 5 and 7, not on dependent due to.
Correct. 3,26,000 ಫ್ಯೂಚರ್ ಇಂಟ್ರೆಸ್ಟ್ ವಾಟ್ ಎವರ್ ಬೇರೆಯವ್ರ ಮೇಲೆ ಏನು ಇನಿಷಿಯೇಟ್ ಮಾಡಲ್ಲ, ಯಾರೋ ಒಬ್ರು ಸಿಕ್ಕಿದ್ರು ಅಂತ ಮಾಡೋದು.
That we have initiated the proceedings against them, all of
You
them.
continue against them, sir. We will not permit a continuance of proceedings against this person.
Only 1, 5 and 7 only they are seeking. Only interest is on respect to 1, 5 and 7, my lords. That is specific observation in the judgment, not upon the D2.
I will observe that execution cannot continue against this person because it is paid. ಅದು ಬೇರೆಯವ್ರ ಮೇಲೆ ಮಾಡಿ. We will have liberty later. Yes. Nothing.
I'll file a memo.
3,26,000 ಎಷ್ಟು ಜನದ ಮೇಲೆ?
The 6 members.
6 members ಮೇಲೆ.
That two partnership, 4
whatever.
members are the partners.
See, whatever. Now,
members are the partners.
Now 1 lakh is paid. It is not joint and several. That's why I saw it. It's not joint and several at all. Unless you straight away proceed against others, sir. Others ಮಾಡಿ.
That some of the number another partner has appeared now.
Appeared now, you take care of that.
That I'll let that.
Yes. Allowed.
In
so far as the petitioner is concerned, it's execution stands over.
One submission may kindly look into.
Yes, sir.
I filed a memo of calculation as per the directions of the land trial court. That where that 9,84,000 is there.
You have not touched other 5 persons who have not paid anything. And the person who has paid 1 lakh, you are holding on to it. And
When he has paid, may kindly look into me.
If it were to be joint and several, I would have dismissed it straight away. It is not.
Yes. That even 1 lakh, that their share, that only 4 partners. That is, it is not a substantial, that is my submission, may kindly be.
Court also records that share is paid.
It is not that share has been paid. May kindly be looked into that has not been recorded in the trial court.
No, sir. Yes.
May kindly look
18% interest, they only 1, 5 and 7, not upon the D2, my lords. They had made observation in the judgment.
Who is D2?
D2 is my lord, the petitioner hearing.
1, 5 and 7 ಮೇಲೆ 18% interest ಇರೋದು.
Yes, my lords, I am not upon me.
Correct, sir. 1, 5 and 7 ಮೇಲೆ interest at 18%, future 18% ಇರೋದು. How are you holding everything to defendant number 2? Proceed against them. Yes, allowed cost. Next. Already ಇಲ್ಲ ಅವ್ರ ಮೇಲೆ 1 ಲಕ್ಷ ಕಟ್ಟಿದ್ದಾರೆ. Future interest ಅವ್ರ ಮೇಲೆ ಆಗ್ತಾ ಇದೆ.
Insofar as they
petitioner is concerned.
Yes,
correct. Yes, second defendant. Next.
93.
Bring for respondent. File the objections. They for 2 weeks time.
Enter ಮಾಡಿದೆ. Counsel appearing for the respond. ಇದು KSRTC.
Correct.
Yes, sir.
R2 to R5.
ಯಾರಿಗೆ ನೀವು?
R2 to
ಎಲ್ಲಿ
R5.
ಸುರಾನ ಸರ್?
ಸುರ.
ಅದೇ ಯಾರು ತಗೊಳ್ದೇ ಇದ್ದಾಗ ಇವ್ರು ತಗೊಂಡಿದ್ದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. ಅದೇ ಅಲ್ವಾ ಇದು?
Correct. File the objections.
No tenderer came forward to take the premises. He takes and you now wash off your hands. He raised the matter on 19th in preliminary hearing. Objections hakidira? Objections if any by then. Yes. Interim order subsisting will continue till the next date of hearing.
94.
For the petition, I'm not.
In the suit for partition, lots, two applications were filed by the plaintiff and defendants seeking temporary injunction. The application IA number 2, my lord, by the plaintiff restraining the defendants from interfering with the.
Up to 190. Once there is one part-heard matter at 4 o'clock. I'll take that and get back to the list.
Please.
Yes, a 4 o'clock matter.
Further hearing at 4 PM. 163.
Yeah, I'm not raising weight, sir. Part-heard ಆದ್ಮೇಲೆ ವಾಪಸ್ ಬರ್ತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ಏನಿರೋದು ಬೇಡ, ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
One submission.
Sir.
On first, the court pronounced an order.
Yes, sir.
I had no opportunity to access it yet.
Then we'll take it on the next date, on Monday. I'll have it
Tuesday or
uploaded. I will
Wednesday.
have it uploaded tomorrow morning.
Tuesday or Wednesday, if the court.
No
takes up
problem.
it.
Yes. Yes, sir. Tuesday, sir. Ninth ಆಗ್ಬೋದಾ?
Thursday ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ Tuesday.
ಯಾವ್ದು ನಾಳೆ? ಅಲ್ಲ ಮುಂದಿನ Thursday. 11.
ನಾಳೆ ಆಗಲ್ಲ ಅವ್ರಿಗೆ.
Next Thursday.
11th is.
11th.
11 will be all right.
11th, 2:30? 2:30, yes.
2:30.
List on 11th. Tomorrow morning I'll have it uploaded.
Very well.
3:30 ಯಾರು ಇರ್ಲೇ ಇಲ್ಲ.
Sorry.
ಎಲ್ಲಿ ರವಿಶಂಕರ್ ಸರ್ ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಇಲ್ವೇ ಇಲ್ಲ ಮೇಡಮ್.
He's on his legs in court all one.
He's always on his legs in some court. What can be done? Yes. I'll hear the respondent, ask him to come.
My lord, this Lakshmi kindly take up the synopsis, my lord.
Serial number? ಅದೇ ನೆನ್ನೆದಲ್ವಾ?
3:30.
162, my lord.
Yes. Oh, the educational trust. Yes, sir.
My lord, the land in question, my lord, was the subject matter of the land, tenancy before the tribunal, entire 99 acres of land. Then, my lord, in the said proceedings, my lord, the petition made an application to come on record. The tribunal, my lord, synopsis ನಲ್ಲಿ ಸ್ವಲ್ಪ ಲೈಟ್ ಆಗಿ ಹೇಳ್ತೀನಿ.
ಲೈಟ್ ಆಗಿ?
Respondent number 9 synopsis.
Respondent number 9, my lord.
ಹೇಳಿ. ವಿಕ್ರಮ್ ಸರ್ ಯಾರಿಗೆ? All right, yes.
4/7 file.
Then, my lord, the tribunal, my lord, they made an application to come on record on the strength of the trust deed. The tribunal held, my lord, that the trust deed has been created during the pendency of the proceedings. It is null and void, and it does not create any right in favor of the trust. Then they filed a writ petition before this honorable court. They have unconditionally withdrawn the said writ petition. Then, after dismissal of the writ petition, my lord, they filed a suit for declaration. The said suit came to be rejected. Then, my lord, they filed an RFA before this honorable court. Before this honorable court, in RFA, they made an application, my lord, that the matter would be compromised. Then this honorable court remanded the matter to enter the compromise before the trial court. In compromise, my lord, they agreed to take only 6 acres out of 44 acres, and they agreed to leave the rest of the lands to me. Then, my lord, in spite of that compromise, my lord, the said compromise petition was challenged by one of the directors of the Sangha. Then the said the petition came to be rejected. They preferred an appeal before this honorable court in RFA. Then the RFA came to be rejected. Then they approached the SLP before this honorable court, before the honorable Supreme Court in SLP. SLP also came to be rejected. Then, my lord, they filed the matter came back to for the purpose of recording the compromise. They did not pay the court fee. Again, it has been rejected. Then they preferred an appeal before this honorable court. The appeal came to be dismissed. They went to Supreme Court. It also came to be rejected. This is the sum and substance of the matter. Now, my lord,
ಈಗೇನ್ ಪ್ರೇಯರ್ ಇಲ್ಲಿ?
the prayer, my lord, the BDA, my lord, has approved the.
Yes, sir. ಈಗೇನ್ ಪ್ರೇಯರ್ ಇಲ್ಲಿ?
Lords, the Honorable Supreme Court has directed that status quo in relation to this property has to be maintained, confirming the orders of this Honorable Court. Passed in revenue proceedings. Now, that only one leverage was given. That if that order of status quo requires to be, that's between the parties, has to be altered, it should be by an order of a competent court. This is essentially where it stands. Now, there was a suit which was filed. I'll have to take this Honorable Court from the beginning, because ultimately what is under challenge is the BDA now sanctioned the plan in respect of a property which is subject matter of a list in 2 rounds before the Honorable Supreme Court. Both the orders clearly confirms that this is a property not meant for private use.
Oh. Where is that order?
Lords, may kindly see, Lords. My synopsis.
Synopsis ಇದೆ.
Nandu. Lords, if your lords were to take the orders passed by the division bench of this Honorable Court in writ appeal number, Lords, can I just take your lordships to 2-3 other documents, and then can I take your lordships to that?
ಓ ಇದು ನೀವು 1962 ಇಂದ ಹೇಳ್ಬೇಕಾ ಈಗ?
ಏನಿಲ್ಲ, ಅದರೊಳಗೆ 2 ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇನೆ.
ಆಯ್ತು ಹೇಳಿ.
Lords, the property belonging to Rangamma is not in dispute. Rangamma executed will in favor of Putswami, not in dispute. Putswami executed a document in the nature of a trust deed containing certain covenants is not in dispute. People who are opposing me are the persons who are claiming under Putswami.
Putswami has already
done away with this property. Yes. That's essentially what I want to show before the court. So whereas I am concerned, I am the person who is claiming under the documents executed by Putswami. Document is intact, it has not been touched by any courts. Now your lords may kindly see that document itself.
When was this execution? Putswami.
Lords, Putswami has executed this document in 1978, 1/10/1978. Is the date of the?
Any court order confirming that incident?
Yes, this is the very document which has been dealt with, Lords, by the court, which has referred to this. Can I just take your lordships to this document? Lords, by the division bench in the writ petition, writ appeal, which is confirmed by the Supreme Court.
Page.
Lords, that is at page number.
In your synopsis or what?
Lords, it is part of the compilation. Lords, there is a separate compilation.
I am holding the compilation.
Please, in that, your lordships will find the order is at page number. I'll just point out once. Page number 300 and Lords, the order starts at page 277. In the marked portion, Lords, in that, if your lordships were to see the orders passed at page number 287, paragraph number 9.
At this time, at the same time.
At the same time, when it is brought to the notice of the court, the person in whose name the entry is made has no interest in the property, and this property originally belonged to Rangamma, was bequeathed the property to charitable purposes. Unfortunately, because she had no issues, persons appointed as executors and his family members are trying to put forth a claim for the property. Various proceedings are initiated. It is difficult to accept the intention behind all these proceedings is to keep the property or proceeds of the property for charitable purpose. The material on record discloses that everyone is putting forth a claim of proprietary interest in the property in dispute. At any rate, this is not a matter which can be decided with the revenue authorities. At the same time, this court cannot be a party to a situation where the persons who have right in the property can be allowed to continue as the khatadars in respect of the immovable property by virtue of allowing the appeal and setting aside the orders passed by various authorities. In those circumstances, we deem it appropriate not only to set aside the orders passed by the authorities, but to set aside the entries of mutation register, reserving liberties to the parties to adjudicate the rights in competent civil court and seek for mutation entries in terms of the orders passed by the civil court. It was submitted if no RTC is no mutated, it would be difficult for them to protect the properties, as the property is the subject matter of various litigations, and in future there may be claims on the property. To protect the interest of the property, it is not necessary nor is it mandatory under law that the name of the protector should be entered in the revenue records. However, in order to put the record straight, as before us, on one side the appellant and his family members, and on the other side the fifth respondent claiming as the trustees under the trust deed are putting forth their respective claims in the property in question. it is made clear that both of them can initiate or defend proceedings to protect this property, which is actually meant for public purposes.
This is taken to the Supreme Court?
This is taken to the Supreme Court.
What happens there?
Lords, if your lords were to see the operative portion of the order in this, my lords,
SLP is rejected or there is a
Lords,
detailed order?
SLP, my lords, is rejected by only one observation.
Till further order is made by the appropriate court.
Appropriate court.
Which is the proceeding pending now?
Lords, there are no proceedings pending in respect of this property as of
Appropriate
today.
court ante yaake
What
ಹೇಳಿದ್ದಲ್ಲ?
happened? Appropriate court is because if your lords were to see the operative portion of the trial,
No, if there state, see, Supreme Court says, in fact, the order of status quo would be operative till any other proceeding or
Lords,
further order.
if initiated, page 293, my lords, having regard to the above, the last paragraph, lords, what their contention
If any
was-
proceedings are initiated as
Yes.
aforesaid, the same shall be heard and disposed.
Lords, without being, this is essentially,
To
my lords,
order in futuro.
in futuro. Lords, now this order has become final, the order of status quo, the orders, lords, passed by this, by the division bench of this honorable court. Lords, it is very clear that this is a property, clause G.
All right, that I saw, yes.
Lords, now having said this, this is one round of litigation. Now there is one civil litigation also which cropped up. That is very important. Lords, Lords, I wanted to take your lordships to the trust deed, my lords. That is very important because
ನಾಳೆ ಕೇಳೋಣ. Because lot of
this requires some time, my lords.
That is why
Yes.
ನೀವು 1962 ಇಂದ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಿ.
ಇಲ್ಲ, ಇಲ್ಲ.
ನೀವು ಟ್ರಸ್ಟ್ ಅಂತ ತಕ್ಷಣ ಅಲ್ಲೇ
1978
ಹೋಗೋದು.
ಬಂದ್ಬಿಟ್ಟೆ ಆಗ್ಲೇ.
Yes.
78 ಬಂದಾಗ
ಇನ್ನು 50 ವರ್ಷ ಬಾಕಿ ಇದೆ.
78 ಆದ್ಮೇಲೆ ಅಲ್ಲಿಂದ ಮತ್ತೆ 20 ವರ್ಷ ಹಾರ್ಬಿಡ್ತೀನಿ. 98ಕ್ಕೆ ಬಂದ್ಬಿಡ್ತೀನಿ.
ಫಾಸ್ಟ್ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ಬಿಡಿ.
ಅದಕ್ಕೆ.
Yes. Tomorrow.
ಆಯ್ತು. Tomorrow at 3:30 minutes.
3:30.
Please.
3:30 or 4 o'clock. Yes.
4 o'clock. I'll be here.
4 o'clock.
Please.
Interim order ಇದೆಯಾ?
Interim order.
That will continue.
Please.
Madam, interim order. No. ನಾನು ಯಾವ್ದ್ರಲ್ಲಾರು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಅಕಸ್ಮಾತ್ ಇದ್ರೆ 2:30 ಮೋಡ್ ಮಾಡಿ.
30 more matters. Order still number 1, Ajay Kattu.
The order, my lords, ordering notice in relation to my application where I sought for an ex parte injunction is under challenge. I just take your lordships to one document, my lords.
Suit for
injunction. My lords,
39(1 and 2) is not answered.
my lords, they have entered into appearance only now. One is answered. The other one, my lords, he would, my lords, come into my property as a trespasser. Gives me, my lords, a business card. That assumes all the important.
Oh, the defense. Where is that business card?
Business card your lordships will find at page number, my lords, 100. My lords are aware, under the Act, my lords, State Emblems Act, the Ashoka emblem could not be pulled. My sale deed, my lords, is in the year 1997.
Ministry of Defense.
Ministry of Defense. At least department aru ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು.
Yes. The petitioner is a plaintiff, institutes a suit for injunction against Kempanna.
Please, my lords.
Against one Kempanna. Kempanna portrays himself to be the president of LRDE Employees Union in the Ministry of Defense. The business card is attached to the petition, is appended to the petition. The business card on the face of it casts suspicion on its generation. On the basis of the said, alleging that there is interference, the suit is instituted. The interim order is not granted, temporary injunction is not granted, but another, what is the order?
My lordships will find it at page number 28, my lords.
The concerned court
Absolutely
does
no
not
advertence
grant
to the
temporary injunction but issues notice. There, the emergent notice to the respondent. Petitioner is at liberty to serve on the second respondent by way of hand summons. List the matter on 24th. There shall be an interim order of injunction restraining the defendants from interfering with the property of the petitioner till the next date.
Yes, I'm so very grateful.
Yes, next.
Number 2, Shri Kishan GS.
Representing petitioner. But I'm challenged the compromise petition entered before the
Compromise date.
It is dated. Lord,
Compromised in suit,
14.
compromise date.
14/12/2019, my lord. Suit number
377 of 2019.
my lord.
Yes. Who are you?
I'm the
What
defendant.
was
in
the
that-
suit for?
It was a suit for specific performance, my lord.
You are the defendant in the
I'm the
suit.
defendant in the suit, my lord.
You have not signed on the compromise.
My lord, your lordship, kindly see, the plaint is at annexure.
Oh, you said the
completely
defendant is blind.
person. Yes, my lord.
Property belongs to whom?
It belongs to the defendant, my lord.
You are 100% blind?
Yes, my lord. I'm 100% blind.
The certificate ಅಲ್ಲಿ.
Lord, in fact, my lord, the trial court has had the opportunity of examining the witness, the defendant, which is at page number 85, my lord.
Why did you take so many years to challenge it?
Lord, I was not even knowing about the entering of the compromise petition. I was not even knowing about the filing of execution petition. Some other advocate has allegedly filed wakalat on behalf of me.
The petitioner is before this court calling in question a compromise entered into on 20th December 2019 in OS 377 of 2019 in a suit.
Decree date, my lord. That is decree date 2012. Compromise petition is dated 14/12/2019, my lord.
14/12/2019. Correct, 14/12/2019 of in a suit instituted for specific performance. The petitioner's property was the subject matter of the suit. The petitioner was defendant number 2. The petitioner was defendant. The learned counsel for the petitioner submits the petitioner is 100% blind and did not know what was happening in the court, but and on what paper signature was taken. The net result is that the property of the petitioner is now not in his or her, in his hands, owing to the said compromise. Therefore, the challenge to the said compromise, which is entered into before the Lok Adalat, in the light of the said submission, what stay can be granted now? What stay can be notice issue ಮಾಡಬಹುದು ಅಷ್ಟೇ.
Lord, execution petition, my lord. Only
Execution
execution of
ಹಾಕಿದಾರಾ?
sale deed. Yes, my lord.
In the light of the aforesaid circumstance, the proceedings in execution number
7 of 2020, my lord.
7 of 2020 shall remain stayed. The petitioner shall serve on the respondent by way of hand summons and file an acknowledgement. Counsel serve ಮಾಡಿ.
Yes, my lord.
Shall serve on the counsel representing the plaintiff before the concerned court and file an acknowledgement of such service. List the matter.
Lord, interim stay of further proceedings in execution.
ಹೇಳಿದ್ನಲ್ಲ sir. So and so. Further proceedings ಹೇಳಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಡು. Further proceedings till the next date shall remain stayed.
May I seek for hand delivery of the order, my lord.
Why sir?
Monday, it is coming up on Monday. my lord.
Monday ನಾಳೆ ತಗೊಳ್ಳಿ. Hand delivery ಏನು ಬೇಡ.
Grateful.
3, Ajay Nandan.
First defendant suit is filed for permanent
ಯಾವ್ದು
injunction.
ಮೊನ್ನೆ ಒಂದಿತ್ತಲ್ಲ ಸೇಮ್ ಅದಾ Rayo Hospitality, whatever, tell me. Yes.
My lords, may kindly take page 82 for a minute, my lords. This is the prayer which is sought. Prayer, my lords, is to restrain me from selling, storing, displaying any, promoting any beer not manufactured by the defendant.
Oh,
defendant
beer
number 1.
problem. Yes,
Beer.
sir.
My lords, not manufactured by the defendant number 2 using the equipment provided by the plaintiff. My lords, one the microbrewery plaintiff gives some equipment. Defendant number 2 doesn't get the license.
No, you are the defendant, is it?
I am the first defendant. The real dispute is between the second defendant and the plaintiff.
What restaurant are you running?
My lords, I am running a pub called as 18 Commune. Which is called
18 Commune.
Commune.
ಒಂದೆರಡು ದಿನ ಬಿಯರ್ ಮಾರಿದ್ರೆ
My
ಏನಾಗುತ್ತೆ?
lords, it's been, my lords, I'll tell my lords what happened. My lords, based on this, my lords, because it said all encompassing this, kindly see page 64 for a minute. 64. This is the clause on which they are relying on. Page 64, if my lords.
What clause?
Clause 11.
Trio agrees
during
in
the term
terms-
of this agreement, it shall not sell any other craft or tap beer.
What are you selling? Bottle
Lords,
beer?
I am selling bottled beer. Now, my lords, kindly see the bottom of the page.
18 Commune sells only bottle beer?
My lords, I sell.
You don't sell draft beer?
My lords,
Craft beer?
No, I can't, my lords, because the microbrewery which is set up by the plaintiff, from there only the beer has to be manufactured. Defendant number 2 has failed to procure a license for that. There's a separate excise license which is supposed to.
Correct, separate.
I am not, and my lords, I'm undertaking that I will not. Craft beer, I will not. My lords, I'll also.
Only bottle.
Only bottle I want to, my lords. My lords, I'll also maintain accounts, my lord. I'll submit accounts to the trial court, my lords. Whatever I've sold doing this, because my lords are considering ad interim. I will.
How do you know?
My lords are my lords, I didn't say my lords are granting.
Just because it is bottled beer, you think you'll grant?
No, my lords, I said considering. I never said granting. I said considering.
Yes.
My lords, I'll maintain accounts. Put me in some terms, my lord. Entire business.
Petitioner is the second defendant.
First defendant.
First defendant in a commercial OS, commercial suit in commercial OS.
1136 of 2025, my lords.
1136 of 2025 instituted by the respondent plaintiff against, primarily against the second defendant owing to breach of agreement.
Breach of agreement, sir.
Owing to breach of agreements. The petitioner runs, what do you run?
My lords, pub, my lords.
Petitioner runs a pub in the name and style of 1-8 Commune. The concerned court has granted an interim order of stay which would affect the petitioner from selling any kind of beer. The learned counsel for the petitioner takes this court through the tripartite agreement.
Tripartite also.
Takes this court through the tripartite agreement, which with particular reference to clause 11, which reads as follows, page 64, madam. In terms of the said clause, the learned counsel would submit that the petitioner defendant number 2, the first defendant is not.
I am the first defendant. Second defendant is, my lord, the person who
the taking this court to the said clause to contend that the second defendant, right?
Second defendant has not obtained
The second defendant has not obtained any license from the authorities to sell craft beer or tap beer, as the case would be. But for selling of a bottled beer, there is no impediment. The order now that is called in question is sweeping that the petitioner cannot sell bottled beer in even. Therefore, the learned counsel for the petitioner undertakes that in the restaurant, i.e. 1-8 Commune, he would sell only bottled beer and not sell craft beer or tap beer, as the case would be, and would further undertake that he would place the entire accounts before the concerned court of sale of such beer. How invoice create madam?
Swami, I am excise. It's excise control. I can't. Every beer is. I have to purchase from MSIL and then I have to.
Craft beer, you have MSIL in the purchase.
No, craft beer
that comes from the keg, sir.
No, that is also monitored by the excise department.
Yes. So and so. In that light, in the light of the said undertaking, the restaurant/pub is now permitted. The petitioner is now permitted only to sell bottled beer. Any event of breach of undertaking would be viewed seriously. Emergent notice, petitioner shall serve on the counsel representing the respondents before the trial court. List on 24th in preliminary hearing. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬೇಕಾ? ಬೆಳಗ್ಗೆಯಿಂದ ಬಿಯರ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ, ಇವಾಗಲೇ ರಾತ್ರಿ ಏನ್ ಬೇಡ. ಎಸ್.
Number 4, need C.
My lord, objector application, please, my lord, is with
2197.
Without there
No
being an
inquiry.
No inquiry.
Yes. Where is the order?
My lord, order at annexure A.
Page
11.
Page
11. No evidence.
Partition suit.
Partition suit.
Who are you?
My lord, not a partition suit.
Then?
My lord, execution, please, my lord, what happens? Chandigaraya Gowda is, my lord, is
ಅಯ್ಯೋ ನೀವು ನೇಮ್ಸ್ ಹೇಳ್ಬೇಡಿ, ಸೂಟ್ ಏನ್ ಹೇಳಿ ಸರ್.
ಅಲ್ಲ, suit for specific performance.
ಸರಿ. Who are you?
My lord, I am the daughter of one Chandigaraya Gowda, where I am having a right.
How?
My lord, through my father, he died intestate. My lord, my elder brother, my lord, he executes a registered sale agreement in favor of the one Sanne Gowda, to which I am not a party to the agreement is concerned.
Suit is decreed.
Suit is decreed ex parte, without there being any contest. Without there being any contest, please.
Yes. Emergent notice to the, emergent notice for the petitioner. ಯಾರು contesting?
My lord, contesting would
Decree
be,
holders.
my lord, to all the respondents.
Petitioner shall serve the respondents by way of hand summons and file the acknowledgement of such service by the 18th of September. List the matter on 24th September. Further proceedings till the next date shall remain stayed.
Please.
Yes. Next.
5.
My lord, this is a suit filed for declaration and permanent injunction. I am defendant number 6 in the matter, my lords.
Then 39(3) not complied, ah?
Indeed, my lords. Order 39(3), proviso is not compliant and 3A is also not compliant.
Where is the latest judgment of Supreme Court? 39(3) not complied vitiates.
My lords. Time City Infrastructure and Housing Limited versus State of UP, my lords. My lords, may I please see paragraph
Yes,
6, my
no
lords.
problem. Homework ಮಾಡಿದ್ದೀರಾ ಇವತ್ತಷ್ಟೇ. Yes, the petitioner is before this court. Petitioner is the defendant number 6, calls in question an order passed by the concerned court granting an ex parte injunction without compliance with sub rule 3 of rule 39, which the apex court holds it to be mandatory. In that light, there shall be an interim order of stay of the order granting such injunction till the next date of hearing. The petitioner shall serve the respondent by way of hand summons and file an acknowledgement by the 18th list on 24th.
Grateful, my
Yes.
lords, may I request hand delivery the matters coming up on the first, my lords. In court.
On the first,
On the first, apologies, my lord, on the 6th, my lords.
on the 6th Saturday.
Saturday.
ನಾಳೆ ಸಿಗುತ್ತೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಏನ್ ಬೇಡ ನಾಳೆ ಆಯ್ತಲ್ಲ ಮೇಡಮ್.
Number 6, Jagdish.
My lord, herein I have filed the application under order 21 rule 97, my lord.
ನಿಮ್ದ್ರಲ್ಲೂ ಎನ್ಕ್ವೈರಿ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, my lord. Inquiry ಆಗಿಲ್ಲ.
Same order as I did in 4, serial number 4. Same, everything same. Yes.
Grateful.
7,
The JDF before this honorable court challenging the proclamation and sale of the house property. 10 lakh rupees plus interest. I am deposit of 4 lakh rupees, madam. I will pay directly to the.
What is the decretal amount?
10 lakh rupees plus interest of 8% to be.
ಯಾವತ್ತು ಡಿಕ್ರಿ ಆಗಿರೋದು?
2018, my lords.
2018.
ಹೌದು.
10 lakhs ಡಿಕ್ರಿಗೆ 30 ಲಕ್ಷ ಆಡ್ ಮಾಡಿ 40 ಲಕ್ಷ ಆಗಿರುತ್ತೆ.
15 ಲಕ್ಷ ಆಗಿ.
15 ಲಕ್ಷ ಆಗುತ್ತೆ ಅಷ್ಟೇನಾ? 10 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
4 ತುಂಬುತ್ತೇನೆ. 4
ಬಹಳ
ಲಕ್ಷ
ಕಡಿಮೆ
immediately ನಾಳೆನೇ ತುಂಬುತ್ತೇನೆ. ಸೊ 6ನೇ ತಾರೀಕಿಗೆ ಫೈನಲ್ ಸೇಲ್ ಇದೆ. ಸ್ವಲ್ಪ ಬಡವರಿದ್ದಾರೆ. 4 ಲಕ್ಷ ತಗೊಂಡೇ ಬಂದಿದ್ರು ಅವರು. ನಾನು ಹೇಳಿದೆ
ತಗೊಂಡೇ ಬಂದೆ, ನೀವು ತಗೊಂಡ್ಬಿಟ್ರ?
ಇಲ್ಲ, ತಗೊಂಡ್ ಬಂದಿದ್ರು ಅವರು. ನಾನು 4 ಲಕ್ಷ ತಗೊಂಡು 25% ಆಗ್ತದೆ ಮತ್ತೆ ತಗೊಂಡೇ ಬಂದ್ಬಿಟ್ಟಿದ್ರು. ನಾವು ಪಾರ್ಟ್ ಮಾಡಿ ತುಂಬ್ತೀವಿ.
ಪಾರ್ಟ್ ಮಾಡಿ.
ತುಂಬಾ ಚಂದ್ರಾಯಪಟ್ಟದವರು ತುಂಬಾ ಬಡವರು.
ಚಂದ್ರಾಯಪಟ್ಟಣ ಅಂತ ಪಾರ್ಟ್ ಕೊಡ್ಬೇಕು.
ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್.
The petitioner, there shall be an interim order of stay as sought for, as prayed for, subject to the condition that the petitioner would deposit 4 lakhs in the next 2 weeks. List the matter on 19th in preliminary hearing. Petitioner to serve on the counsel appearing for the decree holder before the concerned court and file an acknowledgement of such service by the 15th.
6ನೇ ತಾರೀಕಿಗೆ ಸೇಲಿಗೆ
ನಾಳೆ ಸಿಗುತ್ತೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಎಲ್ಲದಕ್ಕೂ ಬೇಡ.
number 8.
ಸುಮ್ಮನೆ ಆಮೇಲೆ ಸಾಯಂಕಾಲಕ್ಕೆ ಕೂತ್ಕೊಂತೀರ ಬೇಕು ಅಂತ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಅದು.
For the petitioner, my lords, an execution petition is filed, my lords, on the basis of an arbitral award. My lords, the attachment is sought, my lords, the garnishee order is sought for. 5 bank accounts are given. Of that, my lords, 4 does not belong to me, my lords. I am the JDR number 1. My lords, I run a school. The same brand name, my lords, is used for other schools also. Now, my lords, who were using that brand name, all those, my lords, accounts are attached. My lords, now there, my lords.
What is the award of the arbitrator?
My lords, the award is on 2 grounds.
You are what respondent there?
My lords, I was the first respondent there.
Correct.
What
award have you suffered?
My lords, I suffered a part decree, my lords, of monetary payment.
How much?
My lords, 20 crores as on date, my lords, is the award amount, my lords. That my lords will find, my lords,
34 petition is filed?
34 is filed, my lords. I have filed 34, they have also filed 34. It is being contested.
Now 34 is pending.
It's pending, my lords.
Now what's the problem?
My lords, what has happened is, my lords, the execution is filed. In the execution, my lords, might take IA number 1, which is filed, my lords.
What is IA 1?
185, my lords, they ask for attachment, my lords, a garnishee order is sought for under 21 rule 46. My lords, 5 bank accounts are given. My lords, they don't belong to me, except the first bank account, my lords, they are not my bank accounts. Order is passed, my lords, where the garnishee is now, my lords, the order is passed attaching those 5 bank accounts where, my lords, 1 belongs to me. The first account, my lords, is my account. 2, 3 and 4 belongs to, my lords, separate schools. They are not me. My lords, they have the same brand name. But my lords, they are not run by the first JDR. They are run by some other trust and societies. Now, my lords, those accounts are.
When was the order passed?
My lords, the 11th of July, my lords. I got to know, my lords, recently after, my lords, the debit freeze
By
was
an
made.
interim order, I will not direct defreezement if it is already frozen or attached.
My lords, there is a debit freeze. There has been a debit freeze. My lords, is
Debit
what I have
freeze
been told.
idre by an interim order, I will not.
My lords, the difficulty
defreeze
is this. My lords, those schools are not able to pay the salaries to these teachers.
No,
my lords.
but you serve on the respondent, will see. Yaar
Yes,
LM Chidananda appear agidare.
Please, my lords, sir.
Our mail serve ಮಾಡಿ, I'll take it on Monday.
Please.
The petitioner to serve on Counsel Shri L.M. Chidanandaya, who appeared before, appeared for the decree holders.
My lords, the execution is filed by
sorry,
Mr. P.D. Surana's office. My lords, I'll serve on Mr.
Whoever,
Surana,
yes.
please.
So the counsel for the petitioner to serve on the counsel representing the decree holders and file an acknowledgement of such service. In the event the acknowledgement is filed, list the matter on Monday.
In
And
the
preliminary
meanwhile,
hearing.
my main difficulty is, my lords, the other schools, my lords, I don't run them. I have nothing to do with them. Now, my lords, because of the same brand name, now, my lords, my reputation in the industry, one is going, my lords, they are not able to operate their schools. My lords,
As Monday varga reputation yen tondre.
yes. But until, at least, my lords, let me operate the accounts insofar as, my lords, the other.
Defreezing ಕೊಟ್ಟಂಗೆ ಆಗುತ್ತೆ.
Yes, I'll wait. I'm grateful.
Yes.
Number 9, Devi Prasad Shetty.
Margadarshi chitta. The petitioner shall serve on the counsel who represents the respondents before the respondent decree holder before the concerned court. The learned counsel appearing with the petitioner submits that the decree holder seeks to execute the decree, notwithstanding the fact that the entire amount being paid. In fact, identical matters are pending and interim orders are granted between several persons and the same decree holders. In that light, the execution proceedings before the concerned court shall remain stayed till the next date list on 24th. Yes, Naveen.
Lords, it's an execution petition wherein the DHR is a credit cooperative limited, my lords, which comes under the Banking Regulation Act. I file an application under section.
Commercial court ಕಳಿಸಿದರಾ ಈಗ?
No, my lords, they dismissed my application, page 15, my lords. The reasoning, my lords, there is no reasoning, my lords.
Reasoning, there is no reasoning?
No, there is no reasoning at all, my lords. Last paragraph, my lords.
21C1I.
Page 15, my lords.
It is a commercial dispute, is it?
Yes, my lords, because
21C1I ಕೊಡಿ.
It says, my lords, here, bankers, traders, all those things will come under the commercial dispute.
We'll see.
Admittedly, they are governed by Banking Regulation Act.
Just the matter on 19th September in preliminary hearing. Petitioner shall serve on the ಆಗಿತ್ತಲ್ಲಿ?
Yes, my lords.
Petitioner shall serve on the counsel representing the respondent in the trial proceedings. List the ಹೇಳಿದ್ನಲ್ಲ. Further, there shall be an interim order of stay of the impugned order. ಕೇಳಿದ್ದೀರಾ ಇಲ್ಲ?
Let's further proceedings, my lords.
Further proceedings before the concerned court till the next date. Yes.
Great. Let's hand delivery for the reason they are coming and interfering with my husband's hotel business, my lords.
ಏನ್ ಹೋಟೆಲ್?
My husband is running a hotel under the.
What hotel?
It's a restaurant, my lords.
Offer them coffee or food? Yes. Next.
Kindly, great.
Yes. ಇದು ಯಾವ್ದಾದ್ರು ಮೇಡಮ್ ಸಿನಾಪ್ಸಿಸ್? ನಾವು
Let's continue. 94.
Objections ಹಾಕಿದ್ದೀರಾ?
No, well, I will get the instructions by tomorrow, so I'll file my objections.
Just on Monday.
Please.
In preliminary hearing. Next.
95.
For the petitioner, Your Lordship. Your Lordship, if I may skim through the events that have happened.
You won't skip through the petition?
No, skim through just go, if I may brief about the events that have happened. Because, Your Lordship, there's a confusion whether we are challenging the additional written statement or the written statement that has been filed by defendant number 224. Your Lordship, we are challenging the order by the trial court wherein we had filed for recall of the order wherein the additional written statement by the defendant number 1 and 7 was accepted. And Your Lordship, they have not filed any application for the same. So what happened?
What are the connected matters now?
My lord, connected matter
is by the first respondent seeking early hearing of the early disposal of the suit.
What
Because
is the first petition, madam? Nimden?
Your Lordship,
You first petition nimda? Illa ivrdu.
first petition nandu, actually the second petition was filed earlier.
yes,
The
Your
second of the petition, 20.
What 95.1 kodi, madam? What is under challenge there?
Your Lordship, we have not been given an opportunity to file the rejoinder to the written statement filed by defendant number 2 to 4. Instead, the opportunity was directly given to the defendant number 1 and 7 to file additional written statement to the written statement filed by.
Aste alla. Kindly see the order at annexure B, Milo, page 30. They did not to oppose. They had not to oppose the application.
They want to file written statement. So what?
Additional statement they want to file is a plaintiff, and defendants 2 to 4 are sailing with the plaintiff.
No, Your Lordship.
Kindly see the
Suit for
written-
partition?
Yes,
Suit
Your
for
Lordship.
partition. They are sailing with that.
Tomorrow they should not, it should
My
not,
lord, sorry.
it should not be said that others have no right, petitioner also has no right. It's not-
No, not that. Kindly see for a minute, annexure B, my lord. It is a collusive, it's a collusive in nature, doesn't matter. They can, dependent 2 to 4 file the written statement after 8 years, that was allowed. And since they are sailing with the plaintiff and made allegations against the defendant number 1, my lord, the additional written statement was filed by the defendant number 1. My lord, after the additional written statement is, there is no stay of the proceedings. My lord observed that the proceedings can go on. The person, first defendant was a senior lawyer, senior advocate of the Karkala bar. He is bedridden. He has given up his sanat, 91 years old, and he was partly cross-examined.
Let the court conclude the proceedings.
It is not being done. Every stage the hurdle, and he want to get out of this world, and he may not.
Get out of the world.
Yes, because of this, my lord. Daily he is taken to KMC Manipal from Karkala and on a stretcher. He is 92 years old.
You
And
want the property now.
No, he doesn't. He want him to be cross-examined. That's all. And the other day also.
Alla, you say you're going on this stretcher to the hospital every day.
Every day. my
And
lord.
cross-examination ಎಲ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಮನೆಯಲ್ಲಿ ಕಮಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. Defendant number 1 has filed an application to be
ಮನೆಯಲ್ಲ ಅಥವಾ on the way ನಾ?
ಈಗ ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲಿಗೆ ರೀಚ್ ಆಗ್ತದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. Kindly see, other day they make one more application.
ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ಸ್ಟಾಪ್ ಮಾಡಿ, will direct the court to consider.
If I may be permitted, Your Lordship,
How long
the
this
defendant
will
number
go?
1 was the one who kept filing applications again and again. Your Lordship, he filed first for the additional written statement, and later he dragged it for next 3 years, Your Lordship. After that, defendant number 1.
No, kindly see the court commissioner.
Lordship,
Yesterday
if I may
he has
be
filed it.
the
ಇಬ್ರು
order,
ಹಿಂಗ್ ಕೊಟ್ರೆ ಏನ್ ಕೇಳೋದು? Yes.
order sheet, Your Lordship.
ಅಲ್ಲ
ಈಗ ನಾ ಏನ್ ಸ್ಟೇ ಮಾಡಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಅಲ್ಲ ಸ್ಟೇ ಮಾಡಿಲ್ಲ. What the plaintiff is saying that let the defendant cross-examine the defendant number 1 first. And the defendant 2 and 4 are saying, no, we will not cross-examine.
Let the court decide all that. Yes. I have not stayed anything. Pendency of this petition will not come in the way of further proceedings before the concerned court. Yes.
My lord,
Your
at least early disposal. Otherwise,
Allah,
I have stated 92 years old. And every day, my lord, he's.
I have not stopped, sir.
Therefore, one observation that.
I have not stopped at all.
Your Lordship, we may be given an opportunity to file the rejoinder, Your Lordship. And
ಯಾವುದಕ್ಕೆ
My
ಮೇಡಮ್?
lord,
the other writ petition,
ಆಯ್ತು, ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ರಿಜಾಯಿಂಡ್ ರಿಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬರ್ಬೇಕಾ ಇಲ್ಲಿಗೆ?
we were not
yes.
given an opportunity to file
Yes,
the
yes,
rejoinder.
next.
96.
my lord, at least an observation that at the earliest it could be disposed of.
No, I have said
Because,
pendency,
this
you
thing-
take advantage of that. Any other observation will be closing the proceedings. Yes, next. ಇದೇನ್ ಮತ್ತೆ ನಂದೇ ಇದೆ ಆರ್ಡರ್?
Also, it may be taken up on 16th or 17th.
Yes, 17th. Yes.
Please.
97. Wait for respondent. Partition.
ಇವರೇನ್ ಇವತ್ತು ಮುಗಿಸಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಸೋಮವಾರ ತಗೊಳ್ಳುವ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ.
98.
ಇದು Order 11, Rule 1.
ನಂದು ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್
Dismissed. Yes.
ನಂದು ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಪ್ಲೀಸ್ ದಿಸ್ ಡಿಸಿಷನ್
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ.
3 ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸ್ವಾಮಿ ನಿನ್ನೆ
ಹಾ,
3 ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಒಂದು ಡಿಸಿಷನ್ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 23, 24.
No, sir. 11-1 I will not permit at all.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Dictation ಮಾಡಕ್ ಟೈಮ್ ಇಲ್ಲ. Dismissed.
ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತಾ ಇದ್ದೀನಿ.
ಓ ಅದೆಲ್ಲ ನೋಡ್ಬಿಟ್ಟೆ ಬರೀತಿತ್ತು. Don't worry. Yes.
ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ತೊಳಿ.
Great.
99.
ಡಿಸ್ಪಾರ್ಡ್ ಅಂತ ಬರ್ಕೊಳ್ತೀನಿ.
Disposed of. Dismissed of. Yes.
I represent the petitioner, my lord.
Hmm.
Appointment of a commissioner in a suit for declaration and possession. Defendant has illegally occupied my property. After the evidence, I filed the application.
It is rejected.
Rejected mainly on the ground it is more in the nature of extracting evidence.
It is only in the nature of extracting.
No, my lord.
More illway.
It is actually showing, seeing what is the existing position. I have sought for assistant executive engineer, BBMP being appointed as commissioner. In the evidence, they say that they have encroached on the road, not on your property. Therefore, my property,
Petitioner to serve on the respondents.
I have served, my lord.
Already?
Yes, my lord. Served and
Acknowledgement is filed. Counsel for the petitioner submits needful has been done. List the matter on 17th. Further proceedings before the concerned court till the next date shall remain stayed. Next.
100.
Petition, my lord, has served the notice to the council, my lord, as ordered by this one report earlier,
Suit
my
for,
lord. Suit for
oh, execution. sir.
Yes, my lord. Declaration and possession.
JDR,
Yes, my lord.
why are you here?
My lord, appeal is filed, my lord, so the appeal is pending. My
Appeal,
notice-
appeal is before a different court or same court?
Different court, my lords. My lord, there is a short delay in filing the appeal, therefore notice is issued. Now, my lords, the execution is lodged, my lords, in which delivery warrant is issued with the survey. My lord, the decree holder himself, my lords, do not know where exactly
How
the
much
property
delay,
is.
sir,
My lord,
in filing the
36
appeal?
36 days delay in filing.
Yes,
my lords.
Ashtena. Yes.
Therefore, my lord, the surveyor is sought to be appointed to locate
Petitioner
the
to serve on
property.
the council, serve ಆಗಿದೆಯಲ್ಲ?
Already served, my lords. I have filed the acknowledgement also, my lords.
Learned council submits needful in terms of order 18/8/2025 has happened. What is the next date?
My lord, next date, my lords, 6th, my lords, there was order, my lords,
What 6th?
the other day, my lords. 6th, my lords, 6th.
Executing court ಅಲ್ಲಿ ಯಾವತ್ next ಇರೋದು?
6ನೇ ತಾರೀಕು ಇದೆ.
Yes, list the matter on 10th, adjournment ತೊಗೊಳ್ಳಿ. Yes, next.
For petitioner, I'm waiting for respondents. Kindly press time to file objections.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections. List after 2 weeks objections, if any. By then, interim order subsisting will continue to the next date of hearing. Next.
102.
For the petitioner in this case, my lords, short accommodation, my lords. Next we can edit, my lords.
At the request of the council appearing for the petitioner list after 2 weeks. Next.
Please, my lords.
103.
I appear for petitioner. A suit for specific one contract for a total consideration of rupees 5 crore, my lord. I have paid 1 crore 95 lakhs, my lord.
What is under challenge, sir?
Under challenge, emergent notice issued. I am seeking only not to alienate the property till the next date of it. That's all.
What is the date of the agreement?
That kindly peruse, my lord. It is within
Kindly perusal date ಹೇಳಿ.
dated 15/10/2024, my lord.
15/10/24. Time is the essence.
No, my lord.
Sale date ಎಲ್ಲಿವರೆಗೆ?
Sell it within subsequent payments made, my lord.
Already made?
Already made.
Yes. The emergent notice to the respondents. Petitioner shall also serve the respondents by way of hand summons. The respondents are restrained from alienating the property during the subsistence of the subject petition. List the matter on 24th. Next.
104.
Both the matters are arising out of two different suits. The suit for permanent injunction in which the petitioners are the plaintiffs. Concurrent
Monday
finding.
ತಗೋಬೋದಲ್ಲ? Urgency ಇದೆಯಾ?
Monday.
Next date ಯಾವತ್ತು?
Date ಅಂತ ಇದಿಲ್ಲ, ನಾವು
ಅಲ್ಲ, suit, my lord, injunction.
Injunction. Monday. Yes. List on Monday in preliminary hearing. Yes, next.
Written 5.
The petition in this case, I've served the copy on the trial court advocate, filed the acknowledgement also today in the office, sir.
I have taken the notice, Your Honor.
Learned registry to print the registry.
Petition become infructuous because trial court has passed the judgment.
This matter,
Yeah, he has filed the miscellaneous petition.
Avattu tamge already, I informed the court also. This court
Yes,
has
yes,
granted
they
an
did
order.
not, correct.
I went to the court, I informed the court also.
Yes,
about
this will have to pass some order. The civil courts are not accepting.
Court now it's insisting upon
web-
court's instruction, I have
web-hosted
to file
copies.
miscellaneous petition. my lord.
That is dangerous.
On that day.
Sometimes there will be a slight delay in issuing the certified copy for the process that is there. If the web hosted copy is not accepted by the civil court, it is posted for judgment, copy is given, it is not accepted, judgment is pronounced.
10:50 my lords, I go there, cameras are there, I insist the court my lords, 10:50 from, came to a chamber, copy is there, everything is there. Now court upon court instruction, court says that you file miscellaneous, withdraw that writ petition, I'll allow this miscellaneous. This is how the court.
Allowed the miscellaneous?
I'll allow the miscellaneous, I withdraw this writ petition, I'll allow the miscellaneous, you file a miscellaneous and insist in the trial court advocate. This is how the court. Even he was present, what's happening.
ಅವತ್ತೇನಾಯ್ತು ಸ್ವಾಮಿ ಫಸ್ಟ್ ರೌಂಡ್ ಪ್ರೊನೌನ್ಸ್
ಅವತ್ತು ಏನಾರು ಆಗಿರ್ಲಿ, I have granted an order on the previous day. When it was brought to the notice of the court, how can the court pass the judgment? And why now saying?
After pronouncing the judgment, he has brought to the notice of the court.
I came 1 o'clock, I mentioned to the court also.
Yes, sir.
This court
Before
also
that,
mentioned.
11:30 it was pronounced.
When did you make a
About
mention?
10:50 my lords, I was in the court hall, cameras are there, 11 o'clock I made a mention, court said come after first round. After first round my lords, we went there, court said that I'm already passing an order. It did not say, it did not pronounce in the open court also. Again 1 o'clock my lords, office boards of the association went there, 1:30 court said that you bring other side advocate, inform them, file a miscellaneous petition. I'm sorry, that was done at 2:30. When I informed the court at 1:30, 2:30 the court said that.
Yes, I'll list it tomorrow, we'll pass some order. Tomorrow at 2:30. This is not correct. Tomorrow you are in this side. What do you do? An interim order is granted and it is not taken note of by the court just because it is a web hosted copy? Yes. Next.
Written 6.
This is a GM police matter, my lord.
Why did it come here, sir?
We're disabled before the roster bench. We've sought for a direction to take action on my complaint and provide protective measures to preserve law and order. The issue, my lord,
Law and order.
to preserve law and order.
Law and order problem ಎಲ್ಲಾಗಿದೆ?
Really, my lord, the issue is I'm a telecom infrastructure provider. I have
ಏನ್
licenses.
tower
I'm
ಆಗ್ತಾ
at the
ಇದ್ದೀರಾ?
tower ಆಗ್ತಾ ಇದೀವಿ. ಸುತ್ತಮುತ್ತ localities ಇಂದ people are coming, a mob is creating.
ಸುತ್ತಮುತ್ತ ಪ್ರಾಬ್ಲಮ್ ಆಗೇ ಆಗುತ್ತೆ ಟವರ್ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ. Radiation it emits.
Yes, my lord, but we have the compliances and it's in compliance with the BBMP requirements and the guidelines. In fact, the BBMP has issued a NOC which I've produced, I produced at page 60.
Get the additional SPP. The learned AG is directed to accept notice for the first respondent. Additional SPP, respondents 2 and 3, list on Monday in preliminary hearing.
Please.
Yes.
Written
Next.
7.
For the petitioners, my lord. The case was instituted for the injunction, my lord, of for trademark infringement. Here, what is challenged, my lord, is the order passed by the learned trial court under order 11 rule 5, permitting accepting documents, additional documents filed by the plaintiff.
You are the plaintiff.
We are,
Sorry,
we
you
are
are the
for the
defendant.
defendant, my lord.
When did you file written statement, man?
Written statement was filed in 10/8/2023, my lord.
10/8/2023.
They have already filed an additional application under order 11 rule 5 initially, my lord, with the same reason that the written statement, they want to safeguard, set up a case against the defense of the written statement.
11/5/C1.
Yes, my lord. That
Now, which is the
application
second,
was
which is
already
the
filed.
second application?
This is the second application is filed recently, my lord. This is at the
Under
stage of evidence.
order 11 rule 1?
Under order 11 rule 5, my lord.
Rule 5.
Lords have already expressed view, my lords, in a
That I will
similar
dismiss the
matter.
petition. Na.
JSM Corporation, I believe that is what they're relying on, my lord.
But JSM, according to the council, once you've already exercised that liberty after filing the written statement to set up the defense in counter to the written statement, if that is already exhausted, another application for documents, I will not
That is not
permit.
the case, my lords.
That's what she's saying.
My lord, if my lords may.
What
see
is the date of
annexure-
the, madam, what is the date of the first additional documents?
First additional.
That's why I asked, when did you file your written statement?
My lord, I filed written statement on 10/8/2023.
10/8/2023.
The first application they filed for additional documents is on 21/11/2023,
21/11/2023.
where the application was rejected and they came before this honorable court, and the honorable court allowed this very same application. That is the first application they filed with the
So
same
first
defense.
application is allowed.
First application has been allowed,
Yes.
which were all trade license and some invoices, which were allowed, my lord. Very well, my lord. That is was in the initial interim, when interim injunction stage had not been cleared. Now at the stage of evidence, after the issues have been framed, they've also filed amended plaint. They could have produced these documents at that time. But now at the stage of evidence, they are coming before the trial court and they've asked for additional documents to be produced, saying that it is the defense set up by the, to safeguard against the defense set up by the defendants.
Anything else,
When they have
ma'am?
already pleaded the same.
My lords, the first application what I had filed, this is a suit for infringement of trademark and for passing off, my lords.
No problem.
They had
Yes.
not, I have issued a legal notice, they have not replied to that legal notice. So I'm not aware of the defense that they have taken, my lords.
Not
Now they
there.
have set up a
In the
defense.
written statement, what is the defense that they took?
It is for that I have filed. The earlier application that I had filed was not on these grounds, my lords. I say
Grounds
those
may be
don't-
manifold. Fragmented grounds cannot result in fragmented applications.
My lord, if I may.
After filing of the written statement, did you file an application under Order 11 Rule 5 seeking to bring in documents?
Yes, my lords, but
You
those
filed
were
it?
documents were copies. I
Done.
had filed those
Yes.
copies.
My lord, if I may,
Wait,
if I may
madam.
clarify.
Yes.
Those, my lords, that
No,
was
madam.
not the,
Once you have filed, exhausted, over.
my lords, I have not received, notice has not been issued in this
Why
matter,
did you
my lords.
come
I
then?
have just appeared the matters on Monday. May I just take a
ಸುಮ್ನೆ
copy of
KVT
the
account stay
petition?
ಮಾಡ್ಕೊಂಡಂಗೆ
But
ಆಗುತ್ತೆ.
there's no
Petition.
caveat also filed.
I will,
ಕೆಲವು ಕೇಸಲ್ಲಿ KVT ಹಾಕ್ಬಾರ್ದು.
I will take note of those applications and those dates.
Wait,
and-
madam, 1 minute. Yes. Heard the learned counsel appearing for the petitioner. The petitioner is the defendant, is before this court calling in question an order which permits permit production of documents under Order 11 Rule 5 of the CPC. The learned counsel for the petitioner submits initially an application was already filed seeking production of documents. This was projected to be in order to set up a defense to the averments in the written statement. Therefore, the application, though initially rejected, was ultimately allowed. The proceedings progressed further. The progression led to the proceedings entering the stage of evidence. At the stage of evidence comes the second application for the same reason of setting up a defense. This, on the face of it, is unavailable to the respondent. This face of it, this prima facie is unavailable to the respondent. The learned counsel so-and-so undertakes to enter appearance for the respondent. The registry to print the name of so-and-so is appearing for the respondent. List the matter on 19th. Further proceedings before the concerned
Petition,
court
my
shall
lords.
remain state.
The first application was not for that reason, my lords, that it was the answer to the case set up by the defendant.
Otherwise, you have no right at all to file.
My lords, that
The
is
only
second
only reason law permits you is to counter the defense set up in the written statement. If you have not countered, it is over, but you have filed an application seeking
But that is not the
documents.
reason on which the first application was filed, my lord. There were several other reasons. I have said
Oh,
it
no,
wasn't in
ಆತರ
my
ಇದೆ ಹೇಳಿದ್ನಲ್ಲ, fragmented reason and
Not in my
fragmented
possession
documents.
at that time.
My lord, just one point. Annexure F, I have.
Intermodal ಬೇಡವಾ?
Very well, very well.
Yes.
108.
Intermodal ಕೊಟ್ಮೇಲೆ one point ಅಂದ್ರೆ reserve it for the final order. Yes.
108 and 109 are connected, my lords. 108 is arising out of the suit in 109, my lords.
Monday ತಗೊಳ್ಳುವ?
Lords, tomorrow is the matter before the
For
commercial
what?
court. My lords, page number 30.
For what ಅಂದ್ರೆ page number 30?
For the
It's
evidence
been
and
transferred from city court to commercial court.
when it is a
They want
commercial.
the plaint to be rejected and then be transferred. I should represent the plaint ಅಂತ ಅವ್ರು ಹಾಕಿರೋ stay ಗೆ.
ಅದೇನ್ ಬೇಕಾಗಿಲ್ಲ.
It has to be returned for the reason it has been filed in the.
710.
20
Plain to be made over to the commercial court ಅಷ್ಟೇ.
ಅವ್ರೇ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು. We said no objection. It was transferred.
15-2 has
ಅವ್ರ
been
ಟೆನೆಂಟ್
invoked
ರೆಂಟ್
as-
ಕಟ್ತಿಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದು. This is one.
Lords, 6.
ಎಷ್ಟಿದೆ ಬಾಕಿ?
37 ಲಕ್ಷ ಇದೆ.
On that
execution
thing, my lords,
ಹಾಕಿದ್ದೀವಿ.
I was a tenant
Some
when
amount may be
COVID.
deposited.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
No, my lords, when the COVID-19 was there, at that point of time, I was running the hotel business. What they're claiming was at the time when the hotel business was closed in the year 2020, I was not running the hotel at all.
What to do? You are squatting over the property and ಕೊಟ್ಟಿದ್ರ ಅವ್ರಿಗೆ? Vacant position deliver ಮಾಡಿದ್ರ?
No, my lords, it was
ಮತ್ತೆ?
just
File execution
further.
they delivered.
ಹೋಟೆಲಲ್ಲಿ ನೀವೇ ಕುಕ್ ಮಾಡಿ ನೀವೇ ತಿಂದ್ರು ಅದು ನಿಮ್ದೇನೆ.
Kindly, my lords. But my lords, if that is the case, my lords, a PIM is also not filed. And the procedure that has been followed has to be
ಟ್ವೆಲ್
followed.
ಆಗ್ಲೇ ಇಲ್ವಾ?
ಆಗಿಲ್ಲ, my lords.
ಅಲ್ಲ ಅಲ್ಲಿ ಬಿಫೋರ್ ದಿ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್
ಅಲ್ಲೂ ಆಗಿಲ್ಲ, my lords.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗೇ ಇಲ್ವಾ? ಪಿಟಿಷನ್ ಟಾಕ್ಸ್
It
ಆಗಿಲ್ವಾ?
can be done here, my lords. In the commercial code, it can be
Then
done.
12A compliance ಆಗೋವರೆಗೂ ವಿಲ್ ಕೀಪ್ ಇಟ್ ಅಸೈಡ್.
My lords, let that stage be posted for 12A itself, my lords. And we don't have any objection to that. ಅವ್ರು ಅದ್ರ ಮೇಲೆ ಬರ್ತಾ ಇಲ್ಲ. Execution stay ಕೇಳಿದ್ದಾರೆ. Execution was an
Because
order which was
execution
already passed.
arises out of the suit, my lords.
12A ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಆಗದೇ ಇಲ್ಲ.
That's what.
See, once the case is made over to the commercial court, if mediation talks or settlement talks have not happened before the regular court, it should proceed.
Lords, they did not
The
appear.
lordship has held
They
that,
did
my
not
lordship,
appear and they
89
filed.
is there, 12 is
Because
not
it's recorded in the order
But
sheet.
nothing
ಲೋಕ
has
ಅದಾಲತ್
been-
ಮುಂದೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿತ್ತು. Because he's a third lawyer. He doesn't know that. Previously, it's an order
ಹೋಗಿತ್ತಾ?
sheet. ಹೋಗಿತ್ತು. ಅಂದ್ರೆ ಅದೇ ಕೋರ್ಟ್ ಮುಂದೆ mediation
ಹೋಗಿತ್ತು
ಲೋಕ
ಅಂದ್ರೆ
ಅದಾಲತ್ ಮುಂದೆ.
ಬೇಕಾಗಿಲ್ಲ.
Lok Adalat, my lords,
The very
if-
same
if-
judge.
ಇಲ್ಲ ಒಂದೇ ಸರ್.
It was for
Same
a,
thing.
my lords,
For a mediation.
bulk Lok
Mega
Adalat,
ಲೋಕ
my
ಅದಾಲತ್
lords.
ಬರುತ್ತೆ. ಅವಾಗ ಹೋಗಿತ್ತು.
ಲೋಕ್ ಅದಾಲತ್, ಮೆಗಾ ಲೋಕ್ ಅದಾಲತ್, ಮೀಡಿಯೇಷನ್
That
ಎಲ್ಲ
time, my
ಒಂದೇ.
lords,
ಇಲ್ಲಿ ಮೆಗಾ ಲೋಕ್ ಅದಾಲತ್ ಏನಾಗಲ್ಲ ಅಂತ.
my lords, ಅದಕ್ಕೆ 15(2) cannot be invoked at all, my lords, because for the pending suits.
We'll see Monday. Yes.
And, tomorrow, my lords, let them.
Let it be take adjournment there.
Kindly, my lords, it may be.
ನನ್ನ ಎವಿಡೆನ್ಸ್ ನಾನು ಮಾಡ್ತೀನಿ. ಅವ್ರ ಬೇಕಾದ್ರೆ ಕ್ರಾಸ್ ಇಟ್ಟು.
Yes, next list on
Kindly,
Monday.
in execution, my lords,
Oh,
let
no,
them
sir.
not precipitate.
Not
my
a case. Yes.
Kindly, kindly, great, my lords.
ಏನ್ ಆಗೋಗ್ಬಿಡಲ್ಲ.
My lords, ಅವರು ಅರೆಸ್ಟ್ ಅಂತ ಅದಕ್ಕೆ
Arrest ಆ?
ಅವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ they had filed,
65 ಲಕ್ಷ ಬಾರಿ.
ಏನ್ ಎದುರ್ಕೋಬೇಡಿ ಪರವಾಗಿಲ್ಲ. Yes, next.
kindly, my lords, great.
110.
ಕಾಪೀಸ್ ಮೇ ಬಿ ಸರ್.
ಕಾಪಿ ಯಾರು ಕೊಡಿ.
ಅಲ್ಲ ಅವರು ವಕಾಲತ್ ಹಾಕಿರೋದು ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ಕೇವೇಟ್ ಅಲ್ಲಿ ಇರಲಿಲ್ಲ, ಬೆಳಿಗ್ಗೆ
ನಿಮಗೆ
ಗೊತ್ತಾಯ್ತು.
ನೋಟಿಫೈ ಮಾಡ್ಬೇಕಲ್ಲ ಹಾಕ್ಬೇಕಾ? Yes.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿರ್ಲಿಲ್ಲ.
Yes, next.
It was listed day before yesterday. I've showed the copies to the other side.
ಯಾರು other side?
Impugn order under order 18 rule 17, my lord.
ನೀವಾ?
Only for the limited purpose of marking a will that was rejected.
Yes, sir.
And matter is tomorrow for argument.
I'll adjournment ಕೇಳಿ. Yes.
My lord, they have already we have requested the trial court and that was rejected and posted tomorrow for argument.
The application for further evidence is filed when the suit was posted for final arguments, a suit of 2012. On completion of evidence from both sides, this application is filed.
Lord,
List the matter on 17th in preliminary
Lord, the
hearing.
interim order.
No.
My lord, kindly see, I have
Oh,
taken
no,
a direction from this honorable court to page number 254.
ಏನ್ direction?
Lord, the direction to dispose of the trial court matter.
Dispose of ತಾನೆ, ನೀವೇ ಅಡ್ಡ ಬರ್ತಾ ಇದ್ದೀರಾ.
No, my lord, my application, my lord, one.
No, no,
The issue
nothing.
number 2 is on me, but my lord, I have
No,
to
no,
prove and
yes,
establish that.
yes, nothing doing.
My lord, the
Only a ruse to drag the proceedings. Next. Yes.
11.
111, I may be permitted to appear for the petitioner's counsel. Not in an
This
execution.
is yesterday's matter.
Yes, yes.
We'll take it on Monday. I'll protect you till Monday. Yes. Heard the learned senior counsel,
May I request for any day other than Monday, my lord?
Wednesday.
Wednesday is fine.
Heard the learned senior counsel, JL Vishwanath appearing for the petitioner. We list the matter on 10th in preliminary hearing. The execution alva?
Yeah.
Proceedings in execution
25.
shall be deferred till the next date. Yes.
112.
Let's. Suit is filed not on the basis of a power of attorney.
Yes, sir.
I'm sorry to trouble at this hour.
Huh?
Sorry to trouble the court at this hour. But this is a. Defendant's suit. But suit is filed, defendant's not the writ petition. The suit is filed for Lord eviction. It is filed on the basis of a power of attorney. That power of attorney, Lord, is neither stamped nor notarized nor registered. Now, Lord, that document, Lord, was sought to be marked by recalling the witness. After we point out that GPA itself is not marked in evidence.
No, of an unregistered document?
Unregistered document which
No,
has the
it is-
power to
It
sell.
is marked, is it?
Today, my lord, it is marked. We point, yesterday, my lord, the matter was listed at 2:30 because K-Waiter was not there. But I brought my lord's notice, the K-Waiter has been filed. My lord said, let it be listed today. We brought to the notice of the court that we have filed a writ petition. The court, my lord, has marked it subject to objections.
List the matter on 17th in preliminary hearing. Objections, if any, by the K-Waiter by the next date. Further proceedings before the concerned court shall remain stayed on the score that an unregistered document is said to be marked without following due process of law, only observing that it would be subject to objections. Yes.
Please.
Next.
113.
Petitioner's counsel.
The matter is listed for orders on the 19th before the trial court. I am a caveator. The purpose of a caveat is that I should be heard before an order is passed.
ಈಗ interim order ಕೊಟ್ಟಿದೀವಾ?
ಏನು ಇಲ್ಲ. My lord, what has happened is.
ನಿನ್ನೆ ಬಂದಿತ್ತು, senior himself said caveat ಇದೆ. It would not
I
be
was
fair
not
on my part to make a
I
mention.
was not informed before it was.
That's
moved.
all right. Did he take advantage of that?
I'm not
He
saying
himself
that, my
told,
lords.
caveat ಇದ್ದಿದ್ದು ಗೊತ್ತಿಲ್ಲ, caveat ಇದೆ, will please take it tomorrow, let him come.
My lords, I have this one submission to make. I'm not talking about the caveat here.
ಮತ್ತೆ?
I filed a caveat in the civil suit. They
ಅದ-
served
ಅದ-
me a copy.
ಅದು ಅಲ್ಲಿ ಕೇಳ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ. May I complete what I'm trying to
Yes,
say?
sir.
We entered appearance after the caveat copy was served on us. The court has heard us, posted it for orders. The purpose of a caveat is that I should not suffer an order without being heard. It is posted on 17th. Now, why would this petition be filed in the interregnum for that?
We'll
But,
hear you. What's the matter?
My lord, I have been entered into an agreement. Agreement is for 10 years. I, my lord, have, my lord,
ಏನದು?
Citations. I'm ready.
Yes.
10 years is the agreement.
Giridhar comes up with surprise always. Yes.
No.
Yes.
10 years is the agreement.
Yes.
What they do, my lord, I develop, my lord, the Acer and the product, the
ಗೊತ್ತು.
name, trade name. I, my lord, develop the product. I, my lord, appoint, my lord, several, my lord, contract manufacturers. 1,000 people are there, my lord, by the contractors. Now what has happened is, they want to, my lord, they have now set up another independent, my lord, subsidiary. So they want to take over the entire thing within, my lord, 4 years Wagil line. What they do, my lord, I have already placed orders for 200 crores worth of material. We have placed also before the trial court. It is coming in the name of, my lord, Acer. Now they are saying that we are now, they called us for, my lord, the negotiation. They said, we will give you 120 days and thereafter you accept the termination. We said acceptance of termination is not permissible. They issued a notice saying that, you have to cure. What they are saying 16 complaints are there. 10 lakh, my lord, products we have sold. Out of that, 16 complaints were there. 13 are already closed. 3 complaints are remaining, my lord, as against 10 lakh, not even 0.00001%. Even, my lord, the agreement says you have to, my lord, they themselves have written letter saying that, my lord, we are all within, my lord, the norms. There is absolutely no problem. And suddenly, my lord, they call us for negotiation and they say we terminated. Therefore, my lord, we filed a petition. Trial court, my lord, first order, my lords, get that at running page, my lord, 87. Caveat was served, matter was heard, matter is posted, my lord, for orders at page 88.
What is, nothing is granted?
Nothing is granted. Then, my lord, what they do is, when it is posted for orders, on that day, my lord, please come to page 44. They produce, my lord, written statement and the trial court says, I will post it now on 17. What do I do, my lord? 200 crore worth of, my lord, goods are here. I am, my lord, at a loss. I can't do anything. Interim order, my lord, is all that we had sought for. Nothing is done.
Yes, sir.
Caveat doesn't mean, my lord, anything.
Let him finish.
He's finished.
My lords, the contract is not produced by them. I'm a company registered in Taiwan. We issued a
Contract is
notice.
terminated.
Contract is terminated.
Midstream.
My lords?
Contract is terminated in the midstream.
Yes, my lords.
All right.
My contract permits me to
All
terminate.
right, I'm not saying it is permitted, terminated midstream.
It is terminated midstream. The contract permits me to terminate it
Now,
midstream.
tomorrow, if that is set aside by the
No, my
court,
lords, the
it
law
can't
on the
be.
point, for these reasons I given the judgment. If I am entitled to terminate the contract at my will, then the only option available, there are two kinds of termination, my lords, termination for cause, termination without cause. If I am entitled to terminate the contract without cause at my own will, I expose myself to damages, but the contract cannot be restored by an order of a court.
We'll see, we'll hear it then.
My lords, I've.
ಈ 5:15 ಏನು ಕೇಳೋದು? ಸೋಮವಾರ ಕೇಳುವ.
I'm ready.
Next date 17th ಅಲ್ಲಿ.
17th is for orders by the trial court. The trial court will get
200
unnecessarily
crore worth
influenced.
of, my lord, admittedly,
Maybe
they
true,
themselves,
my lord, say it is.
17th
they
is,
themselves have.
I am taking it on 8th, sir.
I will ready.
8th ತಗೊಂತೀನಿ sir. ಅಲ್ಲಿವರೆಗೆ ಏನು ತೊಂದರೆ ಇಲ್ಲಲ್ಲ?
Like then ನಮಗೆ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಈಗ. Now, my lord, what has happened is 200 crore worth of, my lord, goods.
ಆಯ್ತು, 2 ದಿನ ಇರಿ. We'll pass out some. Yes. ಈಗ ಏನು ಕೊಟ್ರಲ್ಲ ಅವ್ರಿಗೂ ಕೊಡಿ ಕಾಪಿ. Yes. ಅದೇ ಮಾಡಲ್ಲ, ಅವ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರು ನೋಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
Same judgments which gave to the trial court.
All right, whatever. Yes.
Then 14.
ನಮ್ದು ಒಂದು ಕೊಟ್ಬಿಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಆಯ್ತಾಯ್ತು.
ಟರ್ಮಿನೇಷನ್ ಅದು
ನೀವು ಬೇರೆ ಏನಾರು ಹಾಕೋಂಗಿದ್ರೆ ಅದು ಹಾಕ್ಬಿಡಿ.
ಅದನ್ನು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಏನಾರು ಇದ್ರೆ ಹಾಕ್ಬಿಡಿ.
ಅದನ್ನು ಕೊಟ್ಬಿಡ್ತೀನಿ. ನಾನು ನಾಳೆ ಬೆಳಿಗ್ಗೆ
ನಾಳೆ ಕೊಟ್ರೆ
ನಾಳೆ
ನಾನು ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೀನಿ ಮಂಡೇ ಬಿಡಿ.
ಅಗ್ರಿಮೆಂಟ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಜನರಲ್ ಅವಾರ್ಡ್ ಅನೆಕ್ಷರ್ ಮೇಡಮ್ ಜನರಲ್ ಅವಾರ್ಡ್ ಅಂತ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. ಜನರಲ್ ಅವಾರ್ಡ್ ಚೇಂಬರ್ ಡಿಸ್ಪೋಸ್ಡ್. ಎಸ್
Admission 115.
My lord, I pray for combining the other matter also.
I am
which
not
is
doing that.
Which is pending before this
which
one.
matter?
Same criminal petition be pending
ಇನ್ನೊಂದು
before this
ಹಾಕಿದ್ದೀರಾ?
court. 3870 of 22.
ಆಮೇಲೆ ಅದು 482
Same ಕಾದ same
ಇದು 482 ಅಲ್ವಾ?
ಇದು 48 ನೋ ಇವರೇ ಅದರಲ್ಲಿ ಒಂದು
ಕ್ವಾಶಿಂಗ್ ಈಗ ಇದು ಹಾಕಿರೋದು.
ಪರ್ಮಿಟ್ ಮೇ
ಮೂರು ಪೆಟಿಷನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಯಾವ್ಯಾವ್ದೆಲ್ಲ ಕೊಡಿ.
ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Objection number ಕೊಡಿ ಇಲ್ಲಿ. Tag this petition along with so and so. List it on Monday at 2:30 PM. It is made clear no further adjournment would be granted on any ground.
My lord, that is about an IA. IA passed before the.
Yes.
My lord,
Swami,
my prayer is
this is about quashing, Swami. That.
my prayer is there also caution. Same person.
ಈಗ ಕೊಡಿ ಅಂತ ಹೇಳಿ ನಾನು ಟ್ಯಾಗ್ ಮಾಡಿದ್ದೀನಿ, ಕೊಡಿ ಇಲ್ಲಿ. Monday at 2:30. Yes.
ಯಾವುದು petition? I don't know the number.
3870 of 22.
Yes.
You are the party in person there.
160.
ಇದು ಬೇಡ ಮೇಡಮ್. ಅಡ್ಮಿಷನ್ ಸಾಕು. ಎಲ್ಲ ಎಂಟ್ರಿ ಮೋಟರ್ಸ್ ಇದೆಯಾ?
My lord, it's a 50A, my lord, NDPS.
I know. Entry motors there.
Yes,
And list the matter on 19th.
my lord, not 19, my lord, immediate
12th.
next.
ಬೇರೆ ದಿನ ಇಲ್ಲ ಮೇಡಮ್.
Please.
ಇದೇ ತರ ಆಗುತ್ತೆ. List the matter on 12th. Entry matter subsisting will continue to the next date of hearing. Balkrishna, entry matter ಇದೆಯಾ?
KP Act proceedings, my lord, page number 62.
Covered.
Please, my lord, under bar.
Under bar?
Please.
You want to go bar? Yes.
Page number 62, my lord, your lordship's judgment, insofar as co-accused is concerned.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits qua the co-accused. This court has quashed the proceedings, page 62, madam. In that light, the petitioner being co-accused is entitled to the same order that is passed by the concerned court, with the offense being the same. For the aforesaid reasons, allen helidini adma same. Page 60,
Page number 62.
page 75, 76 ಅಲ್ಲಿ operative portion. Yes, next.
118. Entry matter.
118. List on 26th. Entry matter subsisting will continue to the
19
next.
also.
19 also entry matter ಇದೆಯಾ? 26th. Yes, ಸಾಕು ಮಾಡಿ.
129. 130, my lords, the
big group.
original of the will, my
Only
lords.
concern is, there is no interim order, my lords,
My
only
lords,
final arguments ಗೆ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಆಗ ಒಂದು short date may be given, my lords, because interim order is necessary, otherwise.
23 ಇಂದ entry matter ಇಲ್ಲ.
ಅದ್ರಲ್ಲಿ unfortunately I have tried 10 times to move, my lords, ಅದು ಕಷ್ಟಪಟ್ಟು ಇವತ್ತು ಬಂದಿದೆ. ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಮೇ ಬಿ
ನಾನು ಎಷ್ಟು ಅಂತ ತಗೊಳಕ್ಕಾಗುತ್ತೆ? Already
ಫೈನಲ್ ಹಿಯರಿಂಗ್
exhausted.
ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಅಷ್ಟೇ. ಇಲ್ಲ ನನ್ನ ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್
Yeah, everybody have urgent. I will, when is the next date there?
ಅಲ್ಲಿ ನಾಳೆ
ಅಲ್ಲಿ adjournment ಕೇಳೋಂಗಿದ್ರೆ
ಅಲ್ಲಿ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ sir.
ಅಲ್ಲ, ಇದನ್ನ seniority ಪ್ರಕಾರ ಹಾಕ್ತೀನಿ ನಾನು.
Serial number
Short
130,
date may
my
be given,
lords.
my lords, at least.
The original of the will, this court wanted to see, my lords. The records are here. It's suit for final arguments. was
With which
stayed.
one, sir?
130, my lords.
My lord,
On an application for appointment of a commissioner, which was rejected, court wanted to see the original of the will.
ಆಯ್ತು, ಇದು ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
Serial number 142.
ಹಾ,
Serial number
2017 ಯಾಕಿದೆ ಮೇಡಮ್ ಇಲ್ಲಿ? LB
7.
2000 ಮೇಡಮ್, LB ಕನೆಕ್ಟ್ ಆಗಿದೆ ಯಾಕೆ? List the matter after 2 weeks. A disability ಹೋಗುತ್ತೆ.
My lord, serial number 127.
ಇವೆಲ್ಲ
121.
My lords, in serial number 121.
ಇದು we will not today, sir. We will take it on Tuesday.
My lords, on submission, in serial number 121, my lords, I am appearing on behalf of KM Prakash for respondent number 3, my lords. We have submitted our NOC, my lords. Our name might be deleted, my lords.
We will see later. Next, list the matter on 16th. Yes,
122.
same day. Same day, same day.
123.
I
Same-
123 I
same
appear,
days.
please, my lords.
Yes.
I 123 may be posted in the fresh matters, my lords. I don't have an interim order.
Well, 123 16th.
It may be posted in the fresh matters list, please, my lords. 123. I don't have an
123,
interim order.
list after 4 weeks, interim order subsisting will continue to the next date of hearing. Next,
24.
same order.
125 interim order.
Ah,
I have an award in my favor.
wait, list on 17th, yes.
125 interim order.
Petition, there is interim order.
You are for the petitioner. 125. Rajshekar is all right. List on 17th, yes, next.
26.
Hmm. Idva,
Idem.
yes, 2 weeks IO. Next.
127, I am for the petitioner, my lord.
7.
I'm for the petitioner, my
And for
lord.
the respondent.
Respondent number 1 is the father, respondent number 2 is mother, my lord.
ನೀವು ಯಾರು, sir?
I'm petitioner, son.
Yes. List after 2 weeks, yes.
My lord, kindly a date may be fixed, my lord. This was matter.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
Interim order.
Interim
ಅಲ್ಲಿ
order
police protection ಬೇಕಾಗಿದೆ. They are interfering continuously. ಮೊನ್ನೆ ಹೊಡೆಪೆಟ್ಟು ಆಗಿದೆ.
List on 17th, 128.
Much okay.
128.
128, 2 weeks, yes.
129.
129 laws interim order ಇಲ್ಲ ಅದಕ್ಕೆ short date may be given, my lords.
17th, yes.
130.
My lord, I am for the petitioner.
ಇದು 18th.
Who has to be extended?
18th, yes, next.
131.
Represent the respondent, my lord. 18th will be the date.
Interim order is there?
No.
Yes. List on 22nd, next.
133. Sorry, 132.
ಮೇಡಮ್ ಎಷ್ಟಿದೆ ಹಂಗಂತ ಎಲ್ಲ interim order ಇರೋದೆಲ್ಲ 2 weeks it will come, yes. ಇಲ್ದೇ ಇರೋದು will fix a date.
My lord, one submission.
Serial number.
Serial number 1. ಅದು ಹಾಕ್ಬಿಟ್ಟು 4 matters interim order ಯಾವುದಿಲ್ಲ ಅದು 17th ಹಾಕಿ ಮಿಕ್ಕಿದ interim orders ಇರೋದೆಲ್ಲ 2 weeks ಅಷ್ಟೇ.
My lord, one submission, my lord.
142, kindly extend interim order.
One submission, my lord.
ಹಿಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ಬಿಟ್ಟು ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಯಾವುದಿದೆ?
Serial
ಸೊಸೈಟಿ
number
ಇದಾ?
160 ಹೌದು.
ಇದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದೆ?
ಅಲ್ಲ ತಮ್ಮ ಮುಂದೆನೆ ಹಿಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ರಿಸರ್ವ್ ಆಗಿತ್ತು.
ಹಾ.
ಓವರ್ ಸೆಟ್ ಅದು ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ಲ. ಮತ್ತೆ ಪಾರ್ಟೆಡ್ ಇದ್ರಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಬರ್ತಾ ಇತ್ತು.
ಆಯ್ತು ನೋಡೋಣ, ವಿಲ್ ಸಿ.
Serial number 142.
157.
ಅದೇ ಗೊತ್ತು.
Next Wednesday.
ಫಕೀರಪ್ಪ ಅಂಡ್ ಕಾರ್ಗಿಲ್.
My lord.
Both on
Serial number 64, my lord.
next Tuesday ಹಾಕಿ. ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಎರಡು ಮೇಡಮ್.
Serial number 64, my lord.
So serial number
ಕೆಲಸ ಮಾಡಿ
142.
ಮೇಡಮ್, ಎರಡನ್ನು 2:30ಗೆ ಅಂತಾನೆ ಹಾಕಿ on Tuesday.
So serial number 142.
Tuesday 2:30ಗೆ ಫಸ್ಟ್ ಅವರು ತಗೊಂಡು ಆಮೇಲೆ ನಿಮ್ಗೆ ತಗೊಂತೀನಿ.
My lord.
ವೆಡ್ನೆಸ್ಡೇ ಮತ್ತೆ ಹೋಯ್ತು 200 ಇದೆ.
So serial number
Serial number
142.
64, my lord.
Serial number 142.
ಅಷ್ಟೇ, ಬೇರೆ
Serial number
64, my lord.
142 kindly extend interim order.
Interim order extend ಮಾಡಿ. Serial number 160.
Interim ಇರೋದೆಲ್ಲ extend ಅಲ್ಲ.
ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. 141.
Court martial, please.
आता उन लेकिन उन पात्र वाक्य लगता होता है कि ये तो he left and court master blocked it. Better. Go and ask, okay?